Hello, hello.
ಎಲ್ಲಿ ಹೋಗಕ್ಕಾಗುತ್ತೆ? ಬೇರೆ ಚೇರಲ್ಲಿ ಚೇರಲ್ಲ. ಒನ್ ಟುಡೇ ಒಬ್ಬೊಬ್ರು ಯೂಸ್ ಬೆಂಚ್ ಇವತ್ತಾನೆ ನೆನ್ನೆ ಸಂಜೆನೆ
ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಇನ್ನು ಮೇಡಮ್ ಡ್ರೆಸ್ ಹಾಕೊಂಡಿಲ್ಲ, ಈಗ ಬಂದರು.
ಸಬ್ಮಿಟ್ ಸಬ್ಮಿಷನ್ ಮೇಡಮ್. ಸೆಟಲ್ಮೆಂಟ್ 230 ಕೊಡ್ತೀರಾ? ಸಬ್ಮಿಷನ್
ಮೇಡಮ್, ಲಾಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಒಂದು ಮಂಡೇಗೆ ಮೂವ್ ಮಾಡಿದ್ದೆ. ಮಂಡೇಗೆ ಅಂತ ಹೇಳಿದ್ರು. ನೆನ್ನೆ ಇಷ್ಟ ಆಗಿಲ್ಲ, ಇವತ್ತು ಇಷ್ಟ ಆಗಿಲ್ಲ.
ನಿಮಿಷ ಮಾಡಿ
ಆ ಕಡೆ
ನಾಳೆ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಬರ್ತೀವಿ.
ಇದೆ, ಆ ಕಡೆ ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇದೆ.
ನನಗಾದ್ರೆ ಹಂಗೆ ಹೇಳಕ್ಕಾಗೋದಿಲ್ಲ, ಎಲ್ಲ ಈಗ ಕಮಿಷನ್ ಮಾಡ್ಬೇಕು. ಏನಮ್ಮ? ಹಾಂ, 43 ನಾನು ಅಪ್ಡೇಟ್ ಮಾಡಕ್ಕೆ 43 44 ಏನು ತಿಂದಿಕ್ಕಂದ್ರಿ? ಮನೆಗೆ ಹೋಗ್ತದೆ.
Withdrawal tomorrow. But the
ಇವತ್ತು ಚೇತನ್ ಬರ್ಡೇ ಓಕೆ ಮೇಡಮ್ ಯಾರು ಬರ್ಲಿಲ್ವಲ್ಲ ನಿಮ್ಗೆ ಅಲ್ಲ ಇವಾಗ ಫೋನ್ ಮಾಡಿದೆ ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
My lords, in this matter,
In this matter, ಇಲ್ಲ all matters, fresh matters.
in this matter, an FIR has been filed after the lapse of 17 years, my
Wait,
lords.
sir, ಕುಡಿಯಲ್ಲ, fresh matters ಕುಡಿ. Any mentioning, wait. Covered by judgment, my lords. All pending matters also give. Settlement, whenever you want, make a mention of that and give. No stay memos, no stay ಅಂತ ಬರ್ದ್ಬಿಟ್ಟು ಕೊಡಿ. ಆಯ್ತಾ? ಎಲ್ಲರೂ 2:30 ಬೇಕಾ ಈಗ? ಹಾ. Wait, ಹಾ. Not raise the file? Yes. ಅದ್ಯಾವ್ದು ನೋಡಿ ಮೇಡಮ್. Yes. ಹಾ. ಬೇಲ್ ಇದೆಯಾ? ಬೇಲ್ ಇದೆಯಾ? ಕೊಡಿ. Nothing. No problem. Sorry, wait. Who is that in the middle? Can you keep quiet? Yes. No problem, give it. Your bail ಇದೆ ಅಲ್ಲ ಕೊಡಿ. ಮಂಡೇ ಎಲ್ಲ ಬೇರೆ ಎಲ್ಲ ಏನು ಹೇಳಿ? ಹಾ. All right. You have the benefit of bail or not? Monday. Seniority, of course. Yes. Good. Very. 17th or 18th, give it. 2:30. Fresh or pending, sir? Fresh or pending? What? Who is a police officer? Petitioner is a police officer. No threat at all. Monday. Yes, ತೊಂದ್ರೆ ಇಲ್ಲ ಕೊಡಿ. ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್, ತೊಂದ್ರೆ ಏನಿಲ್ಲ ಕೊಡಿ. ನೋ ನೋ ದ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಸಿನ್ಸಿಯರ್ ಪೊಲೀಸ್ ಆಫೀಸರ್. ಓಯ್ ಆಲ್ ರೈಟ್ ಸರ್, ಡೋಂಟ್ ಗಿವ್, ಬೆಳಗ್ಗೆನೆ ಶಾಕ್ ಕೊಡಬೇಡಿ. ಎಸ್, ಅದು ಓಕೆ, ಅದೆಲ್ಲ ಓಕೆ. ಡೋಂಟ್ ಟೆಲ್ ವಾಟ್ ಎವರ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಟೆಲ್ಸ್ ಯು. ಎಸ್, ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್, ಮಂಡೇಗೆ ಆಗುತ್ತಲ್ಲ? ಯಾಕೆ? ಆಯ್ತು ಕೊಡಿ. 2:30 ಫೈನ್. 2:30 NDPS ಅಲ್ಲಿ ನಾನು ರಿಲೀಸ್ ಮಾಡೋದೇ ಇಲ್ಲ. ಐ ವಿಲ್ ನಾಟ್ ರಿಲೀಸ್ ಹಿಮ್ ಫ್ರಮ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ. ಎಸ್, ಟುಮಾರೋ. ನೋ ಪ್ರಾಬ್ಲಮ್, ಟುಮಾರೋ. ಎಸ್. ಬೇಲ್ ಇದೆಯಲ್ಲ ಟುಮಾರೋ, ಅದಕ್ಕೆ ಐ ಶುಡ್ ಗಿವ್ ಬೇಲ್. ಇಸ್ ಇಟ್? ವಾಟ್ಸ್ ದ ಮ್ಯಾಟರ್? ಟೆಲ್ ಮಿ. ITP day after tomorrow. Pending matter. No problem. Day after tomorrow. 2:30. Kodi pending matters alla kodi sir. Yes. Give it. Yes. This is before me. It will come. Give it. Yes. It will come, sir. Give it. ಅವ್ರು ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು 138 ಮಧ್ಯೆ ನೀವು ಲವ್ ಅಫೇರ್ ಅಂದ್ರೆ. ಸಾರಿ, ವಿಲ್ ಸಿ. ಗಿವ್ ಇಟ್. ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಎಸ್, ಅದು ನೋ ಸ್ಟೇನಾ ಮೇಡಮ್? ನಾಳೆ ಹಾಕಿ, ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್. ಎಸ್. Petitioner? Yen and you want to marry now? Then second time you promised to marry. Kodi 2:30. ನೋ ಸ್ಟೇ ಕೇಸಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ, ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕೋಣ. ಯಾರ್ಯಾರು ನೋ ಸ್ಟೇ ಇದೆ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಡಿ. ವೇಟ್, ನೋ ಸ್ಟೇ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ವೇಟ್, ಅಲ್ಲಿ ಕಮ್ ಬ್ಯಾಕ್ ಮೇಡಮ್. ಅಲ್ಲ, ನೋ ಸ್ಟೇ ಯಾವ್ಯಾವ್ದು ಇದೆ, ಯಾವ ಡೇಟ್ ಮುಂಚೆನೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಅದನ್ನ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹಾಕಿ. ಒಂದು ನಿಮಿಷ.
Your Lordship, it's a fresh matter. The co-accused have already been given interim relief by this Honorable High Court.
Can it wait till Monday?
Yes, I moved it last week for this.
Fresh matter?
Yes, Your Lordship.
ಬರುತ್ತೆ ಮಂಡೇ ಹಾಕೋಣ.
Lord, this is a fresh matter, my lord. There is a civil proceedings here pending in the trial court, my lord. In the meanwhile,
ಕೊಡಿ.
day after tomorrow or day.
We'll see.
Your Lordship, it's a
Yes, madam.
matter, my lord. Permission to travel abroad. It's a 420 offense.
Application ಹಾಕಿದ್ದೀರಾ?
Yeah.
ಕೊಡಿ.
Your Lordship,
Day
it's a
after
pending
tomorrow.
matter, Your Lordship.
13th. Yes. Application ಇದೆ ಅಲ್ವಾ? Yes.
Your Lordship, it's a pending matter, Your Lordship.
Post in the predicate offense and discharge, my lord. ED has now issued summons, my lord, asking me to
Sorry?
appear tomorrow. In the predicate, I'm already discharged, my lord.
ಹಾ,
ED has now issued summons, my lord, asking me to appear tomorrow, my lord.
2:30.
Please.
498, Your Lordship.
Serve on ED counsel and then come.
498, Your Lordship. No stay.
No stay? ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Your Lordship, it's a
Tomorrow or
pending
day
matter.
after, no stay memos will come. Evidence? Then I won't interfere at all. Trial has commenced, I will not interfere. ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿಂದ ಬಂತು? ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಮಂಡೆಗೆ ಹಾಕಿ.
Your Lordship.
ಎಸ್. ಯಾವುದು ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? We'll see. You mention when it is called, we'll take it another day. Interim what? Kodi. 2:30. Recognizance? Kodi. Day after tomorrow. Monday or Tuesday ಕೊಡಿ. Why NBW is issued? Why? Monday or Tuesday, give it, yes. Fresh matter. ಕೊಡಿ. Stay ಇಲ್ವಾ? ಅಟ್ರಾಸಿಟಿ ಸ್ಟೇ ಇಲ್ವಾ? ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ವಾ? ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಡಿಸ್ಪೋಸಲ್ಗ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ವಾ? ಬಿಡಿ, ಮೆಮೊ ತಗೋಬೇಡಿ. ಎಸ್, ಹಂಗೆ ಹೇಳಿ. ಮತ್ತೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಅದು ಕೊಡಿ. ಎಸ್, ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿ ಮೇಡಮ್. ಗಿವ್ ಇಟ್ ಸರ್. ಎಸ್, ಕೊಡಿ ಸರ್.
Lords, Rajya Sabha election bribery law matter, my lords. The lordships are directed the matter to be listed after Arto is served, my lords. They have served him through hand.
We'll see on Friday, give it. Yes. Special court matters ಎಲ್ಲ Friday.
The offense is the 304B and 498A. There is no stay.
Adil no stay. Even if you ask me, I will not grant stay. It's better you take chance before another bench. Allah, you better you take chance before another bench. 498A, 304B, I will not.
Yesterday's matter, my lords, where I moved the matter, my lords, so it was directed to be listed today. My lords, petitioner's application under section 311 was allowed by the trial court, my lords. Revision is filed against that, my lords, before the sessions court, which was not maintainable. Therein, my lords, the application is dismissed and the trial court is directed to here on maintainability of the
138,
138, my lords.
138 ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ.
My lords, it's on 13, my lord.
Ultimately check ಎಷ್ಟು amount?
My lords, I am for the complainant.
230,
my lords.
Tomorrow.
13th ಇದೆ hearing on maintainability.
Tomorrow, sir.
Please.
My lords, daughter,
Settlement ಕೊಡಿ sir.
my lords, daughter-in-law filed a dowry prohibition act
ಅವರೇ ಇನ್ಯಾರು ಹಾಕಕ್ಕಾಗಲ್ಲ.
against all the in-laws, my lords.
ಅದೇ ಮಾಡೋದು ಅವ್ರು, ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗ?
And also,
ಪಕ್ಕದ ಮನೆಯವರು ಇದಾರಾ?
no, my lords, included assault and criminal intimidation in this case.
ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಕೊಡಿ.
Your lordship,
Monday or
the
Tuesday,
petitioner is the another further hearing matter is also.
Further hearing next week, yes.
Wife has filed POCSO case against husband and in-laws, my lords.
Your lordship, the petitioner is the sole accused. He is the owner of the vacant site property, your lordship.
ಏನಾಗಿದೆ?
Allegation is that growing of single ganja plant, your lordship.
Ganja?
No conscious, cultivation.
ಗಂಜಾ ಪ್ಲಾಂಟ್
Single.
ಟ್ರೀ ಇರ್ಬೇಕದು.
ಇಲ್ಲ. ಚಿಕ್ಕದು ಒಂದು ಗಿಡ.
ಚಿಕ್ಕದ ಕೊಡಿ.
My lords, fresh matter, my
ನಾಳೆ.
lords.
Tomorrow, your lordship.
My lords, fresh matter,
Tomorrow.
offences under Factories Act 92 and
92.
96A. 5 workmen have been deceased, my lords. The accused number 2, the petitioner herein has been scapegoated here and as her appointment letter has been post-dated. She's been placed under suspension. She's a government employee, my lords.
ಅದಕ್ಕೂ ಇಲ್ಲ ಸಸ್ಪೆನ್ಷನ್ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
My lords, the trial is going on.
Trial is going on, I will not interfere.
My lords, please, my lords.
No,
We'll be
sir.
here tomorrow, my lords.
No, we'll give it.
There's urgency, my lords.
No urgency ಕೊಡಿ. ಟ್ರಯಲ್ ನಡೀತಾ ಇದ್ರೆ no urgency. Yes.
Lords, pending matter.
ಅದ್ ಯಾವ್ದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ರಾಜಾರಾಮ್ ಸರ್. ನಾಳೆ.
Pending matter, my lords, it involves immoral traffic of Women's Act at 376, my lords. We are for the respondent number 2.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ.
Your lordship, it's a pending matter, your lordship, and there is no stay in this matter.
ಕೊಡಿ, ನೋ ಸ್ಟೇ ಇಲ್ಲ ಕೊಡಿ.
This is a fresh matter. I had moved the memo last week, your lordship, it hasn't been listed.
If that is the complaint, it will be listed after 2 weeks. Otherwise, ಸುಮ್ನೆ ಕೊಡಿ, ನೋ ಸ್ಟೇ ಅಂತ.
My lords, this is a fresh matter. That's 2 FIRs have been filed against the petitioner. There
Monday or
is a
Tuesday?
threat of arrest.
Why?
It's for forgery, my lords, 318, 230, my
230.
lords. My lords, we had moved this memo. 230, my lords. My lords, we had.
Monday or Tuesday?
Sub-inspector.
Sub-inspector?
The retired sub-inspector.
ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್?
No, sir, petitioner.
ಕೊಡಿ.
Lordship 498. There is no stay and
ನೋ ಸ್ಟೇ ಮೆಮೊ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Lordship 498.
ನೋ ಸ್ಟೇ, ಗಿವ್ ಇಟ್. Poor agriculture is stay or no stay? ಕೊಡಿ. Why there poor agriculture is ಅಂತನಾ? ಮತ್ತೆ? 230 ಕೊಡಿ.
498.
Monday or Tuesday?
Fresh matter, my lord.
ಕೊಡಿ.
Stock ಡಿಫರೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಏನಿದೆ?
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅವರಿಗೆ I have given.
Essential commodities act.
That is my
ಕೊಡಿ,
lord.
ಪರವಾಗಿಲ್ಲ, Monday or Tuesday.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅವ್ರ ಮೇಲೆ
ಏನ್ ಪರವಾಗಿಲ್ಲ, ಏನಾಗಲ್ಲ.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
2 ದಿನ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಏನಾಗಲ್ಲ, ಕೊಡಿ.
Kindly work order suspend.
ಈಗ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
Kindly have it tomorrow.
Why are you coming this side? Come this side.
Kindly tomorrow, my lord.
ಕೊಡಿ ಎಲ್ಲ.
My lords, matter.
Give all the memos.
My lords.
No stay memos ಎಲ್ಲ ಕೊಡಿ ಸರ್, ಫಾಸ್ಟ್ Please give all the no stay cases. No stay cases, ನನ್ ಮುಂದೆನೆ ಬಂದು ನಾನು ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ. ವಿಲ್ ಸಿ, ಕೊಡಿ ಎಲ್ಲ. ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಎಸ್.
One submission.
ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಎಲ್ಲ ಕೊಡಿ. ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಅಂತ ಬರೆದು ಕೊಡಿ ಅಲ್ಲಿ. ಸರ್ವಿಸ್ ಸ್ಪ್ಲಿಟ್ ಅಪ್ಗೂ ಸರ್ವಿಸ್ಗೂ ಏನ್ ಸಂಬಂಧ? ಅಷ್ಟೇ ಹೇಳಿ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಎಸ್.
My lord,
give all the memos.
my lord, the
Promise to marry, my lords.
Is in custody.
Illa.
Is in custody.
Not in custody.
Monday or Tuesday.
my lord, fresh,
ಕೊಡಿ ಸರ್ ಎಲ್ಲ.
The pending,
ಬೇರೆ ಎಲ್ಲ ಮಂಡೇ or ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ.
the pending matter.
Parents of
2:30 ಯಾರು ಬೇಕಾಗಿರೋರು ಇರಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಮಂಡೇ or ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ.
Parents of the POCSO victim, your lordship. The counter case against them just because they
ಕೊಡಿ.
have given a POCSO
Monday or
case,
Tuesday, give it, sir.
Lordship. Tomorrow, lordship.
No, tomorrow.
He is convicted, your lordship. He is filed a criminal appeal, your lordship. Now,
No problem, give it,
discuss that counter claim on the same issue, your lordship.
Tomorrow ಆಗಲ್ಲ, give it on Monday or Tuesday. Yes.
my lord, the directors, the petitioner is a director in a company.
Maybe
He's
all of
seeking
you
for
give it for Monday or Tuesday.
fresh matter, my lord.
ಕೊಡಿ sir.
My lord's
Monday,
matter.
please, my lord.
Monday or Tuesday.
My
Yes.
lord's matter is for
Matter is on
framing
Monday,
of
my lord.
charges for tomorrow.
Where is the
my
order
lords.
sheet?
It is with the memo.
Where,
my
what is the
lords.
date?
Tomorrow itself it is for framing of
2:30.
charges, my lords.
My lords,
Yes.
the pending matter.
311 has been rejected, your lordship.
ಕೊಡಿ ಎಲ್ಲ.
Lordship, 311 has been rejected.
ಕೊಡಿ, ಅದು ಕೊಡಿ sir.
10 crores check amount, your lordship.
ಪರವಾಗಿಲ್ಲ
Legal
ಕೊಡಿ.
transaction, your
Give it, give it. Monday or Tuesday, give it.
Tomorrow,
Auto? Sorry? What is the problem? IT years ka? 2:30. 2:30.
My lords, the pending matter. It is a pending matter.
ಕೊಡಿ, ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಈಗ. Unless there is extreme urgency for 2:30, ಬೇರೆ ಎಲ್ಲ Monday or Tuesday ಕೊಡಿ. The other matters, ನಾಳೆ ಇದೆಯಾ ಅದು? ಅದು ಕೊಡಿ. ಆಯ್ತು ಕೊಡಿ.
My lords, the pending matter. My lords, similar petitions have been reserved for orders by my lords, my lord. It's with respect to OTS, one-time settlement.
ಹೌದು.
Party has cleared everything. It's reserved for orders, my lord.
ಹಾ.
It's another loan with respect to same petitioner.
ಕೊಡಿ.
That was with respect to
Take
Union
it on
Bank of India.
Thursday ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Please, my lord.
This matter.
Pending matter.
ಕೊಡಿ, ಯಾವ್ದು offense ಏನು? Buds Act settlement ನಾನು ಒಪ್ಪಲ್ಲ.
Pending matter.
All the, ಕೊಡಿ anyway, we'll see. Tomorrow.
Fresh matter, 2:30.
Settlement ವಿನೋದ್ ಕುಮಾರ್ ನಾಳೆಗೆ ಹಾಕಿ. What modification? ಅಯ್ಯ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಎಸ್. ಅದು
Fresh
ನೋಡಿ
matter.
ಮೇಡಮ್. ಹಾ? Give it. Monday or Tuesday, sir. Give it.
Fresh matter at 2:30, please, my lords.
It will come, ಕೊಡಿ. ಈಗ ಮಂಡೇ ಅವ್ರು ತಡೆಯಕ್ಕಾಗಲ್ವಾ? ವೆರಿ ಗುಡ್, ನಾಟ್ ನೆಸೆಸರಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ಕೊಡಿ. Tomorrow.
Fresh matter.
138 better.
Monday or Tuesday, give it. Special court Friday. Special court ಹೆಂಗಾಯ್ತದು? That ಪಪ್ಪಿ ಟೂರ್ಸ್ ಅಂಡ್ ಟ್ರಾವೆಲ್, ಅದ್ರ ಜೊತೆಗೆ ತಗೊಳ್ಳಿ ಅದು. ಎಸ್, ಅದ್ರ ಜೊತೆ.
Pending 138.
ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ರ ಎಲ್ಲ ಕಡೆ ಮೆಮೊ ಕೊಟ್ಟು ನಾನು ಕಾಯ್ತಾ ಇರ್ತೀನಿ 11 ಗಂಟೆವರೆಗೂ ತಗೊಂತಾನೆ ಇರ್ತಾರೆ ಅಂತ. ಕೊಡಿ, ಥ್ಯಾಂಕ್ ಯು. ಎಸ್,
Pending matter, my lord.
ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
138 where interim order was not extended.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್ ಸರ್.
Tomorrow, my lord.
ವಿಲ್ ಸಿ.
Lords, fresh
ಐ ಹ್ಯಾವ್
matter.
ನಾಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಇರೋ ಚಾನ್ಸ್ ಇಲ್ಲ ಕೊಡಿ. ಎಲ್ಲಿ ಹೋಗ್ತಿದ್ದಾರೆ? ಜಾಬ್ ಮಾಡ್ತಾ ಇದಾರ? ಸರ್ಚ್ ಮಾಡಿ ಬಿಡಿ, ತೊಂದ್ರೆ. ಸೋ ವಾಟ್? ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಹಂಗಿದೆ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಕೊಡಿ. ಎಸ್. FR ಇಲ್ಲ ಏನ? ಅಟ್ರಾಸಿಟೀಸ್ ನಾಳೆ ಕೊಡಿ. ಫ್ರೆಶ್ ನಾಳೆ, ಟುಮಾರೋ.
Lord, fresh matter, please, my lord. Section 75, where a woman is made as an accused, please, my lord. There are trying to
Tomorrow.
arrest, please.
This is a special court matter, my lords. It's
Friday.
one of the Balakari
Friday.
cases which has already been resolved.
Friday.
FIR under registered as a different act. Now, French and that not police they file charge sheet.
Monday or Tuesday, give it, sir. Yes.
It's covered by not.
No, sir, nothing. Yes. ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ ಫಾಸ್ಟ್. ಯಾವ್ದು ತೊಗೊಳ್ಳಿ ನೋಡಿ ಮೇಡಮ್, ನೋಡಿ ಅದು ಯಾವ್ದು
Lordship.
Yes, ಆಯ್ತು 2:30 ಹಾಕ್ಸ್ತೀನಿ.
Your Lordship's kind. Complainant is
Lords, POCSO investigation was stayed by your Lordship's my lords a day before my lord's charge sheet is filed. As on the date of filing of the
No
petition, my
problem,
lords,
give
they
it
would not
Monday or
charge.
Tuesday. ಎಲ್ಲ Monday or Tuesday, no tomorrow, no day after tomorrow. Pending ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
Request for end of the list.
No end of the list, sir. Give it.
Lordship.
Before the magistrate is for framing of charges minutes.
When, where is the order sheet?
I have annexed.
ಯಾವತ್ತಿದೆ?
Today minutes.
2:30, yes.
Lords, for withdrawal, my lords, tomorrow.
Withdrawal, give it.
Yes, my lords.
Lordship, for criminal petition 348026, the fresh matter. Actually, for the last 1.5 months, we are trying for this matter to be posted. Today also, we have moved the memo under fresh. Kindly
Where is that
we
memo?
have handed over 348026.
Why is it not being posted?
As per seniority, it was supposed to come, but it has not.
If you have not complied with the office objections
complied.
and you are telling this, I'll post it to 2027 January. Just go and see. Yes.
Lordship,
It will come. It will come on Monday definitely, but if
Much
you have
obliged,
not
much.
complied and told this
No, we
27
have complied.
January.
Everything we
Yes.
have complied. Lordship, much obliged.
ಕೊಡಿ. ಕೊಟ್ಬಿಡಿ.
The petitioner is having 4-month child, my lord.
So what, sir?
Regular court ಗಪ್ಪಿರ್ ಆಗಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಸರಿ, exemption ಹಾಕಿ. ಅದು 482 ನಾ?
No, a false case, my lord.
ಅದು ಬೇರೆ.
She is nowhere concerned to the criminal case, my lord.
ಮೆಮೋ ಕೊಡಿ.
Complainant has demised.
ಈಗ ಕೊಡ್ತೀರಲ್ಲ, if you want to give, sir. Call the cases, yes. My lord.
Let's one
Call the
submission.
cases.
Let's complainant has demised.
Enough,
my
give all
lords.
the memos.
Pending matter on Thursday, my lords.
Call the cases, sir.
My lords, my apologies. On 13th, it's posted.
No problem, sir. Give it Monday or Tuesday. Yes, next.
List 1, fresh matter, still number 1.
I will try for settlement, my lord.
Huh?
Husband and wife in this matter.
3 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
Even I can understand, my lords, this with complication, we tried all the by taking to mediation also. It's not happening. Probably chances are there, my lord. Both of them stay in the same building. Husband is also a doctor and she's a professor.
In the meantime, next.
Please.
Stayed.
Please.
Number 2.
Petitioner, Malada, society has initiated.
Entire money recovered in auction ಗೆ document ಎಲ್ಲಿದೆ?
Malada, page number 112 execution proceedings has been taken place, my lord. Page number 108, my lord. The property has transferred in the name of the subsequent purchasers, my lord. Moreover, my
You have
lord.
said entire money that is the subject matter has been recovered in auction.
Please, my lord.
ಅದು document ಬೇಕಷ್ಟೆ.
Page number 108, my lord. Other 3 properties also attached by the bank, my lord. Even, my lord, petitioner has not challenged the 69 proceedings as well as 103 proceedings, my lord.
ಎಲ್ಲಿದೆ 108 ಅಲ್ಲಿ? Request for transfer of immovable property.
Already action has been conducted, my lord.
ಎಲ್ಲಿದೆ ಅದು?
On 17 to 2020.
Where is the document, sir?
Page number 108 ಅಲ್ಲಿ.
108 ಅಲ್ಲಿ auction ಆಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ ಸರ್? Following land be registered in the name of, ಯಾರಿದು complainant ಇವರು?
Please, my lord.
Who's the highest bidder? The learned counsel, the petitioner is before the court calling in question the proceedings in CC 1391 of 2020, 1319 of 2021.
Charges are already framed.
Framed?
No,
ಯಾವಾಗ?
not framed. ಇಲ್ಲ.
Page that 23, your lordship. Order sheet.
29/1/2025 ಅಲ್ಲೇ ಆಗಿದೆ, 24 ಅಲ್ಲೇ. The petition is preferred on 20th November 2025. The concerned court has framed charges and set the trial in motion on by its order dated 20/11/2024, a year before the filing of the present petition. The learned counsel for the petitioner submits that the entire amount is already realized by an auction being conducted by the society. Therefore, the said circumstance also be considered by the concerned court at the appropriate time. In the light of the judgment of the apex court in the case of Meenakshi Bala, I deem it appropriate. The entertainment of the subject petition is not the remedy that is available to the petitioner. Leaving open the contentions to be urged before the concerned court, the petition stands disposed. Next.
Number 3.
Ananthaswamy.
They have filed a suit. They have filed a suit against that petitioner. It's in civil in nature, Swami. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, she has filed a OS also. For creating the pressure, she has filed a criminal complaint against the petitioner. Actually, she has no way mentioned she has recognized as an advocate. In this further, what happened? It is a family dispute. Petitioner has assisted her in this regard also, because her husband has filed a criminal case against his wife on 14. Just this document has, I got it only after the filing of this petition, Your Honor. So I prayed that the interim stay may be granted.
Oh, no. Dismiss ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Anything else?
One short time may be given.
No, sir.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲೇನಾಗಿದೆ ಅಂದ್ರೆ
ಏನಾಗಿದೆ ಅಂತ ನಾನು ಬರಿತೀನಿ ಈಗ.
ಅಲ್ಲ ಮನಿ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅಂದ್ರೆ ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ.
ಇಲ್ಲಿ ಅನ್ವಾಂಟೆಡ್ ಆಗಿ ದೇ ಆರ್ ಕ್ರಿಯೇಟಿಂಗ್ ದ ಪ್ರೆಷರ್ ಓವರ್ ದ ಪಿಟಿಷನರ್.
No problems. Anything else? The petitioner is before the court calling in question proceedings in CC 31951 of 2025 arising out of crime number 253 of 2024. The petitioners are accused 1 and 2. The second respondent, the complainant. It is the case of the complainant that the petitioner, projecting herself to be an advocate, has extracted money close to 8 lakhs, 7,81,500 to be the expenses for a particular civil suit that is filed. The complainant, generating certain suspicion or a doubt against the said person who claims to be an advocate, seeks the bar council registration documents of the first petitioner. It is then discovers that the first petitioner is not an advocate and has projected herself to be an advocate and extracted close to 8 lakhs for the purpose of legal remedies for the complainant. At the same breath, the complainant also institutes a civil suit in OS civil suit in OS 715 of 2025 for the purpose of the recovery of the said money. The petitioner, the police on recovery of the said money. The complaint then becomes a crime in the aforesaid crime. The police conduct investigation and file a charge sheet. The filing of the charge sheet is what has driven the petitioners to this court in the subject petition. Petitioners are husband and wife. The learned counsel appearing for the petitioner would strenuously contend that there is no allegation that could become the ingredients of section 3184 or 3162 of the BNS as is alleged in the charge sheet. Therefore seeks quashment of the proceedings. The added circumstance the learned counsel would project is that the civil suit is filed by the very complainant for the purpose of recovery of the amount that is said to have been transacted between the first petitioner and the complainant. The learned counsel would seek quashment of the proceedings on the said score of the pendency of the civil suit. The learned HCGP, on the other hand, would take this court through the documents appended to the petition to demonstrate that there has been luring of the complainant into this transaction. The civil suit, pendency of a civil suit would not bar the proceedings that is projected before the court. I have given my anxious concerns. The four narrated facts, dates, link in the chain of events are all what is averred in the petition. This entire issue gets triggered from the complaint. The complaint reads as follows, page 16 to 19. The complaint narrates graphic details of the transaction between the first petitioner and the complainant and the reason for such transactions. The total amount that is secured by the petitioner intermittently is 7,81,500 on the score of rendering legal assistance. The generation of a doubt by the complainant that whether with regard to whether the first petitioner was an advocate at all comes to know that she was never an advocate but has projected herself to be one and has extracted the entire money. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 24. If the complaint and the charge sheet are read in tandem, it becomes crystal clear that there has been luring of the complainant into a transaction for a particular purpose with a dishonest intention from the inception. In that light, it meets the ingredients of section 3184, which is 420 of the earlier regime, the IPC. In the light of the said circumstance, there is no warrant of interference in excise jurisdiction under section 482 of the CRPC. It is trite law that mere pendency of a civil suit will not clothe the accused with protective orders at the hands of this court. In the case at hand, the civil suit is pending for the purpose of recovery of money. That may be a circumstance, that may be an added circumstance, but the money that is extracted and for the purpose it is extracted after projecting herself to be enrolled at the bar council and taken money cannot be countenanced on the score that civil suit is pending for the purpose of recovery of money. The recovery of money finding no merit in these petitions, the petition stands dismissed. Next.
4.
Stage of civil suits. Stage of civil suit, stage of criminal case. 2019. Charge frame ಆಗಿದೆ madam?
ಇಲ್ಲ.
ಆಯ್ತು. 1 HCGP2 emergent notice. Civil suit OS number 8. The parties to the list are before the civil court, where the issue that is framed would touch upon the ingredients of the, would touch upon the fulcrum of the complaint that is made to set the criminal law into motion. In OS, madam, yes, so and so. In that light, there shall be an interim order of stay of further proceedings in CC so and so till the next date of hearing.
5.
B report is accepted. Notice madam. 1 HCGP2 emergent notice. Next.
6. 9.
Copy serve ಮಾಡಿ notice ಆಗಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ ಮಾಡಿ.
ಆಗಿಲ್ಲ.
The learned emergent notice to the respondents, the learned counsel so and so, or serve ಮಾಡಿ madam. Yes, next. With the cross examination deferred, it is covered. Where are you filing it now? The petitioner, the state is before the court calling in question an order of the concerned court which deferred cross examination on the score of identical witnesses deposing the same. So, on the deposing the same. The state is now before the court calling in question the said order of deferment of cross-examination of CW 2 to 5 till the cross-examination of 1 and 2 gets completed. The issue stands answered by the judgment rendered by this court as to when and what circumstances section 231(2) order should be passed with regard to deferment of cross-examination. In the light of the issue standing completely answered, there is no warrant of interference with the order passed by the concerned court, which is brought on challenge by the state before this court. Dismissed. Next.
8.
One HCGP2 emergent notice. There shall be an interim order of stay of further proceedings only in so far as accused number 4 and 5 are concerned, finding allegations against accused 1, 2 and 3 of torturing the daughter-in-law. Yes, prima facie. Yes, next.
Number 9.
Charge sheet ಹಾಕಿದ್ದಾರೆ. Yes, format. Charge sheet format.
10.
Discharge form. All right. ಏನಿದು?
Offense under section 140.
Page 58 ಗೆ ಬನ್ನಿ.
Molestation, no injuries, molestation, no wound certificate, but no.
Let's see. Yes. Yes, madam.
58 ಮಲೇಶ್ ಮೈ ಯೂನ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಮ್ಮೇಲೆ
ಆಗಿರೋದಾ?
ನಮ್ ಗಲಾಟೆ ಆಗಿದೆ.
Main time. Next.
Number 11.
Ida. A withdrawal, sorry, whatever. Yes. It is impossible to be interfered with. Anyway, is not there. One HCGP accepts notice for the respondents, both 11 and 12.
13.
Notice. One HCGP, 2 emergent notice.
14.
85, 2 only, A2 stayed, A1 illa. Sorry, you are The petitioners are accused 1 and 2 alleged of offense punishable under section 85 of the BNS. Finding no allegation, no ingredient of finding no allegation that would touch upon the ingredients of section 85 against this accused number 2, there shall be an interim order of stay. Only accused number 2, 1 HCGP, 2 emergent notice. Next.
In-laws are before this.
A2, A3,
Yeah.
madam. A2, A3, 85. Yes.
16.
16, again, A2, A3, 85.
17.
A2 only, brother-in, the petitioner is accused number 2, the brother-in-law of the complainant second respondent, finding no allegations that would touch upon the ingredients of the offenses under 85. There shall be an interim order of stay, the accused number 2. Yes.
18.
One ಮೇಲ್ಗಡೆ HCGP, madam, HCGP and emergent notice to the second respondent, ಅದು ಬರ್ಕೊ, ನಾನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ಕೊಂಬಿಡಿ.
Please, my lord. Please, my lord, this is a question of the complaint which is pertaining to drug and cosmetics, my lord. Complaint is filed after a 3 year, 10 months, my lord. And my lord, the second report is passed after the expiry of the drug.
You're in a college, ah?
No, my lord, I am in the.
Then why are you giving lecture? Case ಏನ್ ಹೇಳಿ?
My lord, I am in the Punjabana High Court, my lord. I am from outstation. I am from outstation council, lordship.
Then why are you giving lecture as if you're in a college?
No, my lord, I am just thinking only ground as raised. The complaint is filed.
Heard the learned counsel appearing for the petitioner. The petitioners call in question the proceedings instituted under the Drugs and Cosmetics Act. As obtaining under the statute form number 13, the drug analyst gave the forensic examination of the drug of sample that was taken happens on 19/1/2022. Contrary to the mandate of section 27D, the complaint comes to be registered after about 3.5 years of the said analysis. This would suffer from want of jurisdiction. Notwithstanding the same, the concerned court has taken cognizance of the offence. Therefore, there shall be an interim order of stay of all further proceedings by the petitioners till the next date of hearing.
19. Highly, my lord, may kindly mark my presence as a Nitin Basing, my lord, because it's strong.
Mark, sir.
Highly
Mark your
blessed,
presence. Yes, sir.
19.
Highly blessed.
Please, my lord. My lord, offense is 329 and 320.
Tahsildar is the complainant, sir.
Please, my lord.
Yes,
ಅಲ್ಲ
sir.
ಅದು ನನ್ನ ಲ್ಯಾಂಡ್ ಅಲ್ಲೇ ನಾನೇ ನೀಲಗಿರಿ ಮರ ಕಟ್
ನೋಡೋಣ ಸರ್.
ಅಲ್ಲ please. ಅಲ್ಲ, I'll produce the documents. In the 1978, the same deputy commissioner granted the land in favor of me. All the revenue documents stands in my name. And my lord, so their own the only intention is ಒಂದು ವಚನಾನಂದ ಸ್ವಾಮಿ ಟ್ರಸ್ಟ್ ಗೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್
ಈಗ ಹೇಳಿದ್ದು ಕರೆಕ್ಟ್ ನೀವು.
ಅಲ್ಲ ಆ ಟ್ರಸ್ಟ್ ಗೆ ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ದೇ ಆರ್ ಫೈಲ್ಡ್ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ಮೀ. So this is the main reason, my lord.
Yes, madam.
Documents are very clear. I will submit the documents.
We'll take care of this Tahsildar.
Please.
One HCGP, 2 emergent notice. The learned HCGP secure instructions as to how and why the Tahsildar instituted the proceedings against this petitioner, notwithstanding the documents being in possession and it being clear about the rights of the petitioners. Yes, by the next date, list the matter on 25th. There should be interim order. Ad kottaಯ್ತು sir.
Please, Mel.
Yes. There should be interim order of stay for the proceeding investigation. Further investigation query the petitioner to the next date of hearing.
Please.
ಮಾಡ್ಲಿಲ್ವಾ? 9 ಏನು madam? List number 2 na ಅದು.
I wrongly mentioned.
Serial number 9 ಯಾವುದು?
List number
9 ಏನು ಹೇಳಿದೆ ಮೇಡಮ್ ನಾನು?
discharge.
ಅದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಈಗ ಸುಮ್ಮನೆ ಇರಿ ನೀವು ಸ್ವಲ್ಪ. ಯಾವ ಬೇರೆ ಕೋರ್ಟ್ದಲ್ಲ ತಾನೆ?
No.
ವೇಟ್ ದೆನ್. ಎಸ್ 9 ಅಲ್ಲಿ ಅದು ಇಟ್ಸ್ 85 ದಿ ಪೆಟಿಷನರ್ಸ್ ಆರ್ ಅಕ್ಯೂಸ್ಡ್ 1, 2 and 3 for offences punishable under section 85 of the BNS. Finding no allegations, accused number 2 and 3, the mill and fill, andre mother-in-law, father-in-law, mill and fill, there shall be an interim order of stay of further proceedings insofar as the only insofar as accused number 2 and 3. Yes, 1 HCGP 2 emergent notice. 20. Yes, sir.
Offences are punishable under section 115 clause 2, 126
I'm not,
clause.
you're not audible, sir.
Offences are punishable under section 115 clause 2, 126 clause 2, 351 clause 2, 74 and 3 clause 5, Your Honor. It is a counterblast to the the crime that is registered by the petitioner number 1 against the respondent number 2.
What's the blast?
The complaint, the crime number 57 is the blast.
That's yours.
No, 56 is what was registered with my complaint.
It's not a counter blast, it's a counter case.
It's counter case.
Then why do you say blast? It's a case and counter case.
It's a counter case, yes, yes.
In the meantime, yes.
21.
Okay, for the petitioner, my lord, offence under Atrocities Act.
Atrocity alla 118 ಇದೆ.
My lord, they came to my property and stopped me from constructing the compound wall. Much earlier to this,
Atrocities Act will stay, but 118 ಇರೋದ್ರಿಂದ.
much earlier to this, they came
What,
on
which is the
63.
complaint that you have given?
Adu ide and NCR ide at page 17, my lord.
Page?
17.
Anyway, it's bound to property dispute. In the meantime, next.
Counter. Obliged.
22.
Okay. Yes.
Here for the petitioners accused. The offences.
B report rejected, cognizance taken.
Yes.
In the meantime, next.
23.
ಅದು ರೀಸನ್ ಬರ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. ಇದರಲ್ಲಿ 21, 22 ಅಲ್ಲಿ the petitioners are before this court calling in question the order passed by the concerned court taking cognizance on rejection of the B report. A perusal at the order of rejection of the B report and taking of cognizance in a seemingly civil dispute would run foul of the judgment of the coordinate bench in ILR 2018 Karnataka 1725. Adu party name hakbidi. In that light, there shall be an interim order of stay for the proceedings with the petitioner. Next.
23.
The offense under section.
Notice 1 HCGP 2 emergent notice.
There is civil dispute.
No, yes. Returnable by 28th. Yes, next.
There is gifted.
24.
On that background, gifted executed by the mother of the
We'll see.
first petitioner.
Yes, yes, we'll see.
Any date may be given.
28th, there is a date, sir. Yes.
24.
The petitioners are A2 to A5, alleged of offences punishable under section 85, finding no allegations that would touch upon the ingredients of the offences under section 85 of the BNS, permitting further proceedings would run foul of the judgment of the apex court in the case of Aarti Mehta versus State of Madhya Pradesh 2026 SSC Online SC page 933. Therefore, there shall be an interim order of stay of further proceedings by the petitioner. Next.
25.
For petitioner, madam. For offenses 364 and 307, madam.
307.
Complainant.
But
ready.
only A5. Instigation.
Complainant ready there, my lord. Compromise ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ. Complainant ready there.
ನಿಮ್ ಜೊತೆಗ? 1 HCGP 2 emergent notice, returnable by the 25th. Get the complaint, we'll close it on that day.
26,
Animesh. One HCGP, ಅಲ್ಲ ಇದು HCGP ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. Emergent notice to the respondent, no representation by of the petitioner.
27,
A2 only.
Your Lordship.
The petitioners are accused 1 and 2. There shall be an interim order of stay quay. The accused number 2 only till the next date of hearing. HCGP on emergent notice 2 returnable by the 27th.
Your Lordship, may I make a humble submission, Your Lordship? Your Lordship, what has happened is, as decided in the Lalita Kumari judgment, Your Lordship, there needs to be an extraordinary delay when such a matter is being registered as an FIR, Your Lordship. Your Lordship, in this matter, the complaint is filed on the 30th, Lordship, and on 30th itself, the FIR is also filed. The respondent's family comes from a little influence, Your Lordship, which is why there is a.
We'll see. That's why I've given a date now.
Obliged, Lordship.
List the matter on 25th.
Obliged.
Emergent notice returnable by 25th.
28,
25th or 27th ಇರ್ಬೇಕು ಮಾಡಿ. 27th, yes.
Obliged.
28 also A1 husband.
Huh?
28 my lords, A1 is the husband.
ಯಾವ್ದ್ರಲ್ಲಿ?
He's a Sipai, my lords, ex-service.
ಅಲ್ಲ ಅದು ಬೇರೆ ಸ್ವಲ್ಪ ನೋಡಿದ್ರ A1 ಹಸ್ಬೆಂಡ್ 60 ವರ್ಷ,
Yes.
ಅವ್ರಿಗೆ 50 ವರ್ಷ, ಮದುವೆ ಆಗಿ 30 ವರ್ಷ. ಈಗ 498
Charge sheet ಅಲ್ಲಿ
ಏನ್
allegation.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Ex-serviceman, my lords.
ಯಾಕೆ ಸರ್ವಿಸ್ ಪ್ರಾಬ್ಲಮ್?
Yalla, he has rendered his service in Indian Army.
ಯಾವಾಗ ಬಂದ್ರಿ ವಾಪಸ್ಸು?
Just 2 years back, my lords. 2-3.
Just 2 years
ಹೌದು
back.
sir, retired ಆಗಿದ್ದಾರೆ.
ಬಂದು ಇಲ್ಲಿ ಕಾಟ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನ್ ಕಾಟ ಏನಿಲ್ಲ.
ಮತ್ತೆ
No such, my lords.
the petitioner is now 60 years, the wife 50 years, married for 30 years. What has sprung now is an allegation of dowry harassment as obtaining under section 85. A perusal at the complaint would not indicate an iota of ingredient of said offense under section 85, except sprinkling instances of certain cruelty. If this is permitted to be investigated even, it would become an abuse of the process of the law on the face of it. Therefore, there shall be an interim order of stay of all investigation till the disposal of the petition. 1 HCGP, 2 emergent notice.
29,
1 HCGP, 2 emergent notice, there shall be an interim order of stay only insofar as the offences under the Atrocities Act are concerned. Next.
30,
The petitioner in this case, Your Lordship.
A2 and A3. The petitioners are accused number 2 and 3. All the transaction in the case at hand happens with accused number 1 company, right?
No, Your Lordship. Accused
Individual.
number 1 is also the partner.
Accused number 1. The petitioners accused number 2 and 3 were not involved in the day-to-day affairs as the averment. It is also the averments in the complaint as well. In that light, there shall be an interim order of stay of quay, the accused number 2 and 3 only till the next date of hearing. 1 HCGP, 2 emergent notice. Next.
31,
Shankar, KPID. Learned HCGP is directed to accept notice. The learned SPP is directed to appear in the matter. Monday, fresh matters.
32,
For the petitioners in this case.
Petitioners are accused 1 to 5. Insofar as the accused number 2 to 5, there shall be an interim order of stay as perusal at the complaint or charge sheet agidiyalla?
Charge sheet agide, my lords. My lords, they are residing together, my lords. It may be referred for mediation on 24th, my lords.
Sorry. The learned counsel for the petitioner submits that the husband and the wife have reunited and therefore would settle the issue. List the matter on 24th at 4 PM to report settlement.
My lords, for mediation, my lords.
Mediation ಹೋಗ್ಬೇಕಾ?
Please, my lords. They are residing in Rajasthan, my lords.
The parties to the list, ಎಲ್ಲ appear ಆಗ್ತೀರಾ mediation?
Bangalore Mediation Center itself will come.
The parties to the learned counsel for the ಹಿಂಗ್ ಮಾಡ್ಕೊಳ್ಳಿ madam. The learned counsel of the petitioner submits that the husband and the wife have reunited and would want to settle the issue. Therefore, seeks reference of the matter to mediation. The parties shall appear before the Bangalore so on 20th. List the matter on 24th. Saga?
Please, my lords.
Yes.
33,
NDPS, sir.
In this, my lords, I have produced, documented,
Ah.
annexure 3.
To show consumption.
No, there is no
Then
consumption.
what
I have
document
tested
have
negative.
produced?
FSL report, my lords.
Ah, ಏನು?
In that, I have not tested positive for anything.
ಏನ್ ಟೆಸ್ಟ್ ಮಾಡಿದ್ರು?
Urine test, my lords.
ಏನ್ ಟೆಸ್ಟ್ ಮಾಡಿದ್ರಿ ಸರ್?
Page number 26.
ರಿಕವರಿ ಏನ್ ಮಾಡಿದ್ರಿ?
4 grams.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ.
4 grams.
ಆ?
4 grams of charas, my lord.
4 grams of charas. ಕನ್ಸಂಪ್ಷನ್ ಗಲ್ವಾ? ಕನ್ಸಂಪ್ಷನ್ ಏನ್ ರಿಕವರಿ ಮಾಡಿದ್ರಿ?
My lord, FSL opinion, my lord.
ಏನ್ ಕಳಿಸಿದ್ರಿ?
My lord, sample set, my lord, is.
What sample, sir?
4 grams of charas.
4 grams of what? Sample.
Charas, yes.
ಆಯ್ತು, ಅದು ಚರಸ್ ಆಯ್ತು. ಇವ್ರು ಕನ್ಸ್ಯೂಮ್ ಮಾಡಿದಾರೆ ಏನಕ್ಕೆ ಏನ್ ಕಳಿಸಿದ್ರಿ?
My lord, so it has responded positive for charas.
ಪಾಸಿಟಿವ್ ಫಾರ್ ಚರಸ್.
Oh, my lords. At page number 26, my lords.
ಏನಿದೆ ಅಲ್ಲಿ?
25.
ಹಾ.
Urine test has been conducted.
ಹಾ.
And then I have not tested positive for any of the drugs.
ಮತ್ತೆ ಚರಸ್ ಎಲ್ಲಿಂದ ಬಂತು?
Drugs, my lords.
That is the drugs seized.
ಅಲ್ಲ, ಚರಸ್ ಇಸ್ ಪಾಸಿಟಿವ್. ಇವ್ರು ಕನ್ಸ್ಯೂಮ್ ಮಾಡಿರೋದು ಪಾಸಿಟಿವ್ ಇಲ್ವಾ ಹೇಳಿ? ಕನ್ಸ್ಯೂಮ್ ಮಾಡಿಲ್ವಾ?
No consumption.
Yes.
Initially, in the FIR, they have.
ನೀವೇನ್ ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ? ಅವ್ರು ಏನ್ ಸ್ಯಾಂಪಲ್ ತಗೊಂಡ್ರು ಅದನ್ನ ನೋಡಿ ಸರ್. ಯಾವ್ದು ಬೇರೆ ಕೇಸ್ ಇರ್ಬೇಕದು?
ಇಲ್ಲ, ಇದೆ.
ಇದೇನಾ?
Page 25.
ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿದ್ದೀರಾ ನೀವು? ಮತ್ತೆ ಪೇಜ್ 25 ಅಂತ
Charge sheet ಆಗಿದೆ.
ಅವ್ರು ಹುಡುಕ್ತಿರೋದು ಅದನ್ನ. The petitioner is alleged of consumption of a narcotic drug. On the day of such consumption, it transpires that the petitioner's urine sampling was done by on a forensic examination, which finds that the petitioner has not consumed any contraband. In the light of the said circumstance of the FSL, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. List the matter on 27th. Fresh matters. Next.
34.
108.
Yes, my lord.
It is registered on June 2026. Get the investigation papers.
Yes, Monday.
List the matter on Tuesday, 19th in the fresh matters list. The learned HCGP to secure the investigation papers and place it before the court. Yes, next.
35.
A4 and A5, who are they? A6 is the purchaser.
ವಿಟ್ನೆಸ್ ಆಗಿ ಸೈನ್ ಮಾಡಿರ್ತಾರೆ
ಅಷ್ಟೇ, ಅದನ್ನೇ ಕೇಳ್ಬೇಕಾಯ್ತು. ಅದು ಎಲ್ಲಿ ಹೇಳ್ಬೇಕು ತಾನೆ ಕರೆಕ್ಟ್ ಆಗಿ?
ಅಲ್ಲ, ಅಲ್ಲಿ ಹೇಳಲ್ವಾ ಸ್ವಾಮಿ?
ಅಲ್ಲಿ ನಿಮ್ ಪೆಟಿಷನ್ ಹೇಳ್ಬೇಕು ತಾನೆ ಕರೆಕ್ಟ್ ಆಗಿ. ಊರ್ನೋರು ಅಂತ ಹೇಳ್ಬಾರ್ದು ಅಂತನಾ? The petitioners are accused 4 and 5. They are signatories to the said document as witnesses. They are drawn into the web of proceedings on a subsequent event of the document becoming allegedly fraud, on alleged fraud of the document, creation of the document. The petitioners being witnesses to the said document cannot be hauled into the proceedings is now too well settled a principle of law. In that light, there shall be an interim order of stay, qua accused number 4 and 5 till the next date of hearing. 1 HCGP, 2 emergent note.
36.
Petitioners are accused 1 to 6, alleged of offense punishable under section 85 of the BNS.
1 to 7.
1 to, all right, 1 to 7. Alleged of offense punishable under 85 of the BNS inter alia. Finding no ingredients of the offences qua accused 2 to 7, there shall be an interim order of stay of further investigation.
Yes, ma'am.
Further investigation. The investigation insofar as the husband accused number 1 shall continue. 1 HCGP, 2 emergent notes. Next.
37.
In the meantime,
38.
Raja, OS number.
733 of 2025.
Huh?
733 of 2025.
The parties to the list are before the civil court in OS 733 of 2025. The said civil dispute is projected to become the ingredients of criminal trespass as obtaining under section 329(3). Finding no ingredient of the said trespass, there shall be an interim order of stay of further proceedings square the petitioner to the next date of hearing.
39.
For the petitioner, madam. Madam, the petition.
Page 20 settlement ಆಗಿದೆಯಾ? ಏನಿದೆ ಅದರಲ್ಲಿ?
Madam, the mutual divorce petition as filed by the husband and wife has been allowed, my lord. In that, my lord, there is no specific allegation against the petitioner, my lord.
ಅಲ್ಲಪ್ಪ, ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಇದು ಕವರ್ ಆಗಿದೆಯಾ ಕ್ರೈಮ್?
No, madam.
ಇಲ್ಲ.
After that.
ತಾನೇ ಆಗಿರೋದು.
Yes, madam.
One,
Also, my lord, there is a delay, my lord.
one HCGP, 2 emergent notice returnable by the 25th.
Madam, there is a delay in filing the complaint, my lord.
We'll
And also,
see.
my lord, other accused are dishonorable.
No,
court as
we'll
well,
see,
madam.
we'll see, yes.
Yes.
On
That's
that
it,
day,
madam.
emergent notice returnable by 25th. Next.
40,
In the meantime,
41,
the petitioners A1 ಕೊಡಲ್ಲ. ಇದು 498 ಎಲ್ಲ ಗೊತ್ತು,
The first
ಗೊತ್ತು, ಬಟ್
complaint. And
ಎಲ್ಲ A1 ಮೇಲೆ ಇರೋದು.
they have, my lord,
ಈಗ A1 ಗೆ ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲ ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ. The petitioners are accused 1 to 7. Finding no ingredients of the offences as alleged or any overt act of assault by other accused, there shall be an interim order of stay qua all other accused. Insofar as the accused number 1 is concerned, there is a specific allegation that he has hit the complainant with the helmet. Helmet ಏನದು?
Milk can.
Milk can, sorry, with the milk can. Therefore, there cannot be an interim order of stay qua accused number 1. 1 HCGP, 2 emergent notice.
Please.
42,
Petitioner is accused number 7. Though the offense is the one punishable under section 118 of the BNS, there is not even an iota of ingredient against accused number 7, the present petitioner. In that light, there shall be an interim order of stay of further proceedings qua the petitioner accused number 7 only till the next date of hearing.
43,
The petitioners are accused 1 to 4. 1 to 3. There shall be an interim order of stay qua accused number 2 and 3. Mother-in-law, father-in-law.
ಇಲ್ಲ ಮದರ್-ಇನ್-ಲಾ ಬ್ರದರ್-ಇನ್-ಲಾ.
No, mother-in-law, Emil and Bill, till the next date of hearing, finding no allegations that would touch upon the ingredients of the offences. Insofar as
settled, she has already agreed. Decree also granted, my lord. 498 only.
this is insofar as accused number 2 and 3 are concerned. Insofar as the husband is concerned, the learned counsel for the petitioner would take this court through a decree that is drawn pursuant to mutual divorce granted. In that light, there shall be an interim order of stay with the husband as well. 1 HCGP, 2 emergent notice.
They started fixed, man.
20 returnable by 27th.
Please.
44,
44 and 45 minutes. Case and counter case. Husband is the
ಯಾಕೆ
petitioner.
ಎರಡು? Why ಎರಡು ಕೇಸ್ ಹಾಕಿದಿರಿ?
ಅಲ್ಲಿ
ಅಲ್ಲ, ಕೌಂಟರ್ ಕೇಸ್ ಎರಡರಲ್ಲೂ petitioner ನೀವೇ.
ಹೌದು. After marriage, she stayed with me for 1 month. Threw me out of my own house.
1 month ಅಲ್ಲಿ she drove you out of the house.
ಹೌದು. I filed a complaint. FIR is filed. Charge sheet is filed. She files a counter complaint.
And you went out of the house.
ಅದ್ರ ಮೇಲೆ ನಾನು ಹೈಕೋರ್ಟ್ ಬಂದೆ. She filed.
ಮನೆ ಬಿಟ್ಟು ಹೈಕೋರ್ಟ್ ಬಂದ್ರಾ? ಯಾಕೆ?
I filed a petition, Malach.
Do you think you can stay here?
I filed a divorce petition also. Then she came and she filed an affidavit stating she's the owner of the house. Then the High Court took cognizance of it. Contempt is initiated. Then she said we will settle the matter until 2025. It went on for settlement. Then she retracted and the cases are continuing.
Filed. Now you are in the house, outside the house.
Outside the house.
Huh?
It's in a PG.
PG. Ayyo.
My father is also dead because of all these things. Mother is also in a old age home because of this.
She has driven everybody out of the house. Huh?
There are 4 FIRs filed. This is her second marriage. First marriage also the same thing which is happened. 18 lakhs alimony she took immediately after the marriage. She married me.
ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ಇದು? Both these cases are filed by a solitary petitioner and others. Illa, obre. Others. The husband is before the court calling in question registration of multiple crimes by the wife against the husband as a counterblast to the proceedings instituted by the husband against the wife. The learned counsel for the petitioner takes this court through the documents appended to the petition. to prima facie demonstrate that the wife stays with the husband for over a month and drives the petitioner, his parents away from the house. The parents are now staying in the old age home, the petitioner as a paying guest in some other residential house, but not in his house. It transpires that certain proceedings also took place before this court, where the wife had agreed for settlement but did a volte-face at a later point in time. With all these proceedings, it transpires prima facie that the wife has abused the process of the law in drawing the petitioner or the parents into the streets and the husband now into the web of these proceedings. In that light, there shall be an interim order of stay of further proceedings qua the petitioner husband till the next date of hearing in both these cases. Connect ಮಾಡಿ madam. Complaint ಒಂದೇ ಅಲ್ವಾ?
There are two other petitions which the wife
ಇನ್ನೊಂದೆರಡು
has
ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, ನಾನ್ ಹಾಕಿದ್ದ FIR ಮತ್ತೆ
ಅದು
charge
stay
sheet
ಆಗಿದೆಯಾ?
ಅದು stay ಆಗಿದೆ.
ಬಹಳ
I'll
ಸಂತೋಷ.
pass
ಕೊಡಿ
on the
ಟ್ಯಾಗ್
numbers.
ನಂಬರ್ ಕೊಡಿ.
Yes. Criminal petition number 131905.
ಬರ್ಕೊಡಿ ಸರ್. ಇನ್ಯಾರ್ದು ವೈಫ್ ಕನೆಕ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ. ಎಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಡಿ.
46.
That's for the petitioner, my lord.
OS number.
Please, my lord. 132 of 2024, my lord.
The parties to the list are before the civil court in OS number so and so. On the same set of facts, a criminal trespass is now alleged against these petitioners who are in possession of the property. In that light, there shall be an interim order of stay of further proceedings qua the petitioner to the next date of hearing.
47.
The petitioner is accused number 2 against whom this court on perusal at the complaint would not find any allegations that would touch upon the ingredients. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing.
48.
13.
13 on the
Learned Counsel so and so accepts the BB Patil accepts notice for the respondents. Petitioner to serve set of papers upon the aforesaid counsel forthwith. This the matter on 17th.
Lordship, Lords, passed an order.
If charge sheet is not filed.
The Lordship may tag.
In the tag kodi. Nenne serial number 55 tag
Please.
ಮಾಡಿ.
Listed on 17th.
Serial number?
ಅಲ್ಲ 55 less yesterday.
55
Yes, Lord.
nenne
Listed on
second
17th.
list ಅಲ್ಲಿ 55 ಇದೆ ಅದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡಿ.
Yes, listed on 17th.
17th.
Yes.
List on 17th.
Great.
ಟ್ಯಾಗ್ ಆದ್ರೆ ಅದು ಬರುತ್ತೆ 17th. Vipin sir 109.
Lord, let them produce the medical certificate.
ಬರ್ಲಿ
My
ಅಲ್ಲ.
lord, nothing is
Documents ತರ್ಸು.
Because my lord, it's a joint development agreement which was entered.
No,
in
that
20
other instance is not a problem. 109, I want to see the documents. Heard the learned counsel Bipin Hegde appearing for the petitioner. The learned HCGP to accept notice, secure the investigation papers and place it before the court on the next date, 17th fresh matters.
50.
106. 106. BNS. My lord, sir, even the postmortem report, my lord, would say that the victim bled out.
What's the compensation given?
That's that I shall secure.
The learned counsel shall secure instructions with regard to the amount of compensation granted by these granted by these petitioners to the family of the deceased. List the matter on 17th in the fresh matters is next.
The matter is kept for charges, my lord.
Parvala, first give the information. Yes, next.
List number 2 being spoken to still number 1.
ಏನಿದು? Being spoken to why?
Lordship was pleased to not
Subsequent.
allow the petition and not directed not to release the compensation in favor of Gravya Nirmana Samiti.
Alla, in favor of to the members of the society who was head, who was in charge of the affairs of the
Yes,
society.
please, Lord.
Anyway, he had resigned. He had no grievance.
But Lord, here Lord, he stand for your Lordship.
Who stand?
He stand on the other side. But for a moment, Lord, I will.
Stand of the other side ಅವತ್ತೇ ಹೇಳಿದಾರಲ್ಲ ನಾನೇನಿಲ್ಲ ಬಟ್ ಹೋಗೋರ್ಗೆ ಹೋಗ್ಬೇಕು ದುಡ್ಡದು ಅಂತ
But
ಅಷ್ಟೇ.
here he says this.
ಹಾ.
But Lord, before the learned magistrate, Lord, his stand is totally different. But he has
What
set
has
up, Lord,
happened?
one Nagesh, but in his place, and he has filed, Lord, a series of objections. And Lord, he is obstructing, and Lord, in fact, but even the,
ನೀವು ಅಲ್ಲ ಯು ಆರ್ ನಾಟ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ತಾನೇ ಈಗ?
I'm not the president.
ಬಿಡಿ ಅವ್ರು ಯಾರು ಸೊಸೈಟಿ ಮೆಂಬರ್ಸ್ ಹೋಗುತ್ತೆ.
I, actually the respond number 2, because he is not a president as of now. Now the present president is Nagesh.
Whoever it is.
Yes, but what they are impersonating before the court is.
Impersonating.
Please, my lord. Now what the argument that was canvassed by the senior counsel saying that let the deceased accused son be allowed to operate the account. The same thing is even done in the trial court.
Now you are not there. ಯಾವ ಮೆಂಬರ್ಸ್ ಹೋಗ್ಬೇಕು ಹೋಗ್ಲಿ ಅದು.
Please, my lord.
ನಿಮ್ಗೆ ಯಾಕೆ?
My lord, I have filed an application under section 302 subsect of CRPC. Now I am prosecuting the case. They have filed an application. Now who has filed the application? The same person who have before this court, the Kadegowda.
I have directed that members of the society who had lost their land will get the money.
Correct, my lord.
Period. Ashte.
That's it.
That's all.
Now
nobody else will have any grievance, much less you. ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಮತ್ತೆ?
Who actually?
He is trying to canvass before the learned magistrate, stating that the order of the learned magistrate is correct. But if lordship
Hari Prasad.
My lord. Let me clarify, my lord. The only.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ ತಗೊಂಬನ್ನಿ ಇಲ್ಲಿ.
Please.
53 blood. Yes, 53 of my IA for clarification.
IA ಬೇರೆ ಹಾಕಿದೀರಾ?
ಅಲ್ಲ, for clarification.
ಎಲ್ಲಿದೆ ಕ್ಲಾರಿಫಿಕೇಶನ್?
I have filed one application. It is listed today.
ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
I am not, sir.
It is only IA for clarification. He is
Of
out
what?
of court blood last time only.
Last time I still remember he has told he has nothing to do because he is not holding the office.
Correct.
And I directed that every pie should reach the persons, members of the society who have lost their lands.
Correct.
Straight.
Now the only grievances is, my lord, as to what Samiti actually happened to be the genuine Samiti.
Adella good. That is not the scope of the petition.
Nirmana Samiti, I am making this submission. Respond number 2 was never Lord the president.
ಅದು ಗೊತ್ತಿಲ್ಲ sir. Even he was never there, but as on the date I decided the matter, he was not there.
Yes, correct.
That is correct.
Yes.
And the petitioner, what clarification you have sought?
Clarification with regard to saying that the Samiti happened to be the Samiti that is run by the Karnataka state employees.
Whoever is running the Samiti,
But
sir.
that is how Lord he is trying to.
Whoever is running the Samiti now will get the compensation. Members ದುಡ್ಡು ಹೋಗ್ಬೇಕಷ್ಟೇ ಅದು.
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ ನೀವೇನಿಲ್ಲ?
My lord, my apprehension is that.
ಅಲ್ಲಿ ಆದ್ಮೇಲೆ ಬನ್ನಿ, ಅಪ್ರಹೆನ್ಷನ್ ಏನಾದ್ರು ಇದ್ರೆ ಅವಾಗ.
My lord, now the Samiti, the very dispute is which Samiti happened to be general Samiti. Now they are purporting the material stating.
Whatever Samiti is considered to be the Samiti here in the order, that is the Samiti. All right, that's all. The petitioner has preferred an application seeking clarification of the order. The clarification is sought on the score that the second respondent complainant is interfering with the order that is order to be passed by the concerned court pursuant to the order passed by this court. This court had disposed the subject petition. Well, where is the order?
On 24/6.
Where is the order?
My lord, with regard to my lord, what has happened is now Kadegowda has once again he has filed an application seeking defreezing of the same account. Once it has reached a finality.
No. I am only saying, ದುಡ್ಡು ಹೋಗೋದು ಬೇಡವಾ ಎಲ್ರಿಗೂ?
ಹೋಗ್ಲೇಬೇಕು ಸ್ವಾಮಿ. But the contention.
Land loser ನಿಮ್ಮಿಬ್ಬರು ಗಲಾಟೆಲಿ persons who have lost the land will not get the money.
My lord, his submission, the Kadegowda, for a moment, my lord, the submission of this petition.
I am not going to rehear the matter, sir.
No, my lord. Just to clarify.
You said that you have nothing to do with this.
Yes, my lord. Even now,
and
that's
the
my
concern
stand.
of the court was that every land loser should
Correct,
get
my lord.
the amount of compensation which is now stuck in that frozen account.
Yes, my lord.
I directed defreezing for the said purpose.
Yes.
ಅಷ್ಟೇ.
My lord, my concern.
Are not defreezing and court is
My lord, my concern is the stand taken by.
After objections.
Yes, just for a moment, my lord. The stand taken by the
ಈಗ
petitioner.
ನಿಮಗ್ ದುಡ್ಡು ಬರ್ಬೇಕಾ?
My lord.
ನಿಮಗ್ ದುಡ್ಡು ಬರ್ಬೇಕಾ?
I am nowhere concerned, but.
ಮತ್ತೆ ಬಿಡಿ.
My
Yes.
lord. May I make a
No,
for a
no,
moment,
Hari
my lord.
Prasad, this is not the way.
Let me clarify, my lord.
Yes, sir.
The petitioner before this court came in the guy saying that he is actually happened to be one of the member of the Samiti.
You forget about the petitioner, sir. I have passed an order that every member of the society who has lost his land should get compensation.
Correct.
And that compensation amount is now does now lie frozen in a bank account.
Correct.
I have directed defreezing that every amount should go to him. Whoever is now managing the affairs of the society shall distribute it to all the members. That is all I have said.
Now they are contesting that who is managing that Samiti.
ಅದಕ್ಕೆ ಇವತ್ತು ಯಾರಿದಾರ ಅವರು ಅಷ್ಟೇ. ನೀವಿಲ್ಲ ತಾನೆ.
My lord, by what,
No, he is
whoever.
trying to inject not some
No,
other
my
person
lord.
now.
That
Who?
is,
Not only
No,
complainant.
no, sir.
no,
The petitioner.
my lord. For a moment, my lord.
No,
Just
Hari Prasad.
once-
This is, you
just-
are, I think you are creating all the problems now. Andre, your client is creating all the problems
For a
here.
moment, my lord.
Not letting the amount go to the members of the society.
Just one sentence, my lord.
Yes,
They
sir.
clarify. My lord, TH, in this petition, the Kadegowda came before this court in the guise of saying that he was actually the member of the society.
Huh?
Now he has filed one more application before the trial court, where he said that he actually advanced to TH Ramakrishna as a loan. May I pass on this, my lord? The
ಅದೆಲ್ಲ-
application so filed by him.
One ನಿಮಿಷ. This court, ಬರ್ಕೊಳ್ಳಿ madam. This court on 24th June 2026, by a detailed order, disposes the petition directing a particular action to be taken. The order reads as follows, page 23-24 of the IA. The order directed the defreezement of the account of the Samiti and the officers of the Samiti who are presently holding office to secure the said amount of compensation and distribute it to the persons entitled to get compensation without driving those entitled persons again to knock at the doors of this court. In the course of the hearing, the complainant, who was the erstwhile president of the, not of this Samiti, but on the strength of being a president of the government, State Government Employees Association, Mandya.
He was
had-
also, he
Alla,
was also de
ಆಯ್ತು.
facto, de facto.
Ex officio.
Ex
And on the strength of that being, he was an ex officio member of the subject society. On the day of the hearing of the petition, on the day of the hearing of the petition, the respondent complainant had no connection with the affairs of the present society. He had his term as president of the government employees so and so society was association was over. Association was had come to an end. In that light, he had no grievance, but the only interest that he projected was that the amount should go to the persons who have lost their lands. This is exactly what the direction, what this court has rendered as quoted supra. The second respondent cannot now go before the concerned court and throw a spanner in the wheel to stop compensation to go to the persons who are entitled to. He is not the one who is entitled to, but cannot, he's not the one is entitled to is an admitted fact. But the others who are entitled to should get the benefit of the lands being acquired and the compensation being stuck in a particular bank account. The direction was to defreeze the account and distribution of the said amount to the land losers who are members of the society by the office bearers of the society. This is with the aforesaid clarification, the IA stands disposed.
One more submission, not he is trying to induct somebody, not that should also be.
Trying to induct somebody in ಅವರಲ್ಲಿಂದ ಬರ್ತಾರೆ.
He has filed application, not application after.
I have not filed any, I have not filed any application.
The learned senior counsel submits that the complainant who had submitted before this court that he has nothing to do with the present society is wanting to induct someone else. The learned counsel submits that there is no warrant of induction of any person if the amount of compensation reaches the persons who are needy. And would submit that he has not attempted to induct anybody before the concerned court. This submission is placed on record.
I submit, my lord. Let this entire exercise of dispersing the amount may be overlooked by at least a magistrate. My lord. There is some issues with regard to siphoning of this money. That is what the only concern. Let this be done under supervision of the DG.
ನೀವು ಅವ್ರ ಮೇಲೆ ಏನೋ ಇಟ್ಕೊಂಡು ಬರೋರ್ಗೆ ದುಡ್ಡು ಬರೋದು ಆ ಲ್ಯಾಂಡ್ ಲೂಸರ್ ದುಡ್ಡು ಹೋಗ್ಲಿ ಬಿಡಿ ಸರ್.
My lord,
When he says, Lord, he has no objection, but I don't know, I am unable to understand. his
If there is
submission.
anything, you come back, we'll see.
Not a respondent,
only-
police may be directed to not defreeze the account.
To the
Not
Samiti.
ಈಗಲೇ ಹೇಳಿದ್ನಲ್ಲ.
One more submission, police are to defreeze, not there, my lord. The police are saying, will settle the, that is how, my lord, the police are acting as, my lord, agency for settlement. You will ask me kindly direct the police to defreeze the account.
My lord, Now what they are trying
See,
to.
one nimsha. For implementation of the order of this court, which has directed that every member of the society who has lost the land should get the compensation, the investigating officer shall forthwith direct the concerned bank to defreeze the account and see to the defreeze the account. The members, the office bearers of the society now shall oversee that the amount reaches every person who has lost his land.
Samiti which is legally entitled to my lord.
ನೀವು ಈ ಹೊಸ ಸಮಿತಿ ಆ ಸಮಿತಿ whoever is holding office today.
Who is holding the office? Please, my lord.
ಅದೇ ಬರ್ದಿರತ್ತೆ.
Please, please.
Yes, sir.
Grateful.
But one more last submission.
Eh,
I'm sorry for. But this original account number 1 has died during the pendency of this.
ಅದನ್ನೆಲ್ಲ ನೋಟ್ ಮಾಡಿದ್ದೀನಿ ನಾನು ಮತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಬರೀ. Yes.
No,
What
now
I have
not-
written is enough now. Is rehearing the matter ಆಯ್ತು. Yes.
Grateful.
Number 2.
And for the petitioner. After challenging before this honorable court, my lord, the case has committed to session court. Sessions case number quash ಆಗೋ ಬದಲು CC number quash ಆಗಿದೆ.
ಆಯ್ತು ಸರಿ. ಅದು the learned counsel for the petition, this court will disposal ಯಾವತ್ತಾಗಿದೆ ಹೇಳಿ.
14-6, my lord.
The subject petition,
24.
this subject petition stood disposed by an order dated 24/6/2026. The learned counsel for the petitioner submits that what is quashed is the CC and the matter had been committed to the court of session in SC
725 of 26,
725/26 and therefore that had to be quashed.
pending before 45th additional city civil and sessions judge.
That's it. In the light of the order needs correction with regard to incorporation of the SC number. So and so. A fresh copy be issued to the petition.
Please.
Next.
Fresh matters number 3.
My lords, I appear for the
ಬೇರೆ
petition.
ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಇದ್ವಲ್ಲ ಏನಾಯ್ತಿದು?
My lord, serial number 88 ಅಲ್ಲ.
80?
88 my lords.
ಅದ್ರ ಜೊತೆ ತಗೊಂತೀನಿ. ಇದೇನು ಇದು ಸರ್ವ್ಡ್ unrepresented ಆಯ್ತು. We'll take it along with 88.
4.
My lordships,
My lord, in
page
this
number 51
case, my
and
lord,
where
today
the
I have-
charge sheet and the complaint is on page number 51, my lord. There is not even a single ingredient which can attract 498A. The complaint is very, basically the father was taking the child for taking bath and the child cried and came back. And for that correction, she has come and filed a 498A and 323 implicating the son because the family court had ordered for family therapy. So
family therapy?
No, the GWC, there is an order of family therapy by the trial court, my
There is
lord.
a concept of family therapy, is it?
Yes, my lord. At Nimans. So because
Right.
both the husband and
Hans.
wife stay in the same house, my lord, in fact, there are 10 cases running. The whole reason why it had come here is because there was a MC which has been filed because of adultery. Of basically that is the whole reason.
Let her file
this
her
came.
objections. Yes,
My
ma'am.
lord, but meanwhile.
Wait, sir. Yes.
My lord, today I have filed the wakalat for respondent number.
Learned counsel so and so submits that she has entered appearance for the respondent, registry to print the name of so and so is appearing for the respondent.
And the second thing is, my lord, their petition is of the page number 110, but
The
served only
petitioner to
50
serve complete set of papers upon the council as afore noted. Lest the matter on 24th in the fresh matters list. Objections, if any, by then. Yes.
My lord, one submission, my lord, the complaint and the charge sheet reply what they have given, both are not in tandem at all. In the charge sheet where
It
the
need not
entire-
be. Don't worry. Yes.
At least the stay may be given, my lord, for correcting the child if this may be bought in.
We'll see next.
Obligement.
5.
Appear for the petitioner in this matter, my lord. My lords, the
48%.
impugned order.
You appeared before the committee?
ಆಯ್ತು, ಆಗಿದೆ.
Appear ಆಗಿದ್ದೀರಾ?
ಆಗಿದೆ. ಬಂದಿದೆ.
My lords,
Wait, ಅವ್ರದ್ದು ಕೇಸ್ ನಿಮ್ದಲ್ಲ.
My lords, I have challenged an impugned order, my lords, whereby the learned magistrate has permitted under section 302 subclause 2 to engage a private person to engage his own advocate as a special public prosecutor, my lords. My lords, he has allowed the husband of the de facto complainant who is passed away, my lords, to engage his counsel, my lords. My lords, the matter, my lords, is a civil in nature, my lords, wherein the entire substance of the case is that, my lords, the father of the petitioner who died was the owner of a property wherein he had allegedly, my lords, executed a will in favor of the late wife of the de facto complainant, my lords, late wife of the husband now.
ಈಗ ಇಶ್ಯೂ ಏನ್ ಸರ್?
My lords have
302 ತಾನೆ?
Yes, my lords.
Yes, sir.
I have my submissions. He has an IA for stay. ಅದನ್ನ ದಯವಿಟ್ಟು ಕೊಡ್ಬೇಡಿ. ಯಾಕೆಂತಂದ್ರೆ
ಅಯ್ಯೋ ಅದು ಬಿಟ್ಟು ನಿಮ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ, ನಾನೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಡಿ.
ಅವರು ಯಾಕೆಂದ್ರೆ ಎರಡನೇ ಸಲ ಬಂದು ಇದು ಮಾಡ್ತಾರೆ.
ಆಯ್ತಾಯ್ತು, 302 ಅಪ್ಲಿಕೇಶನ್ ನೀವು ಹಾಕಿದ್ದೀರಾ ಈಗ?
ಹೌದು, ನಮ್ಮ ಕೌನ್ಸಿಲ್ ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ
ಈಗ ಅಲೋ ಮಾಡಿದಾರ ಕೋರ್ಟ್ ಅದನ್ನ?
ಮಾಡಿದ್ದಾರೆ.
ಏನು ಸಪರೇಟ್ ಆಗಿ ಮಾಡಕ್ಕ ನಿಮ್ಗ?
ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಈಸ್ ಎ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೌನ್ಸಿಲ್.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೌನ್ಸಿಲ್.
Complaints council cannot become a prosecutor there.
ವಿಕ್ಟಿಮ್
ಅದು ಅಸಿಸ್ಟ್ ಮಾಡಕ್ ಮಾತ್ರ ಸಾಧ್ಯ ಅಷ್ಟೇ.
302 ಲಿ
302 only assistance to the prosecution.
ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಸ್ ಕೋರ್ಟ್ ನೀವೇ ನಿಮ್ಮ ಒಂದು
ಹೌದು ಕರೆಕ್ಟ್, ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಮಾತ್ರ ಅಂತ.
ಇಲ್ಲ ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು. ಕೋರ್ಟ್
ನಾನು ಕೊಡ್ಬೇಕು.
ಯದುಕುಮಾರ್
ಕೊಡಿ, ಇಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ.
ಇಲ್ಲ
This is on who can make an application. Under 302(2), what is permissible is your counsel may assist the prosecution. He cannot replace the prosecutor.
302 ಲಿಗೆ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಇನ್ನೊಂದು ಸೈಟೇಷನ್ಸ್.
Now the effect of the order is prosecutor ಬದಲು ನಿಮ್ಮ advocate ಇರ್ತಾರೆ, ಅದಾಗಲ್ಲ. That is not permissible. He will assist the prosecution.
ಇಲ್ಲ, ಅಸಿಸ್ಟ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ 301 ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ ನಮ್ಮ ಕೌನ್ಸಿಲ್. ಬಿಕಾಸ್ he is the senior PP retired. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಹಾಕಿ.
That is not the issue, whoever he is. Yes, Jagdish sir. ಇದು 498 ಏನಾ?
Not no.
Then
theft and
380.
380.
114 ಇದರಲ್ಲಿ.
You may assist the prosecution ಅಷ್ಟೇ.
ಅಲ್ಲ ಇದು
That's all.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಹಾಕಿದ್ದಾರೆ.
We will not open floodgates like this, nothing.
ಅಲ್ಲಿ ದರಿವಾಲ್ ಇಂಡಸ್ಟ್ರೀಸ್ ಅಲ್ಲಿ ಅದೊಂದು
JK ದರಿವಾಲ್ ಎಲ್ಲ ಆಯ್ತು, ಎಲ್ಲ ಆದ್ರೂನು ಅಷ್ಟೇ. Will permit you to assist, permit the prosecutor to, your counsel to assist the prosecution.
ಈ ಕೇಸಲ್ಲೂ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ ತಾವು.
ಅದು ಯಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಅಂತಿರೋದು, ಅದ್ರಲ್ಲಿ ಇಶ್ಯೂ ಇಸ್ ಡಿಫರೆಂಟ್.
ಕಂಪ್ಲೇಂಟ್ಸ್
ಆತರ ಸಿ, if every complainant is permitted to engage his counsel, prosecutor ಬೇಕಾಗೋದಿಲ್ಲ. That's not the purport of law.
There are so many incriminating circumstances. ಯಾಕಂತಂದ್ರೆ
ಅದು heinous offenses ಅಲ್ಲಿ 302 ಆಲ್ ರೇಪ್ ಅದೆಲ್ಲ ಓಕೆ. ಇದ್ಯಾವ್ದು ಥೆಫ್ಟ್ ಅಲ್ಲಿ?
ಆಕ್ಚುಲಿ ಥೆಫ್ಟ್ ಇದು ಅದು ಸರಿಯಾಗಿ ಸೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಯಾಕಂತಂದ್ರೆ ಇದು 445 ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತಾ ಇತ್ತು, ಆಗ್ಬೇಕಾಗಿತ್ತು, ಆದ್ರೆ ಹಾಕಿಲ್ಲ ಅವರು. ತುಂಬಾ ಕೊಲ್ಯೂಡ್ ಆಗಿ
ಟ್ರಯಲ್ is already on.
ಇದು ಕೊಲ್ಯೂಡ್ ಆಗಿ ನಾನು ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಂಪ್ಲೇಂಟ್.
No, sir. 302(2) will permit assistance, that's all. Yes, sir. That you can't object.
So many
I have no objections for that, my lords.
You can't replace the prosecutors. Yes. That's only in exceptional circumstances.
ಸುಮಾರು 3-4 ಇದು ಸೈಟೇಷನ್ಸ್ ಕೋಟ್ ಮಾಡಿ.
No. We'll list it tomorrow. We'll modify the order. We'll list tomorrow in the fresh matters. Next case.
Number 6.
My lordships, ಇದು ರಿಪೋರ್ಟ್ ತರ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್.
ಯಾರು ಹೇಳಿದ್ದು?
My lord.
Wahida.
Password, I think there was some miscommunication. I've informed them. I'll get it.
Password.
7.
Petitioner in this matter, my lord.
Bakery.
All these cases, accused number 1 already pleaded guilty, my lord. And non-compliance of section 155 subclass 2 of the CRPC. And based on the voluntary statement of accused number 1, this petitioner was implicated in the matter.
ಸುಮಾರಿದೆ, ಮೊನ್ನೆ ಕೆಲವು ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀವಿ. ಇಲ್ಲಿ ಅದು ಕೊಡಿ, ಹಲಿಮಾ ಮೇಡಮ್ ಅಪಿಯರ್ ಆಗಿದ್ರು. I have quashed same petitioner. on the ground that non-compliance with 155.
ಇಲ್ಲಿ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ.
And accused
ಅದೇ
number
permitted. ಅದ್ರಲ್ಲೇನೋ ನೋಡಿದೆ ನಾನು.
And accused number 1 already pleaded guilty, my lord. And based on the voluntary statement of accused number 1, the petitioner was implicated in the case, my lord.
He's pleaded guilty.
Accused number 1.
Yes, SPPR.
ಇದರಲ್ಲಿ we invoked
ಮೇಡಮ್ ಅದು ಹಲಿಮಾ ಮೇಡಮ್ದು ಸೇಮ್ ಪೆಟಿಷನರ್ ಲೀವ್. ಹಲಿಮಾ ಮೇಡಮ್ ಕೇಳಿ ಜಡ್ಮೆಂಟ್ ಯಾವ್ದು ಅಂತ ಕೊಡಿ. ಡಿಸ್ಪೋಸ್ಡ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಅವ್ರು ಕೇಳಿ ಕೊಡ್ತಾರೆ. ಎಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ತೊಗೊಳ್ಳಿ ಮೇಡಮ್, ಅದು ಕಾಪಿ ಕೊಡ್ತಾರೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
lordship same my lord, liberty.
4 cases, my lord.
4 ಇದೆ.
Your lordship same my lord, liberty.
Same grounds, my lord.
Liberty.
ಅದರಲ್ಲೂ ಲಿಬರ್ಟಿನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. 4 cases.
But A1 already pleaded guilty, my lord.
You also do it.
Yes, very continuation of criminal proceeding against the accused number 2 petitioner is.
The whole problem is I would have done it, but ನೀವು ಬೇಕರಿ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ ಅದಕ್ಕೆ.
ನಾನ್ ಬೇಕರಿ ನಡೆಸ್ತಾ ಇರಲಿಲ್ಲ. The allegation is that near Iyengar bakery,
Iyengar bakery,
no, accused number 1 was running the matka.
Matkas.
Yes, yes. That is
ಮುಂದ್ಗಡೆ ಬೇಕರಿ, ಹಿಂದ್ಗಡೆ ಮಟ್ಕ.
That is the case of the prosecution. I am the petitioner is the accused number 2, my lord. Based on the voluntary statement of accused number 1, I have been implicated in the case. Absolutely, there is no
liberty I am giving.
Materials.
Yes. If there is anything liberty, I have always given. Yes, next.
And based on the voluntary statement, my lord, I am relying upon your lordship judgment on this point.
ಪರವಾಗಿಲ್ಲ, ಕ್ವಾಶ್ ಮಾಡಿದ್ದೀನಲ್ಲ ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಯಾವುದು ಇದು 7, 8, 10 and 11.
9 withdrawal.
9 withdrawal, of course.
Till number 11, 12.
Yes, Anish.
3172, my lords.
Last
time, my lord, the learner prosecutor has submitted that the amount has been transferred as cash through account only, my lords.
Yes, SPPR.
Only so
recovery at his instance, my lord, at least in serial number 12. Recovery that its instance.
Recovery is from him, is it?
Yes, ma'am.
What's the amount?
No, the gold chain.
105, my lords. The accused has been arrested. First, my lords, may I kindly see my lord 94.
You are talking of conscious possession.
My lords.
Conscious possession irlilla anta.
No. I was in possession, admitted, my lords. The notice says that. My lords, may I kindly see page number 94. The notice issued to us. The accused was arrested and during interrogation he confessed as to snatching of the gold chain.
Page
94, my lords. It is a notice, my lord, the relevant portion. Middle portion, my lords.
Was arrested during interrogation. He confessed to snatching the gold chain from complainant's neck and falsely claiming to his wife that he needed money. So
Treatment and credited to your branch. Same has been with the 27 statement, page number 105. Relevant portion, my lords. That also comes as a part of the 27 statement. 105, my lords. The middle portion, my lord. After staying home for 2 days.
After staying home for 2 days
without going out, 30/10/2024, he went to Muthoot Finance in Tannisandar, informed them that his wife was unwell and requested money by pawning the gold chain he had. Muthoot Finance agreed to give him rupees 2 lakhs for the chain and they transferred the money to his bank account at Punjab National Bank. My lord, it has been pledged with us stating that it is owned by his wife. Immediately the notice issued, we handed over.
We have issued a notice to him. Provide us CCTV footage of the days of incident. The allegation, my lord, of course, my lord, I don't have any, presently I don't have.
This is your statement. New record matter. Our statement recorded before the police.
The time of the issue, my lord. Subsequently, we learned that accused number 2 and 3, with petition number in 12 and petition number in 14, have colluded to do this kind of activity furtherance. Anyway, of course, that's only a voluntary statement. Therefore, we issued a notice to him to get us CCTV footage of the days of incident to understand what is happening. They don't provide us. Therefore, my lord, that conscious possession, of course, the statement is said, my lord, but they're all in hand in
statement. Allah, statement prakara, he has himself gone and told that it is his wife's. Then what will they do?
No, the chain which was broken, which was refixed and then handed over.
Correct. It is wives ಅಂತ ಹೇಳಿದ್ರೆ why will they?
Alla, but the issue, my lord, that if you had given us the CCTV footages to that day of incident, we could have drawn.
Why, what happened to CCTV footage?
But I'm not aware, my lord. It's been whatever it has been sought, it's been given.
The lordship may
It's
see
the
the
start
notice
sheet
issued,
stage,
he
it's not
received
the
the notice.
investigation stage.
Madam.
ಕೊಡಿ.
That has been. ಇದೆಲ್ಲ ಏನದು? ಇದು
4/11/24. No, in 2024 itself, you come to this page 94. This is what is there already.
Yes, my lords.
Therefore, the accused so and so has pledged the gold chain in the name of your finance. You are hereby instructed to produce the gold chain along with the records of the CCTV footage before me.
But it is seized on the same day.
No, where is CCTV footage, sir?
Well, CCTV
You should have
footage-
given it that day
My lord,
itself.
it's their allegation. Now they have been.
That's all right. You should have given it. There's not cooperation with the investigation.
That is not the case.
That may not be the
Against them.
case, but your notice itself clearly said with the record CCTV footage before me.
My lord,
What's the
same day
hitch
it
in,
has been
what's
handed
the
over.
hitch in giving the footage?
Well, same day it has been handed over. The gold has been seized,
Even
handed over
gold
the
is
same
seized.
day.
What about the CCTV?
My lord, before the, after the charge sheet, my lord, I'm before my lordship, my lords. Two seats,
Sir,
I'm not.
you
but the
forget
allegation
that.
by-
Why you did not give this
But
footage?
whatever it has been asked is been given. Whatever it has been asked is given, including the gold chain, it has been handed over on the same
Gold
day.
chain is handed over, sir.
Well, whatever it has been sought, my lord, whether it is CCTV,
CCTV
whatever it is, it's been
ಇದು
handed over.
1 minute. 4/11/2024 is the notice. Jagdish sir.
Yes, my lord.
Now charge sheet is also filed. This is at the stage of investigation.
No, therefore we have drawn adverse inference. Initially, we never drawn him an accused. He
Huh.
not cooperated this fact, my lord, the accused number one.
What is, now you give the CCTV footage? Yes,
No
Anish.
difficulty, my lords. My lords,
Give it
what
then.
happened is that.
No, you wait, you give the CCTV footage and let them see it. I will take it next week, we'll quash
It
it.
is not that is the case. What happened is
Whatever
that-
be the case.
Well, what happened is, fun for a moment, my lords, I
Yes.
kindly see
Yes.
here, my lord. What happened is that on same day, another accused, the same accused statement has been recorded in a different manner, stating that it has been pledged with us with the knowledge. That is in page number 46 to 47, A1 statement. Then
46?
again, my lords, my blind, they had obtained the signature in the blank papers.
See, I'll tell you, this, if the footage had been given, everything would have been put to
But
rest.
that is not their case.
that
Here
may-
their case is that
Now what-
based on the A1 statement, that is 47 to 46 to
Now we'll
47.
see. When will you give the footage?
But it can be given, my lord. Already
The-
may be handed over. Might
the
have already been
petition-
handed over.
The learned SPP would produce the records with regard to a notice issued on 4/11/2024. The petitioner also relies on the same notice to contend that the person who had sold the gold chain
Not
was,
sold.
what
pledged,
was it?
Pledged.
Pledged the gold chain was his wife's, while it was somebody else's which he had snatched from the complainant's neck. The notice also indicated that the petitioner should give back the gold chain and the CCTV footage of the said day. Gold chain is given back to the prosecution, but the CCTV footage is not. Therefore, the petitioner is drawn as an accused. In the light of the said circumstance, the counsel Anish would submit that he would hand over the CCTV footage. There is no difficulty of handing over the CCTV footage of the said day. The said action be complied with by the next date of hearing. List the matter on 25th in the fresh matters list. The CCTV footage by then be handed over. Once it is handed over, the court would consider the allegations against the petitioner and also and pass appropriate orders.
One more submission, last submission. But I am not been arraigned as an accused because of the reason that the CCTV footage was not
I
handed
said
over.
submission. That's a submission of the state. Yes.
State.
Next.
But I should be handed over to the police or my lord?
Investigating officers.
But now the investigation has been concluded. That is the difficulty.
To the investigating of CCTV footage to the investigating officer who had conducted investigation and filed a final report before the concerned.
Great.
13.
Not the same stage, not fresh matter.
Same stage, yes.
Offense is NDPS Act. NDPS. But there are two FIR, my lord, registered. Based on one cause of action, my lord. First FIR,
Yes,
my lord, so 24/9,
Notice ಆಗಿಲ್ವಾ?
2025, my lord. ಆಗಿದೆ sir.
The learned HCGP is directed to accept notice for the respondent.
Yes, sir, notice.
ಆಗಿಲ್ಲ? ಎಲ್ಲೇನು ತೋರಿಸ್ತಾ ಇಲ್ಲ? ಬರೀ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ಅಂತ ಇದೆ ಅಷ್ಟೇ.
ಸ್ಟೇ ಕೂಡ ಇದೆ.
ಅದು ಮಾಡಿದ್ದೀನಿ, ವಾರಂಟ್ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ.
ಹೌದು ಸರ್.
ಹಾ. Learned, ಇಲ್ಲ, not issue. Learned HCGP is directed to accept notice for the respondent and the learned SPP is directed to appear in the matter. ಒಂದೇ ನಿಮಿಷ ನೋಡ್ಬಿಡ್ತೀನಿ ತಾಳೆ. ಓ ಇದೆ, ಸಾರಿ ಮಾಡಿದೆ.
Copy is not.
ಇದು 9/6
ಕಾಪಿ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ.
ಅಡಿಷನಲ್ SPP ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದೆ. 9/6 ಕರೆಕ್ಟ್ ಅದು? ಹಾಂ ಸರಿ, ಎಸ್. ಕಾಪಿ ಕೊಡಿ. Petitioner to serve set of papers upon the state forthwith. List the matter on
Court matter is
Monday.
tomorrow, my lord.
Huh?
Trial court is for framing of charges tomorrow.
Don't worry, yes. List the matter on Monday in the fresh matters list. The interim order subsisting would continue till the next date of hearing.
14.
ಇದೇನು ಅದೇನಾ? Same day hack, list on 25th.
15.
My lord, in this matter, I pray for a week time, my lord, since there are certain additional documents to be produced, my lord. Next week, any day.
List at the request of the council, interim order there.
Illa, ma'am.
At the request of the council appearing for the petitioner, list on 27th.
Obliged.
Yes, next.
16.
154 Evidence Act.
Kindly pass, sir. I have it in the afternoon, senior result.
I'll take this at 2:30. So no,
ಪಾಸ್ವರ್ಡ್ ಕ್ಯಾನ್ ರಿಕ್ವೆಸ್ಟ್ ಸ್ವಲ್ಪ ಮಧ್ಯಾಹ್ನ ತೊಂದರೆ ಇದೆ.
ಯಾಕೆ ಅಲ್ಲಿದೆಯಾ?
ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿದೆ, ಅಲ್ಲಿ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್.
ನಾಳೆ?
ಕ್ಯಾನ್ ರಿಕ್ವೆಸ್ಟ್
Tomorrow.
Yes, in the afternoon, my lords.
Tomorrow, sir. Yes.
17.
For a week's time for objection.
Interim order ಉಂಟಾ?
Illa, there is a release of the golden ornament.
Gold.
Their objection only for 230 grams. Total 1,900 grams.
ಮಿಕ್ಕಿದ ಗೋಲ್ಡ್ ನಿಮ್ದಲ್ಲ?
ಅಲ್ಲಲ್ಲ, ಬ್ಯಾಂಕ್ ಇದು ಪ್ಲೆಡ್ಜ್ ಆಗಿದ್ದು ಗೋಲ್ಡ್.
They are saying only 213 grams.
Further investigation.
List on 19th in the fresh matters list as a last chance at the request of the council appearing for the respondent. Next.
18.
Petitioner, my lords had directed us to produce documents to show that we have an affiliation with another hospital. I'm placing those documents.
For the same period?
Yes, my lords, for the same periods and a period and for other periods as well, from 2022 to 2026.
Yeah, which
My lords,
hospital you
one
had?
is Shri Matru Hospital, which is of the year 2023.
ಆಮೇಲೆ
2024 ಅಲ್ಲಿ Neo True North
True
Hospital.
North Hospital.
23 is
Kaveri.
Kaveri Hospital. 26
Kaveri.
is again Kaveri.
And never with this hospital.
No. My lords, one
Pivot.
is the learned counsel for the respondent had submitted that every hospital should have every college should have a affiliation with a hospital that has 100 beds. However, their hospital has only 28 beds. That document is at
Which
page
this
24.
Sacred Oak.
Please, Manoj, that's it. That document is at
ಇದೆ
page.
ನಿಮ್ದೇನು ಮಂಜುನಾಥ್?
Lords, perusers page number 2, paragraph 5.
ಹಾ.
ಸದರಿ ಕಾಲೇಜು ದಿನಾಂಕ 25/8/2022ರಂದು 2021-22 ಮತ್ತು 2022-23ನೇ ಸಾಲಿನ ಮುಂದುವರಿಕೆ ಸಂಯೋಜನೆಗೆ ಪಾವತಿಸಿರುವ ಶುಲ್ಕ ರಶೀದಿಯೊಂದಿಗೆ ಅರ್ಜಿಯನ್ನು ವಿಶ್ವವಿದ್ಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿತ್ತು. ಈ ಅರ್ಜಿಯಲ್ಲಿ ಕ್ಲಿನಿಕಲ್ ಅಂಡ್ ಹಾಸ್ಪಿಟಲ್ ಫೆಸಿಲಿಟಿಗಾಗಿ ಸೇಕ್ರೆಡ್ ಓಕ್ ಮಲ್ಟಿ ಸ್ಪೆಷಾಲಿಟಿ ಹಾಸ್ಪಿಟಲ್ ಎಂದು ಅರ್ಜಿಯಲ್ಲಿ ನಮೂದಿಸಿರುತ್ತಾರೆ. Now my lords may kindly peruse the application which is filed, my lord, which is at page number 13. ಇದರಲ್ಲೇ ಇವಾಗ ನಾನು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ page number 13, my lord. Page number 13 is the application which is filed to Rajiv Gandhi University.
Page 13 is a complaint.
ಅಲ್ಲಲ್ಲ ಈಗ ನಾನು ಕೊಟ್ಟಿರೋದು
ಈಗ ಕೊಟ್ರು.
ಈಗ ಕೊಟ್ಟಿರೋದು ಪೇಜ್ ನಂಬರ್ 30. This is the application which is filed by the petitioner college. If my lords peruses page number 24, part 4 ಕೆಳಗಡೆ clinical and hospital facilities, Sacred Oak multi-speciality hospital.
Yes, madam, look into this.
My lords, may kindly look at document number
Is
5.
original ಎಲ್ಲಿ?
Original ಇದೆ.
ಎಲ್ಲಿದೆ? ಕೊಡಿ.
I have the original.
My lords, may kindly look at page, go to page 27
Off.
of the memo of documents that I've just filed. 27. Iva kottira memo alli.
27, yes.
Page 25, sorry.
25, yes.
25. Adralli, number of beds is 28. As per the resolution, every
Where is number of beds?
number of beds, category of establishment.
Yes, number of beds 20. This is available online.
Please, my lords, this is what they have submitted there. We have got it from the online portal itself.
And where
As
is
per
it
the
that it should be 100 bed?
As per the resolution, which is at page 34, last time kottira memo.
Last time memo. Is it original kudi?
Please.
It's here. Page 37, ma'am. Paragraph 17.
Oh, just a moment, just.
Sorry.
Is it original? Certified copy.
True copy which is given by the police.
ನಿಮ್ಗೆ ಎಷ್ಟು ಬೆಡ್ ಇದೆ?
My hospital is 100 bedded hospital.
100 ಬೆಡ್ ಇಲ್ಲ. ಮತ್ತೆ 28 ಅಂತ ಯಾಕೆ ಹಾಕೊಂಡಿದ್ದೀರಾ?
That's paragraph 17, my lords may kindly see. To start a nursing,
ಇವ್ರ ಹತ್ರ ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇದೆಯಾ?
they are next to our college. So on an oral understanding, I used to send students over there.
ಈಗ ಎಷ್ಟು ಬೆಡ್ ಇದೆ ನಿಮ್ದು?
My hospital is 100 bedded hospital.
ಮತ್ತೆ 28 ಅಂತ
Pollution control board ಗೆ just upload ಮಾಡ್ಬೇಕಾದ್ರೆ
I will direct prosecution to be initiated against you. Straight away. Pollution control board ಕೊಡ್ಬೇಕಾದ್ರೆ 28 ಬೆಡ್ ಅಂತ ತೋರಿಸೋದು, 100 ಬೆಡ್ ಹಾಸ್ಪಿಟಲ್ ನಡೆಸೋದು. What is all this? When you have displayed yourself to have a 28 bed hospital.
Initially my lord when the hospital
Initially ಅಲ್ಲ, ಇದು ಯಾವಾಗಿಂದ ಇದು?
The recent one, my lords, this is what the document.
You will face prosecution, sir. I will direct now the state to inspect how many beds you have. And if it is the 28 beds you have, you cannot have an agreement with them at all.
That is not the case at all. That is not the case at all. Lord, if
ಅದಕ್ಕೆ sitting in a glass house, when you throw stones at someone else, you should be careful.
please, if my lords peruse the statement of objections which are filed by the petitioner.
You forget it, sir. Name 28 bed, 100 bed ಹೇಳಿ first.
My hospital is a 100 bedded hospital.
100 bed. Yes, one ನಿಮಿಷ.
My lords may kindly produce this one.
Wait. Where is this you just now showed? 28 bed.
20, Iva kottira memo, document number 5, page 25.
When is it pulled out?
Recent, that in 18th August 2026.
Valid till 18th August 2026. Certificate of registration. Establishment registered. Establishment details. Number
This
of
document
beds.
was issued on 19th August 2021.
Increase ಮಾಡಿದ್ದಕ್ಕೆ ಎಲ್ಲಿದೆ? 28 ಇಂದ 100 ಆಗಿರೋದಕ್ಕೆ ಯಾವಾಗ?
We have the document.
Get the document.
I can produce it, my lord. I can produce it.
The learned counsel for the petitioner, Anaga S. Desai, files a memo along with documents which depicts that the complainant hospital is only 28 bedded. For an MOU to be entered into for the purpose of admission of the college, it should be a 100 bedded hospital. The learned counsel Manjunath for the respondent Manjunath submits that initially it was only 28 bedded hospital. Now it has become 100 bedded hospital. Therefore, the document which permits 28 to become 100 by the competent authorities be placed before the court on the next date, failing which adverse inference would be drawn that the complaint is registered only for settling extraneous course. List this matter on 25th at 4 PM for further hearing. Interim order subsisting will continue till the next date of hearing.
Wait.
19.
Yes, Praveen Gudra.
Truck terminal matter, my lord, sir.
ಗೊತ್ತು ಅದು. ನಾಲ್ಕು ಸರಿ ಕೇಳಿದ್ದೀನಿ.
Before the trial court, he had no objections, my lord.
Allah, no, I never said no
You
objections.
Please touch your heart and I was there.
I said never no objections for it.
Indemnity bond ಗೆ ಒಪ್ಕೊಂಡಿದ್ರು.
ಅಲ್ಲಿ
Because of the stay ಅಂತ ಹೇಳಿ it was not considered.
My lord said, take your lordship to my objections ಅಲ್ಲಿ. Paragraph 5 I have clearly mentioned. Now the court asked whether the amount, to whom this amount belongs. It's a scheduled commercial bank. The transaction is only with respect to any basic amenities, has to be the recharging, they don't have transaction of lending or receiving. So this is what it is. Now, there's a money trail on the document quoting where the amount which was been for the contractors, 3 major contractors, the amount was been transferred to an extent of 33 crores. They, in fact, 11 crores has been transferred to 9 shell companies. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಅವ್ರೆಲ್ಲಾ ತಗೊಂಡೋಗಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಈ ಫಿನೋ ಬ್ಯಾಂಕ್ ಗೆ ಅಮೌಂಟ್ ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಪಂಜಾಬ್ ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ ಗೆ. ಈ ಪಂಜಾಬ್ ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ ಅವ್ರು ಈಸ್ಕೊಳಕ್ಕೂ ಬರೋದಿಲ್ಲ. ಈ ಫಿನೋ ಬ್ಯಾಂಕ್ ಡಸಂಟ್ ಹ್ಯಾವ್ ಎನಿ ರೈಟ್ ಟು ರಿಸೀವ್ ದಟ್ ಅಮೌಂಟ್. From whom it has to be received? It has to be received from their agents, not from the third parties. Agents should have been deposited the fund. For what purpose? If I have charged any Airtel bill or postpaid electricity bill ಬಂದಿರೋ ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು. ಅದು ಬಿಟ್ಬಿಟ್ಟು ಇವ್ರು ಯಾರೋ ತಗೊಂಬಂದ್ ಬ್ಯಾಂಕ್ ನನ್ನ ಅಕೌಂಟ್ ಹಾಕೋದು ಅಂತ ಹಾಕಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಇವನು ಕೈಯಿಂದ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ತೆಗೆದು ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಇಟ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ ಅವಾಲ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ದ ಅಮೌಂಟ್ ವಾಟ್ ಹಸ್ ಬೀನ್ ಡೆಪಾಸಿಟೆಡ್ ಇನ್ ದ ಬ್ಯಾಂಕ್ ಇಸ್ ದ ಟ್ರಕ್ ಟರ್ಮಿನಲ್ ಅಕೌಂಟ್ ಅಮೌಂಟ್. The amount which the third party agent has paid is his own amount, what has been paid to them.
We'll see. Heard reserved.
They have already made the merchant as a witness, my lord. Witness statement has also been produced.
Yes. Next.
20.
Here for the petitioner, my lord.
My
lord, criminal trespass.
Huh?
Criminal trespass, page number, CLD is there, page number 16.
Oh, ಏನೀಗ? ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
Stay there.
A submission. On the last date of hearing, they have taken the interim order by
Suppressing.
misleading the court.
ಸರಿ ಹೇಳಿ ಸರ್.
The interim order may be looked into. It
Yes,
says
sir.
that there are 8 to 9 crimes registered by the wife against the husband, upon which the stay was granted. The very petition
ಇದೇನ
discloses.
ಹೇಳಿದ್ ನೀವು?
Yes, my lord.
ಹಸ್ಬೆಂಡ್ ನ ಕಾಪಾಡಬೇಕು ಅಂತ.
Yes, my lord.
ಸರಿ.
They have filed the objection. They have showed 14. I have showed only 9. They have showed 14. Page number
14
5.
cases.
They have filed 500 pages objection.
ಎಲ್ಲಿದೆ?
We have filed vacating of stay.
ಅಲ್ಲ ಎಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಎಲ್ಲಿದೆ?
We have filed yesterday in the counter, my lords. But before that, at page 7, my lords, their very petition.
ಅದು ಕೊಡಿ, ಇಲ್ಲಿ ಏನ್ ಹಾಕಿದಾರೆ ನೋಡೋಣ.
ನಾನು just 9 ಕೊಟ್ಟಿದ್ದಾರೆ, 14 ಮಾಡಿದ್ದಾರೆ.
Those are cases, not crimes. There is difference between case and crime.
All right. ಅವರು ಕೇಸ್ ಹೇಳಿದ್ದು, ಕ್ರೈಮ್ಸ್ ಹೇಳಿ.
ಅಲ್ಲ, ರೆಕಾರ್ಡ್ ಆಗಿರೋದು ಕ್ರೈಮ್ಸ್ ಅಂತ.
ನನ್ ತಪ್ಪಿರ್ಬೇಕು.
My lords, no. The very submissions on that day was crimes were registered. On that ground, stay was
Criminal appeal.
Criminal trespass will not attract because since I have got the same deed.
ಯಾವ್ದು ಇದು 14 ಕ್ರೈಮ್ ಇದು ಪೇಜ್ 5 ಅಲ್ಲಿ ಇರೋದು?
14 all the cases
14
between
cases
husband and
of
wife.
course.
Between husband and wife.
My lords, initially.
ಇದು ಎಷ್ಟನೇದು ಇದು? ಇದು 14th?
This becomes the 15th one.
15th.
It is not only filed by the wife. It is.
No,
between husband and wife.
Between both of you.
Between both of them.
Oh, now what's the problem, sir?
My lords, in the year 2022, 23, they had accepted to mutually get divorced. They told that they would pay 60,000 amount and give the house in which he has criminally trespassed. So thereupon he
ಅದು ಯಾರ್ದು ಮನೆ?
It is in the ownership of the petitioner.
Correct. All right. Ownership of the petitioner. You are staying there.
Yes, my lords.
ಅವ್ರು ಬರಬಾರ್ದು ಅವ್ರ ಮನೆಗೆ?
He is not staying there.
That's all right.
Yes, my lords. The problem is whenever he comes
I am
over
not
there.
staying there. She is not allowing me to go there.
ಒಂದು ನಿಮಿಷ ತಾಳಿ.
My lords,
Now you allow him to submit.
Whenever he comes over there, there is assault which is done. That is the problem. The FIR which is registered is not only again for trespass, it is also for assault. If the MLC record, which is in the vacating of stay, it may be looked into. There is MLC record which discloses that it was assault by the husband on the wife. So for trespass, even if it goes, for assault it remains.
Oh, so trespass hoitu.
Trespass, my lords, again in trespass, it is not always ownership, it is possession.
Correct, possession. It's
Easy.
not, but right to enter a premises,
Yes,
which is owned by him, you can't stop.
true, my lords.
All right?
But my lords, it is a continuous assault which is done. Whenever he enters the house, a 14-year-old child is there along with me. Now, whenever he enters the house, he always makes sure that he assaults the wife, he fights with the wife, he abuses the wife. So that is what has been
ಅದಕ್ಕೆ ಏನು 1152
1152, my lords.
ಆಮೇಲೆ
Non-cognizable, my lord.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ.
Non-cognizable.
It is non-cognizable ಅಷ್ಟೇ, not recognizable ಅಲ್ಲ.
If my lords permit, the investigation can continue for 1152.
I will not, sir.
My
I
lords,
will not permit investigation even for a day in this.
My lords, the
It by
MLC
section 155 clause.
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ sir.
My lords, that apart, he has filed a counter case. Under 200, he has filed a counter case. A PCR is pending. My lords, when case and counter case is pending, the one cannot go when the other is pending.
No problem, sir. ಅದನ್ನು ತಗೊಂಬನ್ನಿ, ಅದನ್ನು ಮುಗಿಸ್ಬೋಣ.
My lords, till now, the order has not been passed under 156(3). It is still at the nascent stage.
Yes.
My lords, for a moment, the MLC record may be looked into. There is scraping of the nail which has been occurred.
What name?
My lords,
What?
there is scraping of the nail, evolution of
Nail.
the. Yes, my lords.
Fine.
So there is assault with, there is a specific case. When there is a specific case, my lords have held.
Scraping
many
of the
times.
nail.
Yes, my lords.
ಅದನ್ನ ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
My lords, it is the very contention in that PCR is that he was there. It is not a case that he had not entered the house. When there is an admission on his part that he has
So he has
the
entered the house ಅಂದ್ಮೇಲೆ scraping of the nail is deemed to have committed by him.
My lords, when there is an allegation, it is to be investigated, my lords. Not at this stage where the court can enter into
Absolutely.
the inquiry of
Yes,
the
sir.
materials, my lords.
Anything else, sir?
My lords, that apart.
Enough, sir. Stop.
ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಿ ಹಸ್ಬೆಂಡ್ ಈ 14 ಕೇಸ್ಗೆ ಸ್ಟ್ರೆಸ್ ತಾಳಲಾರ್ದೆ ಕುಸ್ ಬಿದ್ದೋಗ್ತಾರೆ. ಅಲ್ಲಿರೋ ಪೊಲೀಸರನ್ನೇ ಕರ್ಕೊಂಡೋಗಿ ಜೈದವಾಗ ಸೇರಿಸ್ತಾರೆ. ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಗಿದೆ. ಇದು ಸಿಚುಯೇಷನ್ ಹಸ್ಬೆಂಡ್ 14 ಕೇಸ್ ಹಾಕಿದ್ರೆ ಗಂಡ ಹೆಂಡತಿ ಮೇಲೆ ಹೇಗ ಆಗ್ಬೇಡ ಒಬ್ಬ ಗಂಡನಿಗೆ.
ಈಗ ಆಗಿದೆಯಲ್ಲ.
ಆಯ್ತು, ಲೈಟ್ ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಯ್ತು, ಸ್ಟಂಟ್ ಆಗ್ಬೇಕಂತ ಹೇಳಿದ್ದಾರೆ.
What stopped?
Stent.
ನೀವು ಸ್ಟಂಟ್ ಅನ್ಬೇಡಿ. Yes.
What stopped him from honoring the mutual consent divorce, my lords?
ಅದಕ್ಕೆ ಇದೆಲ್ಲನಾ?
It is not for that reason. Now this lady does not have a job. She does not earn anything. Now she has to take care of the 14-year-old child as well.
ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಮೇಂಟೆನೆನ್ಸ್ 30,000 ಕೊಡ್ತಾ ಇದೀರಿ.
40,000, my lords.
40,000 ಇರೋದನ್ನ 30,000 ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿಲ್ಲ, ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ತಾನೆ?
My lords, these cases are not cases which have been filed frivolously.
ಈಗ if you stop filing frivolous cases, I will entertain this. If you again start filing frivolous cases against each other, I will view it seriously and pass orders.
The list may be looked into. There are
Nothing.
There are only 4 cases, main 4 cases. The other cases are the offshoot cases. Appeal, then to the High Court. Those are the offshoot cases.
That is not the thing.
No, my lords.
1152 ಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಡೆಸಬೇಕಾ ಈಗ?
Yes, my lords. It is an allegation.
Correct, sir.
And it is the MLC record.
Whose nail is it ಅಂತಾನೆ ಬೇಕಾಗಿರೋದು. ಮತ್ತೆ
if the husband is allowed to do all this,
husband is allowed, where is he allowed to do all this?
My lords, this is what is happening.
This is the problem. If both of you live in harmony, nothing is going to happen. If both of you settle the dispute in harmony, nothing is going to happen. If you're going to go on like this, cases after cases, this is what is going to happen.
My lords, in the mutual divorce, even I had agreed to do, but he did not honor. He comes back from
mutual divorce ಯಾಕೆ ಒಪ್ಪಿಲ್ಲ?
It was done by the same advocate. Earlier advocate.
ಯಾಕೆ ಅವ್ರ ಮೇಲೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಇದೆಯಾ?
ಇಲ್ಲ, ಅವರೆಲ್ಲ ಇನ್ನೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ರು. He is the advocate for the same person.
ಆಯ್ತು, ಅದೇ ಸ್ಟಾಯಿಕಲಿ ಸೈಲೆಂಟ್ ಇದ್ರಲ್ಲ ಅವರು, ಎಲ್ಲೇ ಇದಾರೆ ಬಿಡಿ.
It is because he suppressed the fact, that advocate, so he was not able to go about.
Now will you settle everything now?
My lord, every time I am ready, but the thing is my wife is not willing. She is asking arbitrary amount. ಒಂದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಬಂದು 2 ಕೋಟಿ 3 ಕೋಟಿ ಇದೆ, ಅದನ್ನ ಕೊಟ್ಬಿಡು, 1 ಕೋಟಿ ಕ್ಯಾಶ್ ಕೊಡು, ಹೆಂಡತಿ ಮಗ ಎಲ್ಲ ಬಿಟ್ಟು ನಾನು ಎಲ್ಲ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ ಗಂಡಾಗಿ.
Wait, you sit across, I will give a date.
ಸೆಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೆಡಿಯೇಷನ್ ಮಾಡಿದ್ರೆ ಆಗ್ತಾ ಇಲ್ಲ.
ನೀವು ಸ್ವಲ್ಪ ಕೇಳಿದ್ರೆ ಸುಮ್ಮನೆ ಆಪ್ಟಿಕ್ಸ್ ಸಾಕು ಇವತ್ತಿಗೆ. So this I'll post it on next Thursday, by Thursday or Friday. By then,
That still is in hospital.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದು ಆಚೆ ಬರ್ಬೋದು.
Yes, madam.
ತೊಂದ್ರೆ ಇಲ್ಲ. 27th I will post it. Settle the dispute with both of you. If you don't settle it, we'll pass orders. Yes.
Recent judgment is also there, my lord.
No problem.
Nehalal versus Abhishek Kumar,
That-
2026 SEC on bail.
Good.
40 cases between
Judgment
husband
I
and
know, sir. Yes, list the matter on 27th. In view of plethora of cases between the husband and the wife, this court is of the opinion that the parties to the list should sit across and settle the dispute between them, lest further cases be filed against each other. In the event there would be no settlement, appropriate orders would be passed on the merit of the matter. Interim order subsisting would continue till the next date of hearing. Yes, next.
Much obliged. my lord.
Same station.
Same stage.
376 promise to marry, my lords. The petitioner is accused number 2. Allegations is to accused number 1 that he has promised to marry the.
Respondent ಇದಾರಲ್ಲ? ಇಲ್ಲ. First time ಬರ್ತಾ ಇದೆಯಾ?
ಇಲ್ಲ. Notice was issued.
Undertakes to enter appearance. Yes, sir. What's the duration? 376, 406, 420.
I am the accused number 2, my lords.
Who are you?
I'm accused number 2.
Adeu, father?
No, my lords.
Then?
I was friend of accused number 1. Accused number 1 sent me.
1 minute. Did you shoot that video?
No, my lords.
What's the allegation?
Allegation is that, my lords, accused number 1 and complainant, they met through.
That's all right. ನಿಮ್ದೇನಿದೆ role, sir?
ನಾನೇನಿಲ್ಲ. I went to meet the respondent number 2 in the court premises to buy some time to return the money, my lords, that was owed by the accused number 1 to the respondent number 2. Adashte allegation. I went and I sought time for 1 week accommodation for him to give the money to respondent number 2, the complainant. That is in page number 20, my lords, if I may read.
The petitioner is accused number 2. The second respondent is the complainant. The complainant and the accused number 1 are said to have had a relationship. Therefore, the offense on the pretext of marriage and its breach has led the registration of the crime and filing of the charge sheet for the offences punishable under section 376 inter alia. Insofar as the petitioner is concerned, the summary of the charge sheet would read as follows, page 57. If this be the role of the petitioner, there cannot be a better illustration of abuse of the process of the law, albeit prima facie. There is no representation on behalf of the complainant who had undertaken to enter appearance on the last occasion. Therefore, there shall be an interim order of stay of further proceedings only against the petitioner accused number 2.
Split up again.
Huh?
There is split up order.
In split up order.
Charge sheet. The proclamation was issued against the petitioner.
Why you did not appear?
My lord, notice was never served to me.
ಇದು ಕೊಡಿ, split up number.
Charge sheet has been not filed, my lord. Only
So,
order.
further investigation ಅಂತ ಮಾಡಿ. Yes. Further investigation against the petitioner. ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ, ಕೋಟ್ ಮಾಡಿದ್ಮೇಲೆ. This is the finding in the summary of the charge sheet. The learned counsel for the petitioner submits that the case has been split up against the petitioner for his non-appearance before the concerned court. In the light of the said circumstance, all investigation and the proclamation shall remain state till the next date. Nimdala sir, previous matter.
22.
Petitioner is accused number 7.
No.
No corroborative evidence against.
The petitioner is before the court calling in question the proceedings in CC 109 of 2024 for offences punishable under idralide. The learned counsel heard sounds. The learned counsel for the petitioner will project a solitary circumstance that the petitioner is drawn into the web of proceedings on the voluntary statement of
Accused number 1 to 4.
accused number 1 to 4, and he is now drawn as accused number 7. This court had directed the learned HCGP to secure instructions with regard to any corroborative material against the petitioner for his role in the episode of crime, or he had been drawn into the web of proceedings only on only on the voluntary statement of others. The offences are the ones punishable under the Karnataka Prevention of Slaughter and Preservation of Cattle Ordinance Act, and the offence was the one punishable under Section 379 of the IPC, along with the provisions of the said act. In the light of the said statement that there is no corroborative material against the petitioner, further proceedings against the petitioner accused number 7 cannot be permitted to be continued. In the light of the settled principle of law, the judgment ಕೊಡ್ತಾರೆ. Allowed question. Yes, next.
Great, Your Lordship. Much obliged.
23.
Madam, for the petition is of under section 138 of an act.
What's the ground, sir?
Without taking any sworn statement of cognizance, the trial court directly issues the summons to the accused, the petitioner here.
One, the learned counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings. Further proceedings shall remain stayed till the next date, list the matter on 24th in the fresh matters list. Next.
24.
That's accused number 1 and 4, my lords, are the petitioners. That's registration.
Stay there.
Illa. That's my
Post
only-
immediately after service of notice upon the second respondent.
That's my only request, my lords. Accused number 1 is, my lords, a bona fide purchaser from, my lords, the father of CW4. He, my lords, files this complaint immediately after his father's death.
We'll see, yes.
Please.
5.
25 and 25.1, my lords. The petitioners have approached us for no objection, my lords. They'll be collecting the no objection on Saturday, my lords. I pray for
All right,
time.
less the interim order there.
Interim order, my lords.
Less the matter after 2 weeks, yes.
Grateful, my lords.
26.
Filing the wakalat for respondent, my lordship. First time to filing the objection, my lordship.
ಏನು offense? Interim order there.
Yes, my lordship.
Interim
The
order.
learned counsel so and so undertakes to enter appearance for the respondent, registered to print the name of so and so as appearing for the respondent. List after 2 weeks, IO. Next.
Grateful. 27.
Appearing for the petitioner.
ವಕಾಲತ್ on behalf of the respondent number 2, my lord. Since the-
Notice ಆಗಿದೆಯಾ? Notice ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
No, my lord.
ಮತ್ತೆ ಸುಮ್ನೆ ಇರಿ. Yes.
My lord,
ಇದೊಂದು ಬರ್ದಿಡ್ಬೇಕು caveat provision ಇಲ್ಲ.
offense taken place at Ooty, Tamil
ಹಾ,
Nadu.
ಇದು ನೆನ್ನೆದು. ಹಾ, ಎಸ್ ಸರ್.
They have done then 0 FIR.
ನೆನ್ನೆ ಏನ್ ಮಾಡಿದೆ? 2:30 ಮೂವ್ ಮಾಡಿದ್ದು.
ಇಲ್ಲ, ನಿನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ರೆಗ್ಯುಲರ್
ಹ್ಮ್.
ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತು. ಇದು ಜೂರಿಡಿಕ್ಷನ್ ಆರ್ ನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ FIR ಹಾಕಿ
ಇದು
arrest ಮಾಡಿದ್ದಾರೆ.
64 ರೇಪ್. ಕೊಡಿ ಪೇಪರ್ಸ್. ಅಲ್ಲ, ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಏನು ಆರ್ ನಗರ?
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ 10/7/2026.
ಹ್ಮ್.
ಅಫೆನ್ಸ್ ಆಗಿರೋದು ಊಟಿ ತಮಿಳುನಾಡಲ್ಲಿ. ಅದ್ರ ಮೇಲೆ ನಾನು ಬೇಲ್ಗೆ ಹಾಕೊಂಡಿದ್ದೀನಿ, ಅಲ್ಲಿ ಕೂಡ ಜೂರಿಡಿಕ್ಷನ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇಲ್ಲಿವರೆಗೂ ಬೇಲೆ ಆಗಿಲ್ಲ.
No, no, initiated, she was taken from Bangalore. So offense continued to happen from Bangalore to all the way to.
ನೀವು ಬೇಲ್ ಅಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲಿ
FIR ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು ಎಲ್ಲಿ?
ಆರ್ ನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
ಮತ್ತೆ
ಸೆಷನ್
ನೀವು ಬೇಲ್ ಊಟಿಲಿ ಹಾಕಿದ್ರೆ?
ಅಲ್ಲ, ಇಲ್ಲೇ ಹಾಕಿರೋದು. ಇದೇ CCS 54
ನೀವು ಒಫೆನ್ಸ್ ಆಗಿರೋದು ಊಟಿಲಿ ಏನ್ಬಿಟ್ಟು ಎಲ್ಲ ಊಟಿಲೇ ಮಾಡ.
ಅಲ್ಲ ಸರ್, ಇಲ್ಲಿ CCS 54 ಅಲ್ಲಿ ಅದೇ ಜೂರಿಡಿಕ್ಷನ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇವತ್ತವರೆಗೂ ನನಗೆ ಆರ್ಡರ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ.
ಇಲ್ಲಿ
ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ CCS 54.
We have filed our, I'll ask my officer to go and give representation.
ಡೋಂಟ್ ರೈಸ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್.
Will not raise that.
ಅಷ್ಟೇ.
I'll ask my
ಅಲ್ಲಿ ಬೇಲ್ ತಗೊಳ್ಳಿ. ಸ್ಟೇ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಈ ಕೇಸಲ್ಲಿ.
ಕ್ಲಾರಿಫಿಕೇಶನ್.
The petitioner is before the court calling in question the registration of a crime in crime number 211 of 2026, registered for offense punishable under 64, 351 and 350 of the BNS, which is for rape inter alia. The learned counsel for the petitioner submits that the incident has taken place in Ooty when the complainant and the petitioner had traveled to Ooty. The traveled to Ooty. The counsel would further submit that the concerned court is not considering the application for bail on the jurisdictional issue. The learned SPP would submit that they would not raise the question of jurisdiction, as the complainant is a resident of Bangalore and had traveled with the petitioner from Bangalore to Ooty. And Ooty, in the light of the said submission, the learned withdraw ಮಾಡ್ತೀರಾ ಇದು? In the light of the said submission, The learned counsel seeks a leave of this court to withdraw the petition and pursue the remedy for bail and approach this court in the event of need in future. Reserving such liberty, the petition stands disposed.
28.
For the petitioner is accused number 9, my lord. Earlier, my lord, 1962, the father of the petitioner was allotted the land for a 1 acre, my lord, in survey number 37.
It 13 ಇದೆ ಇದರಲ್ಲಿ.
13 is, but not applicable to.
ಅಲ್ಲ, not applicable to you.
Yes, my lord. And after that, my lord, among 6 members, my lord, one was the allotted.
The petitioner to serve complete set of papers upon Latif B, representing the Lokayukta, with Lokayukta list the matter on Tuesday in the fresh matters list.
Among them, my lord, one matter is already stayed, my lord.
ಯಾರ್ದು?
Either crime number 4.
Attack the petition along with so and so.
Crime number 3 ಅಲ್ಲೂ ಆಗಿದೆ, 4 ಅಲ್ಲೂ ಆಗಿದೆ, sir.
Attack this petition along with so and so in the light of ಬೇಡ ಬೇರೆ ಆಮೇಲೆ 13 ನವರು ಸ್ಟೇ ಕೇಳ್ತಾರೆ. Tuesday will grant. Yes.
We are the beneficiary only.
Tag 1 ನಿಮಿಷ. Tag the matter list on Tuesday.
Publish.
29.
Petitioner, my lord, 498A, 109, my lord.
ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ ನಾನು. How do you appear?
ಏನು ಹೇಳಿದ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ಆಗ್ಲೇ.
ಯಾಕೆ ಹಾಕಿದೆ? ನೋಟಿಸ್ ಮಾಡಿದ್ಮೇಲೆ ತಾನೇ ಹಾಕ್ಬೇಕು. ಕೇವೇಟ್ ತರ ಆಗ್ತಾ ಇರಲಿಲ್ಲ ಎಲ್ಲರೂ. There is no concept of caveat in 482. ಮತ್ತೆ
Petitioner 5 and 6 is student, my lord.
ಏನಿದು? ಯಾರ್ಯಾರು?
5 and 6. Both are students.
Accused 2 and 3. 498 ಏನಾ?
498.
109 ಇದೆ sir.
109. PCR is filed.
95 is also there.
PCR is filed on basis of PCR.
5 and 6 ಏನ್ ಮಾಡಿದ್ದಾರೆ?
5 and 6 is the general allegation only.
20 years. 15 ವರ್ಷದವ್ರು ಇವ್ರನ್ನೂ ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು. A basis of private complaint is registered.
1 HCGP to emergent notice there shall be an interim order of stay in so far as accused number 6, 7, 8 and 9. Insofar as the others, the same would be considered after the appearance of the respondent complainant. ವಕಾಲತ್ ಹಾಕಿ. The registry to print the name of so and so who is said to have entered appearance even before the issuance of notice.
1 and 2
It is accepted with costs of rupees 5,000. ಇನ್ಮೇಲೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ ಎಲ್ಲದಕ್ಕೂ ಬಂದ್ರೆ. Yes.
30.
Not cost.
ಇರ್ಲಿ 10,000 ಮಾಡ್ಲಾ? Yes.
But after my retirement, the other directors have issued the check. I am neither
The
the
number
drawer.
30.
Please,
Yes, sir.
neither the drawer of the check nor the signatory of the check.
When did you retire, sir?
Lord, I request my lordship to kindly turn to page 52. I retired on 28th October 2020. The check is dated 28/12/2020.
Retired as what, sir?
Past directors, my lord. I left the
Partner.
company. I left the company. I was one of the directors. I left the company.
Direct.
Please.
The petitioner is the erstwhile director of what company?
Navayug Synergy.
Navayug
Energy Solutions.
Navayug Energy Solutions. He is drawn as accused number 6. He is said to have retired as resigned as a director from the company on
28 October 2020.
28/12.
28
October 2020. The check is said to be issued in the month of December 2020 after the retirement of the petitioner. In that light, there shall be an interim order of stay qua the petitioner till the next date of hearing.
Please.
Emergent notice to the respondent. Next.
Appear for petitioner, my lord.
Kindly pass over, my lordship.
On the previous hearing,
Senior will come, kindly pass over, my lordship.
311 application was challenged.
I pass over.
My lord had
Interim order
indicated
ಇದೆಯಲ್ಲ?
to direct on an order, dictation for order. That was an indication on the previous hearing, posted for 2:30.
We'll
That
do it.
Want of time, it was not
Pass over. ಸಾಯಂಕಾಲ ಮಾಡ್ತೀನಿ.
grateful.
32.
Similar complaint in the same, virtually the same complaint.
Charge frame ಆಗಿದೆಯಾ?
Charges frame, ಇಲ್ಲ, frame ಆಗಿಲ್ಲ. Charges frame. Similar complaint is stayed, by your lordships.
ಇದನ್ನು ಮಾಡ್ಬೇಕು ಅಂತೇನು?
It was a rent, actually a rent dispute
Right dispute.
Rent. She
Rent.
did not pay rent. In the legal notice, she threatened that if rent is not paid, I'll file a case against you. That was noted.
Dance class,
Dance class.
Huh?
Dance class. Dance class ಗೆ rent ಕೊಟ್ಟಿದ್ದು.
Idu dance class.
Same complainant, same accused.
Why is the complainant making you dance?
Rent ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾವು we are struggling.
ಎರಡು ಕಂಪ್ಲೇಂಟ್.
ಎರಡು ಕಂಪ್ಲೇಂಟ್. ಅದು ಆಗಸ್ಟ್ ನಲ್ಲಿ ಒಂದು, ಅಕ್ಟೋಬರ್ ನಲ್ಲಿ ಒಂದು.
ಎವ್ರಿ ಮಂತ್ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಒಂದೊಂದು ಕಂಪ್ಲೇಂಟ್.
Same allegations virtually.
Check this. Rent ಇದೆಯಾ? ರೆಂಟಾ ಬೇರೆ ಏನಾರು ಇದೆಯಾ? At the learned senior counsel Vivek Subbareddy appearing for the petitioner. Tag along with so and so, same order, please.
33.
Kindly pass over the matter.
Why, sir?
I've engaged Ravi Shankar sir in this matter.
He is working as an RRT. May I request, may I place some documents not for Lordship Peruzza. Person was born in 1941. The land was granted to her in 1943. That's a record built, my lord. The person residing in Aralamalike, Dodbalapur Taluk. Land is granted in Kengeri Obli. And interestingly, my lord, the land was acquired for BDA development. BDA itself writes a letter in the year 2023 asking him to conduct a survey because the land, this particular survey number also belongs to government land. This person doesn't do anything and keeps it aside.
ಆಯ್ತು, ನಾಳೆ ತಗೊಂಡು ಇದು ನೋಡ್ಬಿಟ್ಟು ನಾಳೆ ತಗೊಂಡು.
Yes.
This also.
ಅದು
And he is also accused in Arogya Swami's other case.
ಇದು
No, I'm being a public servant, my lord.
ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಅಕ್ಯೂಸ್ ಆಗಬಾರ್ದು ಅಂತಿದ್ಯಾ?
No role in this matter at all.
ಅದು ನೋಡೋಣ. ಇಲ್ಲ ರೆಗ್ಯುಲರ್ ಬಟ್ ಬರುತ್ತೆ.
34.
Petitioners for in this matter, my lords. Petitioner is the sole accused, my lords, challenging the charge sheet. Charge sheet is filed for the offences 354A and 354B. In fact,
34A, 34B?
354A and 354B. Petitioner and respondent number 2, my lords, these facts are not stated in the petition. In fact, they both were in a relationship for.
Why did you not state that in the petition?
Because the, my lords, the allegation in the.
ಆಮೇಲೆ ಕನ್ಫರ್ಮ್ ಆಗ್ಬಿಡುತ್ತೆ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತ.
ಇಲ್ಲ.
ಮತ್ತೆ?
There was a breakup between them. Due to the reason, my lords, the girl had a previous relationship with the boy. They had a breakup and so she was with the petitioner.
Photo delete ಯಾಕೆ ಮಾಡಿಲ್ಲ?
My lords?
Come to page 28.
My lords, there is no photos record. That is what I wanted to show, my lords. Page number 33.
ಮುಗಿಸಿಕೊಂಡು ಆರೋಪಿ ಆಫೀಸ್ ಹೋಗಿ ಮೊಬೈಲ್ ನಲ್ಲಿ ನನ್ನ ಫೋಟೋಗಳನ್ನು ಡಿಲೀಟ್ ಮಾಡು ಎಂದು.
Page 33 is the master. It is clearly stated, my lords.
ಎಲ್ಲಿ 33 FSL ಕಳಿಸಿದಾರಾ?
ಹೌದು, my lords.
ಏನಿದೆ?
34, if my lords may kindly see, in the third paragraph. ನಂತರ ಆರೋಪಿಯು ಮೊಬೈಲ್ ಫೋನ್ ಹಾಜರುಪಡಿಸಿದ್ದು ಪರಿಶೀಲಿಸಲಾಗಿ ರೆಡ್ಮಿ ಕಂಪನಿಯ ಮೊಬೈಲ್ ಫೋನ್ ಆಗಿದ್ದು ಆರೋಪಿಗೆ ಅದರ IMI ನಂಬರ್ ಕೇಳಲಾಗಿ ಈತನು ಸೋ ಅಂಡ್ ಸೋ ಎಂದು ಡಿಸ್ಪ್ಲೇ ಆಯಿತು. ಸಿಮ್ ಬಗ್ಗೆ ಕೇಳಲಾಗಿ ಯಾವುದೇ ಸಿಮ್ ಇರುವುದಿಲ್ಲ. ಗ್ಯಾಲರಿಯನ್ನು ಚೆಕ್ ಮಾಡಲಾಗಿ ಇದರಲ್ಲಿ ಸುಮಾರು ಫೋಟೋಗಳಿದ್ದು ಫಿರ್ಯಾದಿಯ ಸಂಬಂಧಿಸಿದ ಯಾವುದೇ ಸೋ ಅಂಡ್ ಸೋ ಫೋಟೋಗಳು ಯಾವುದು ಇರುವುದಿಲ್ಲ.
Yes.
There's no photos. It is just a
dispute
among them.
The petitioner is before the court calling in question registration of proceedings in so and so for offense punishable under section 354A and B. The allegation is that several pictures of the complainant were found in the phone of the petitioner at the time when they did have certain relationship between the two. The learned counsel for the petitioner takes this court through the report of the FSL which indicates that not a single picture of the complainant is there in the said phone. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Please, sir.
1 HCJP, 2 emergent.
The petitioners are charge sheeted for the offence of punishable under section 115, 118, 138, 351. The allegation in the present complaint and the background of the matrimonial dispute arose between the complainant and petitioner family. The complainant.
Yes, sir.
Is none other than the.
None other than.
The petitioner wife, sister, husband, my lordship. Initially, the complaint filed by the mother of the petition number 1, which is in page number 50, my lordship. Mother of the petitioner one
Come
against
to
the
page 32, sir. Wound certificate.
wound certificate are simple in nature, my lordship.
As-
The petitioner
yes.
one is an advocate.
Anything else? Sir?
Allah, in this case, my lordship, there is a matrimonial issue. The petitioner, the wife has lodged the complaint against the mother and sister of the petitioner, which is in page number. The afterthought, the present
First
complaint.
petitioner go nimgo ಏನ್ ಸಂಬಂಧ?
The first petitioner, the sister, first petitioner, wife, sister, husband, complaint, my lordship.
Which is your case?
My case is page number 50, my lordship.
ಅದೇನಾಗಿದೆ?
Still is still is consideration for investigation, my lordship, pending for investigation. And mother of the first petitioner filed the complaint against the petitioner, first petitioner, wife, mother and sister, my lordship. Only thing that they have objected. There is a matrimonial issue, my lordship. He got married. The petitioner number one got married.
One HCGP to emergent notice returnable by 27th, list on 27th.
And my lordship is that petitioner number one being an advocate. There is a
There shall-
matrimonial issue among
There
the
shall
two
be an
family
interim
members.
order of stay only insofar as the accused number 1 is concerned. Next.
The others are there no role attributed by
ಆಮೇಲೆ
others, my
ನೋಡೋಣ,
lordship,
yes.
because
ಇದರ ಅವ್ರಿಗೂ ಬೇಡ ಬರ್ಲಿ.
Release-
27th, yes.
release
List on
on petition number 1 release on.
27th, yes.
ಅಲ್ಲ petition number 1 stay ಅದ continue
ಬೇಡ.
ಆಗಲಿ. ಅಲ್ಲ petition number 1 continue ಆಗಲಿ sir. I am
ಅಲ್ಲ
not
ಅವ್ರ
pressing.
ಅವ್ರದೇ ರೋಲ್ ಇರೋದು ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಅದರ್ದು they are no role ಅಂತ ಹೇಳಿದ್ದು ಸ್ವಾಮಿ.
ಅಂದ್ರೆ ಇವ್ರದ್ದು ಇದೆ ಅಂತ ಅರ್ಥ.
ಅಲ್ಲ ಇವ್ರದ್ದು ಇಲ್ಲ ಅವ್ರದ್ದು ಇಲ್ಲ.
ಇವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ರಿ ಇನ್ನು ಅವ್ರಿಗೆ ಕೊಡಕ್ಕೆ.
ಇಲ್ಲ sir. Petition number 1 it is practicing advocate is come in the way of investigation, come in the way of his practicing, my lord.
ಅದು 1 ಮಾತ್ರ ಇರಲಿ. ಎಸ್.
36.
ಇದು ಡ್ಯಾನ್ಸ್ ಕ್ಲಾಸಾ?
ಇಲ್ಲ ಇಲ್ಲ. ಇದು abetment to suicide, brother is robbed in blood and uncle. And
Uncle.
brother ಮೇಲೆ allegation page 45, page 45. About para 17, gist of the case. ಅಲ್ಲದೆ ಆರೋಪಿ 2, somewhere in the middle of the second param. ಅಲ್ಲದೆ ಆರೋಪಿ 2
2 and 3 ಇದಾರೆ ಇಲ್ಲಿ. What is the relationship between deceased and you?
Deceased brother-in-law. Brother-in-law.
Yes, madam, ನೋಡಿದಿರಾ? ಏನಿಲ್ವಾ?
Simple injuries is there.
Simply-
assault is there, my lordship. As per charge sheet, my lordship, allegations are there against this petitioner. Wound certificate showing.
Wound ಬಿಡಿ madam, it's dead now.
The allegation is, blood, shall I read that? Blood?
ಆರೋಪಿ 2 ಮಂಜುನಾಥ ತಾಯಿಗೆ ಸ್ಟ್ರೋಕ್ ಆಗಿದೆ, ಅವರನ್ನು ನೋಡ್ಕೋ. ಇಲ್ಲವಾದರೆ
Yes, this is the allegation.
ಹೆಂಡತಿ
ಇಲ್ಲವಾದರೆ ನನ್ನ ಹೆಂಡತಿ ನನ್ನನ್ನು ಬಿಟ್ಟು ಹೋಗಿದ್ದಾಳೆ, ಅದರಂತೆ ನೀನು ಸಹ ಹೋಗು. ಇಲ್ಲ ನಮ್ಮ ತೋಟಕ್ಕೆ ತಂದ್ರೆ ಔಷಧಿಗಳನ್ನು ಕುಡಿ.
A3 ಯಾರು?
A3 is uncle. ಅಸಭ್ಯವಾಗಿ ವರ್ತನೆ ಮಾಡಿದ್ರು ಹಿಂದೆ ಅಂತ.
ಹಿಂದೆ.
Last 3 lines ಇರುವಾಗ ಮೃತಳು ಆರೋಪಿ 1 ಮತ್ತು 2.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. The allegation against the petitioners as found in the summary of the charge sheet is as follows. The allegation is abetment to the ingredients. The allegation is abetment to suicide. A perusal at the allegations ingredients found in the summary of the charge sheet cannot become the ingredients as necessary for abetment to suicide as obtaining in section 45 of the BNS for it to become the offense under section 108 permitting further proceedings against this petitioner. These petitioners on the aforesaid score would run foul of the judgment of the apex court in the case of Yadavinder Singh Yadav, 2025 SSC online, SC page 2332. In that light, there shall be an entry modest.
Please. Public.
Yes, Nishit.
Application for relaxation of bail condition rejected, my lord. He needs to travel abroad, my lord. Matrimonial dispute between the petitioner and the complainant, my lord.
Application ಅಲ್ಲಿ.
Application, my lord.
Travel abroad ಗೆ itinerary ಕೊಡಿ.
Itinerary ಕೊಟ್ಟಿದ್ದೀನಿ, but that is lapsed now, my lord.
ಎಲ್ಲ ಕೊಡಿ ಈಗ. Affidavit ಹಾಕಿ ಒಂದು, I'll permit you. List Monday ಹಾಕ್ಲಾ? Monday 27th in the fresh matters list. Yes.
38.
Pay for the petitioner. That's 40 is also connected with this.
ಏನ್ ಸುಮ್ಮನೆ ಇದು?
That's NDPS matter.
ಆಯ್ತು 40 also.
40 also.
ಆಯ್ತು ಕೊಡಿ. Yes, sir.
My lords, may I request your lordship to take up serial number 40 first, my lord?
41st.
Please, my lord.
41 ನಿಮ್ದ?
ಇಲ್ಲ 40, 38 and 40. my lord.
40th matter first.
Correct.
Take 41st ಅಂದ್ರೆ?
Sorry, my lord.
Yes.
Petitioner, my lords, is a resident of Delhi, my lords.
Sake of?
Resident of Delhi, my lords. My lords, a crime gets registered against him 92/2026 for NDPS offences, my lords. My lords, the recovery is from accused number 1, 3 and 8, my lords. My lords, now after further investigation, my lords, there are around 21 accused in this case, my lords. Around 32 kgs of MDMA has been recovered from other accused. My lords, I am only on legal ground, my lords. My contention is that, my lords, I was not produced before the magistrate in 24 hours, my lords. In this case, my lords.
That's the ground?
That's the ground, my lords.
Right.
My lords,
Then we will hear the SPP on this, if that's the only ground.
my lords, may I request your lordship to kindly come to page 237, my lords, for a moment, my lords.
237.
237.
One moment. Yes, sir.
Lords, I'm sorry, 232, my lords. Para 4, my lords. My lords, this is the application for transit warrant filed by the respondent, my lords. Before the Delhi court, my lords. Para
A21 yaru? You are appearing for A21 also?
I am appearing for A6, my lords, only for A6. My lords, there is no recovery from this person, my lords. It is only based on his confession statement, my lords.
Recovery is from only Nigerians?
Nigerians, from all the foreign nationals, my lords. My lords, there is recovery from accused number 193, my lords. They are resident of Delhi, my lords. But there is no recovery from accused number 6, my lords. It is only based on confession statement, my lords. He's been roped in this crime, my lords. My lords, para 4, my lords, the officers and...
ಎಷ್ಟು 36 kg MDMA na?
But the recovery is from others, my lords.
ಆಯ್ತು ನೋಡೋಣ.
My lords, para 4, my lords.
But you are only on arrest ಅಲ್ವಾ ಈಗ?
Only on arrest, my lords.
Para 4.
Para 4 of page 232, my lords.
Yes, sir.
My lords, the officers and staffs are deputed on 14/5/2026 to trace accused, namely Dheeraj, son of late Ashok Sharma. The police team apprehended the accused number 6 from Dakshinapuri, Ambedkar Nagar, South Delhi on 14/5/2026 at 11 AM. After interrogation, it disclosed that the accused was involved in the said crime. Hence, arrest was made at 7:30. My lords, he was apprehended and arrested at 11 o'clock, my lords. And the order of the magistrate, my lords, is at page
Produced before the magistrate when?
Next day, 7 o'clock, my lords. There's an 8-hour delay in producing, my lords.
Where was he produced?
My lords, before the court of judicial magistrate for
Delhi.
South Delhi Circuit Court, my lords. My lords, the order of the magistrate is that, my lords, 2:37, my lords. My lords, the order was passed at 7:15 PM, my lords. My lords, there's a delay of 8 hours in producing him before the magistrate, my lords.
ಆಮೇಲೆ transit
After that, the
transit warrant.
And then he was produced before the magistrate in Bangalore on 19, my lords.
19/5/2026.
26, my lords. My lords, that's my only contention, my lords, that he was not produced before the magistrate in 24 hours.
Yes, sir.
Now, our contention, my lord, he was arrested at...
Only at 7:30.
That's correct. And the magistrate order, my lord, doesn't say that if that is the case.
My lords, it is in their application, they say that he was apprehended at 11 o'clock, my lords.
Arrested, your lordship is at page 239 is the order, typed copy of the order. He doesn't say that he was arrested before. Arrested at 7:30.
7:30 is the arrest, 7 o'clock is the production, next day. Correct again.
Apprehended at 11 o'clock, my lords. Apprehended, my lords, there is no difference between apprehend and arrest, my lords.
That will
He
have
was,
to
my
see.
lords, the personal liberty is curtailed at 11 o'clock in the morning, my lords, and thereafter he was produced before the magistrate 7 o'clock.
You are drawn as accused number 6, is it?
Accused number 6, my lords.
What is the connection with accused number 1 and others?
My lords, there is no connection, my lords. It is only on confession statement, my lords. My lords, may kindly have page, my lords.
Yes, look at
investigation. He is the...
My lords, page 86, my lords.
Used as a mule to transport.
My lords, para 3, my lords. Page 86, para 3, my lords. My lords, Prakarana, the A4 ROP, Danfa Gerald.
That's the only ground, right?
My lords, that's the only allegation, my lords. It is only based on confession statement, my lords. I've been roped.
Yes, SPP ನೋಡಿ ಅದು. Both 39 and 41.
41 is a body warrant has been taken.
My lords,
39 ಅಲ್ಲೇನು?
38 and 40, my lords.
38 ಅಲ್ಲೇನು?
My lords, 38, my lords, while he was in judicial custody, my lords, on this crime, my lords, another crime which was already registered, my lords, this petitioner, my lords, was roped in as accused number 4 in that case. My lords, my contention is that, my lords, it is covered by the judgment of the Honorable Supreme Court, my lords. My lords, in a subsequent crime, my lords, the procedure of arrest has to be followed, my lords. Because, my lords, I have the right to apply for anticipatory bail, my lords. If the arrest is not followed, my lords, the arrest in that case is vitiated, my lords.
We'll see. Answer both. Yes. List on 19th, fresh matters.
Grateful.
Learned SPP is directed to appear in the matter. Next.
39.
Additional minutes. Challenge to the FIR, my lords, on the reference of a private complaint. She is the accused number 2. Landowner, my lords, had given her land in a JDA to accused number 1. So A1 enters into an agreement of sale with the complainant on 10/6/21. I am not a party there. I have not received any money either. Thereafter, subsequently, my lords, on 25/10/21, again accused number 1 sells the property to accused number 3. Even there, I am not a party, not the beneficiary, nor a recipient of any money as such.
The meantime. Yes, next.
41.
Under section 85, my lordship. Petitioners as the father-in-law and mother-in-law of the complaint, my lordships.
Meantime.
42.
Yes, next.
Interim.
85.
85. Father-in-law and mother-in-law.
Move, sir. Yes.
42.
Yes, Santosh.
They are invoking, my lord, the section 31R, 31S and 324A.
11. ಅದು ಬಿಡಿ 118 ಇದೆ.
Other 118 is there, my lord. But the entire incident, my lord, is being typed by this complaint, my lord. We went for asking for the money which was given for securing job, my lord. Then this complaint is lodged, invoking the SC/ST provisions.
Atrocities will stay.
Yes, my lord.
The other offenses.
Other provisions also, my lord, because I am seeking for anticipatory bail.
That ಅದಿದ್ರೆ ಸಿಗಲ್ಲ, ಬೇರೆ ಎಲ್ಲ ಸಿಗುತ್ತೆ. The heard the learned counsel appearing for the petition 1 HCGP to emergent notice. There shall be an interim order of stay insofar as the offences under the Atrocities Act and the offence under section 1181 of the BNS till the next date of hearing.
Please, great.
43.
The petition in this case. Let's challenge the FIR minutes. The verbal
ನಿಮ್ಗೇನು ಹೇಳಿ ಸರ್.
verbal altercation, my lords, exaggerated complaint, my lords, after 3 days of the incident. That's there is no previous acquaintance, my lords. Despite that, SC/ST Act has been implicated, and thereafter, my lords,
ಎಲ್ಲದರಲ್ಲೂ 1181 ಕಾಮನ್ ಆಗ್ಬಿಡು.
Entire incident is recorded in a CC camera, my lords, near the temple.
In the meantime, yes.
44.
The allegation is that, my lord, accused number 1 and the complainant was in a low relationship.
Love relationship. ಬೇರೆ ಏನಿದೆ?
When the accused number 1 asked for the marriage, she refused. For that, she filed a false complaint.
Promised to marry?
By the girl.
By the?
Girl. Even till today, they are.
She did not marry you. You want to marry her?
Yes. In the complaint itself, she states that.
Kahani mein twist.
In the complaint itself, she states that.
Who is the complainant, sir?
Girl.
ಏನಂತ?
In the complaint, my lords. Kindly come to page number 32. Typed copy.
You are stalking her, ಅದಕ್ಕೆ.
ಮದುವೆ ಆಡು ಅಂತ ಕೇಳಿದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್.
ಮದುವೆ ಆಗೋ ಅಂತ ಕೇಳಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. You are stalking her.
Even the accused number 2 to 10 days.
2 to 10 we will stay, but 1 will see.
We are ready to marry her.
Who is 2
to 10 are the relatives. Relatives in this friends.
Ready to marry ಯಾರು ಅಂತ?
Petitioner number 1.
She should be ready ಅಲ್ಲ?
ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಪ್ಕೊಂತಾರೆ. ಪರಸ್ಪರ ಪ್ರೀತಿಸುತ್ತಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ. Page number 32.
Yes.
ನಾನು ಮತ್ತು ನಮ್ಮ
The case at hand arises out of a 0 FIR registered in 6 of 2026. The case projects a twist. Here, the complainant is not alleging the offense of deceitful means as obtaining under section 69, but the accused number 1 is now forcing the complainant to marry. Therefore, the complainant has alleged the accused number 1 of stalking and other offenses against him. Not stopping at that, the members of the family and the parents are all roped in under the dragnet of crime.
Parents are not there.
Parents alva? Yaru ಮತ್ತೆ ಇವರು?
Friends, neighbors and friends.
Neighbors and?
Neighbors and friends.
Neighbors and acquaintances of accused number 1 are also drawn into the dragnet of crime. Therefore, the number of accused are 10. Therefore, there shall be, in that light, in the light of the aforesaid, there shall be an interim order of stay, qua accused number 2 to 10. Insofar as the first petitioner is concerned, it would be considered on the next date of hearing. 1 HCGP 2 emergent notice returnable by 28th. Yes.
45.
The order is, my lords, permitting the prosecution to produce documents through complainant.
242 to.
242
Ah.
my lord. My lords, I'll place the charge
ಏನ್
sheet.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಂದೇ ಇರ್ಬೇಕು.
They're already part and parcel of charge sheet, my lords. I'm placing the charge sheet annexures and also the document which he wanted to produce.
Madam, 138 ಆ?
ಇಲ್ಲ,
ಇಲ್ಲ, ಇವ್ರ ತಾನೆ. Learned HCGP is directed to accept notice, go through the papers and make submissions. Monday fresh, Tuesday fresh.
Tomorrow is the matter listed before trial court, my lords.
For what, sir?
For trial, my lords, trial is going in. Documents are already marked. That's why
Further
I sought-
proceedings before the concerned court shall remain stayed till the next date. Just on 19th ಅಂತ ಮಾಡಿ.
Please.
19th fresh matters. Learned HCGP Wahida MM. Yes.
46.
Yes, sir.
Batch of petitions, ma'am.
Yes, sir.
Relating to offense under, my lords, section 55 of the Biological Diversity Act 2002.
Biodiversity Act.
Biodiversity Act 2002, which was amended, my lords, in 2024.
Yes.
Now, before amendment, section 55, my lords, there are two kinds of penalties. I will read section 55. Whoever contravenes or attempts to contravene, abates the contravention of the provisions of section 3 or section 4 or section 6 shall be punished with imprisonment for term.
Shall we take this at 2:30 and finish it? Yes.
Please, go straight.
Pass over.
47.
Yes.
We filed the petition for 482 Millard regarding the
Petition for
reinvestigation, Millard.
482. Yes, sir.
Complainant is seeking further investigation, Millard. That's what my kindly say. Mother is the.
What's the offense, sir?
302 ಆಗ್ಬೇಕಾಗಿತ್ತು.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸರ್?
ಈಗ ನಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ 270 304 ಹಾಕಿದ್ದಾರೆ.
ಓ ಇದು ಆಕ್ಸಿಡೆಂಟ್.
ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲ, ಅದು ಅಸಾಲ್ಟೆಡ್ ಅಂಡ್ ಕಮಿಟೆಡ್ ದಿ ಮರ್ಡರ್.
ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಈಗ?
270 304 ಡೆಡ್ ಪರ್ಸನ್ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
Yes, comment.
Yes, Millards. The investigation was not properly conducted, Millards.
We'll see, we'll see.
It is properly conducted, Millards. Millards, initially, Millards, a crime of 19/2025, Millards was registered and the charge sheet was filed, Millards, at page 24. Millards, the allegations, Millards, is that, Millards, the accused number 1, Millards, is the deceased. He was also one of the charge sheet witness. Millards, A2, Millards, is the owner of the offending vehicle. Millards, he has no driving license, insurance to the vehicle. He allowed the Millards accused number 2 to drive the vehicle. Millards, on the date of incident, Millards, A2 was driving A1 was driving the license. A1 is the deceased. Millards, even A1 also, Millards, he was not having driving license to drive the vehicle. Millards, he overturned and fell down on the Millards on the road. And immediately, Millards, he was admitted to the hospital on 19/2/2025.
ನೀವ್ ಯಾರು?
Complainant.
You are the complainant.
Yes. Mother of the deceased.
ನಾವು ನಿಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಈಗ.
ಹೌದು.
Because you let your son use the vehicle?
ಅಲ್ಲ, ಡಿಸೀಸ್ಡ್ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ 304A ಅಂತ. You kindly see the complaint ಮೇಲೆ page number 22, last 2 lines. You kindly see. Annexure B, so.
ದಿನಾಂಕ 22/25 ಮಧ್ಯಾಹ್ನ HCT
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಎಲ್ಲಿದೆ? ಅರ್ಲಿಯರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
last occasion directed the other side, my lord, to get the
ಕೊಡಿ.
regarding the motive aspect, my lord, they are not regarding the statement
Yes,
of
give
one
it.
Mutturaju,
Yes.
my lord, and
Kodi,
also
kodi.
not
Who is the motive?
collected.
Who is the motive? My lord,
investigation
there is no
paper.
motive
Wait,
at all.
sir. Kodi.
As per the FSL
Na-
report,
nale
my lord, there is no alcohol or anything.
List tomorrow. Yes.
My lord, 3 times, my lord, she has lodged a complaint against the same offence. All the 3 complaints were considered and finally a charge sheet was filed
ಆಯ್ತು.
for the offence punishable under section 279, 307.
Next.
48.
Another Q under challenge, my lord. The order, impugned order passed on memo, page 168, my lordship.
ಎಲ್ಲಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಸರ್, ಬಂದಿಲ್ಲ ಅವರು. ಸರ್ವ್ ಮಾಡಿದ್ವಿ. ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್. ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ರಿ?
You lost 2 months back only. As per the direction of this lordship, notice has been served to the trial court advocate.
ಏನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತಾ ಇದೆಯಾ?
Yes, ನಡೀತಾ ಇದೆ. On the suit for seeking of delivery of possession and for declaring.
Who are you?
So I am the plaintiff, lordship. I filed the suit.
Huh?
I am the plaintiff. The suit has been filed by me for cancellation of alleged sale executed by the defendant, number 1.
What is the order that I have passed?
Yes, Lord. Page 168 may kindly be seen. 168. The impugned order, annexure Q passed on memo. Now, what has happened, Lord? This lordship.
168.
Yes.
ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಯಾಕಾಗಿದೆ ಇಲ್ಲಿ? ನನ್ನ ಆರ್ಡರ್ ಯಾವ್ದು?
Yes, Lord. In the earlier writ petition, this lordship has given direction to the trial court to dispose the matter within a period of 6 months. For the reason, Lord, same is placed before this lordship only.
ನಟರಾಜ್ ಸಾಹೇಬ್ರದ್ದು ಯಾವ್ದು ಇದಿಲ್ಲ, ಅದೇನು?
ಅದ್ರಲ್ಲಿ ಮೆಮೋ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಮೆಮೋ ಹಾಕ್ಬೋದು ಅಂತ ಹೇಳಿ. So what has happened after giving direction by this lordship, one of the defendant filed.
ಮಧುಸೂದನ್ ರಾವ್ ಅವ್ರ ಮೇಲೆ ಸರ್ವ್ ಮಾಡಿ. ನೀವು ಯಾರ್ಯಾರಿಗೂ ಸರ್ವ್ ಮಾಡಿದ್ರೆ?
ಇಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಕಂಟೆಸ್ಟೆಂಟ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
ಅರ್ಲಿಯರ್ ನಲ್ಲಿ ಇಲ್ಲೂ ಯಾರು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಸರ್. ಡೈರೆಕ್ಷನ್ ಮಾತ್ರ ತಾವೇ ಕೊಟ್ರಿ ಟು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್. Because the plaintiff is a senior citizen, is a heart patient, is aged about 82 years. For the reason, this lordship has disposed the matter even without issuing the notice.
ಸೇಮ್ ಪೆಟಿಷನರ್.
Same petition. For the reason.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನೀಗ?
ಪ್ರಾಬ್ಲಮ್ ಏನು ಅಂತಂದ್ರೆ, ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟ ಮೇಲೆ ಒನ್ ಆಫ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಫೈಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸೇಯಿಂಗ್ ದಟ್ this court has no pecuniary jurisdiction. With that, regarding the pecuniary jurisdiction already decided in the page 86 may kindly be seen. The additional issues.
Where is that order passed now?
Yes, early page 86. In the same, in respect of same issues, the already order came to be passed saying that not the court having pecuniary jurisdiction to try the matters. Page 86 may kindly be seen.
Anyway, ಈಗ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಏನು ಉಪಯೋಗ ಆಗುತ್ತೆ?
ಏನು ಆಗಲ್ಲ, ನಾನೇ ಹಾಕೊಂಡಿರೋದು ಮತ್ತೆ already unnecessary delay ಆಗುತ್ತೆ. So ಈಗ where the case is pending, that court have a pecuniary jurisdiction to establish that I am produced the subsequent gazette notification issued by the government of Karnataka, page 80, page my lord.
But they ಅವರು ಅಪಿಯರ್ ಆದ್ರೆ ಒಳ್ಳೇದಲ್ವೇ?
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಅವ್ರು ಎಲ್ಲಿ ನಡೆದ್ರು ಅವ್ರಿಗೆ ರೆಡಿ ಇದ್ದಾರೆ, ತೊಂದರೆ. One of the defendant to drag the proceedings, such a written statement can be filed without application of judicial remand. The earlier order has been passed.
Day after tomorrow, fresh matters. Yes, next.
49.
It's appearing for the petitioners, Lordship. Lordship were to hear on the
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ, ಏನಿದು?
Lordship.
ಓ 5,000.
5,000. Yes,
Yes, sir. ಏನ್ ಬೇಕಾ?
I need to make any.
I will, Lordship may hear the matter on merits.
Will hear it.
Yes, my lords.
ಈಗಲ್ಲ. ಏನ್ ಸ್ಟೇ ಇದೆಯಲ್ಲ, ರಿಟೇಲ್ ಆರ್ಡರ್.
I just have to make one.
5,000 ಕೊಟ್ಟಿದ್ದೀನಿ, ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇನ್ನೇನ್ ಬೇಕು?
My lords, that is not.
List after 2 weeks, entry order subsisting will continue till the next date of hearing.
Date. Yes. Any date?
ಬೇಡ, ಬರ್ಲಿ.
50.
Your Honor, I am appearing for the petitioner company in this matter. This is regarding claiming immunity from the prosecution.
Please, my lord. And your lordship, on the last occasion, had directed me to go through the provision. Lords, the proposition which I propounded on the last date, that, my lords, it may not
come to the aid of the petitioner insofar as criminal prosecution is concerned may not be entirely right. Not that would be only insofar as the corporate debtor. Now, your lordship may kindly see.
One submission, my lord. I am representing the corporate debtor only. The corporate debtor is accused number 1. Earlier it was known by Aradhya's team.
Moratorium.
Moratorium aitu, resolution plan approve aitu. Now for the past offences have been prosecuted.
My submission may benefit him, my lordship.
32A prakar agalwala, sir.
Please, my lords, there are 3 conditions. That is what my lords have wanted.
Yes, sir.
Notes the first suggestion which the petitioner made, that he would have to produce materials before the discharge court. Milords I may have to concede to that owing to this reason. Though, milords, there is bar under Prafulla Kumar Samal. Milords, the condition under 32A of the IBC. The lordship may kindly see 32A of the IBC. Milords, provides 3 preconditions. 1, milords, is that the resolution plan has to be approved. 2, milords, that the people who are part of the resolution plan, the new management in the corporate debtor, should be neither aided or related or anyway concerned to the old management. And 3, milords, the new management's takeover should be approved and they will have to take charge. Milords, these things can be better considered by the discharge court.
No, sir. I will myself
Please,
clear
in that
everything.
Please, in that case, milords, I'll have to file objections to these milords documents which he has produced.
The learned
Your lordship has asked me to.
Mohan Raj.
No, milords. Mohan Raj is on the constitutionality of 32A. Milords, that your lordship was pleased to ask me the interplay between the criminal prosecution and the 32A. Milords, that the Honorable Apex Court was pleased to consider in Ajay Kumar.
Kodu yavadu? Paragraph.
Relevant paras are milords 69, 70 and 84. Considering, Manish, how the criminal prosecution would interplay insofar as corporate debtor is concerned,
I will
and
see.
how it
File your
not-
objections if you want. List the matter on 24th. Objections, if any, by then interim protection granted earlier stands extended to the next date of hearing.
Much of.
Grateful.
P1.
P1 is a CBI matter where bank would not have jurisdiction to file the complaint, my lords. And this would stand covered by the.
This is MI Arun.
MI Arun judgment. Prashant Hegde's case. Along with that, the declaration of fraud has been set aside by the coordinate bench. That my lords will notice.
Coordinate bench, just MI Arun order.
Well, I know in judgment too. Here, this is a case of loan default to the tune of 56 crores. So declaration of fraud now has been set aside at Annexure G, my lords, at page 223.
Please, milords, your lordship on the earlier occasion was pleased to dismiss the petitioner's.
Idralla. RC stage, FIR stage. Now this is after charge sheet.
Ground is the same. The ground is that per se on banking circular, Lord CBI would not get the jurisdiction to investigate offences.
The change of circumstances
That
and
is-
judgments, my lords.
That is rejected by me.
That was rejected, my lords, in the case of very petitioner. Therefore, my lords, issue estoppel would govern the petitioner.
There are 2 judgments subsequent to that order. One of my
Supreme
lords.
Court?
No, one of my lords in the case of Valmiki's case. To say under 35A, that is exact in the petition itself. Under 35A of the Banking Regulation Act, CBI would not have powers, my lords, to entertain.
Bank cannot
complaints,
seek.
please.
The Union Bank of India's case, I have said, bank cannot seek.
Bank cannot.
See, in the coordinate bench
But the
relying on
circular,
that would state
circular
that
is there, sir.
unless there's an amendment made to the Delhi
I don't
Special
know
Police
how,
Establishment Act under section 6, the same cannot be done, my lords.
No, sir.
Coordinate bench
based
has
on
not
record.
considered the judgment of your lordship. Therefore, my lords, in the
extracted. It's
teeth
clearly
of.
No, even otherwise, RBI circular have a statutory force.
Please.
In terms of the RBI circular, whichever loan has default, loan default goes beyond 50 crores, automatically goes to the CBI.
That is not
The
in
teeth
doubt.
of that circular, how can an order be passed?
My lords, because that judgment states that specifically unless an amendment is brought to the Delhi Special Police.
Which judgment?
That Prashant Hegde, which are placed on record. my lords, in
No,
last
sir. There is no question of section 6 interpretation into this at all. DSP Act is a separate circumstance altogether.
Please, that is what was stated in the judgment.
CBI
And that has been challenged in the Supreme Court. CBI has challenged it, bank has challenged it. There's no state till date, my lords. Along with that, petitioner was
No, no,
declared
sir.
as a fraud, my lords. Now that declaration of fraud has
No,
been,
declaration of fraud is a different
has
thing
been set
altogether,
aside.
but
And the principal
this
amount has
submission
been
saying
placed.
they are not under the act, but it automatically goes to the CBI in terms of the circular. And RBI circular, Supreme Court, I think I've considered that also.
Lords, in the case of very same petitioner, my lords, the judgment is by associate number.
What is this now?
The fair stage,
No,
RT
this,
stage.
this
is after
happened.
charge
No,
sheet.
that's a different thing. This has become final.
Your lordship judgment is final, my lords. It has not been.
That was not challenged in the Supreme Court, my lords.
It
We
is-
waited
it is
for
final.
charge sheet to be filed.
See, guidelines for reporting frauds to police. Straight away, I've extracted at page 203. Irrespective of the involvement of the public servant, if it is beyond 50 crores, it straight away goes to the CBI. That's the master circular.
I'll place the.
And the effect of master circular also I have considered in the same judgment. How is this? ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
It's ex parte order was passed.
Ex parte order ಇದು?
ಹೌದು.
ಯಾವ್ದು coordinate bench ದು?
ಅಲ್ಲ ಅಲ್ಲ ಇದ್ರ.
My lords, so they were not parties to it. That was in a writ, my lords.
Without
At
hearing the
223
CBI,
case.
how did the interpretation about CBI come in, sir?
No, that was not on the crime, my lords. That is
Then?
only on declaration of fraud. Only the bank was involved in that, my lords. Lords, when kindly notice page 223. It was between.
Everything about the CBI is spoken without making, CBI ಮಾಡಿದಾರಲ್ಲ sir.
Not on the fraud, we were not.
ನೀವೇ ಇದ್ದೀರಾ?
ಅಲ್ಲ, Prashant B. Agdale, we were party.
ಮತ್ತೆ what did you do?
Please, my lords, we placed all the judgments. The coordinate bench was of the opinion on a different, what your lordship has just fell from your lords in the case of my lords Valmiki scam. That, my lords, the coordinate bench, his lordship was pleased to interpret to the manner that the word spoken was to the extent of even throwing away the CBI, despite we bringing it to the attention that the FIR registered by CBI was upheld by my lord. That is also quoted in Valmiki. Therefore, my lord, per se in that
Valmiki is on a different footing, sir.
And Prashant Hegde, my lords, all these
Don't try
contentions
to
were
obfuscate the issue. And when it comes before other benches,
That's two other judgments.
your two other
Uttar Pradesh
judgments.
and Delhi High Court, I'll place it on record, my lords. When
ಎಸ್
lords
ಪಿ
may-
ಪಿ ಅವರೇ ತಗೊಳ್ಳಿದು ಎಲ್ಲಿದೆ ಅವ್ರು ಕೊಡಿ ಅಲ್ಲ ಡಿ ಎಸ್ ಪಿ ಆಕ್ಟ್ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ಸರ್?
That is
What is
was
the
stated,
relation?
my lords. Same contentions which he is canvassing
Hmm.
was also canvassed before the coordinate
No,
bench.
is it not that the same submission was made and I have rejected it? And that rejection has become final.
I was not a part
You
of
go,
the,
you are not a party.
no, my lords, in the first writ,
First,
my lords,
first
I was
petitioner ನೀವೇ ಅಲ್ವಾ associated lumbars?
a different
Then?
appearing.
Ah.
I just go through the
Change in counsel
submissions made in
cannot
that.
bring in
Sir,
change in
what is
law,
this?
my lord.
Change in council, change in bench, some other submission is made without bringing it to the notice of this court.
Allah,
This
Allah.
has become final. Same submissions I have answered.
Because the
And
coordinate
the
bench,
coordinate bench holds against the CBI interpreting DSP Act, which is not even necessary here.
that is to say,
RBI circulars are there or not ಅಷ್ಟೇನೆ. 35A ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ sir?
my lords, that is to say, the bank cannot directly go
Now
to the
this
CBI
has,
and file
what
a
have you
complaint.
done with this, that order?
Lords, we have
It
challenged.
has a sweeping effect on all your actions.
They've
Yeah,
challenged,
One.
challenged
Supreme
it.
Court, but now there's no interim order. Bank is challenged, CBI is challenged, there's no interim order.
Against quashment, my lords, generally they do not give interim orders. My lords, it is admitted that my learned friend is.
All right.
My lords, I'll place the other judgments also on
I
record.
will see.
This, my lords, I may have to answer this, my lords.
Heard reserved, yes.
Lords, other judgments of Madhya Pradesh and Delhi.
ಕೊಡಿ
my
ಎಲ್ಲ
lords,
ಕೊಟ್ಬಿಡಿ.
I'll place it on record.
ಕೊಡಿ.
At 2:30, can I place
Please
it?
do
my
it,
lords?
yes.
Please.
52.
Encroachment into forest land and
Anyway, want to take coursive ಅಂತ ಹೇಳಿದ್ವಿ. 2 weeks.
Sorry, my lord, for petitioner, my lord.
Entry ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ? Yes.
Interim order not to.
ಇದೆ coursive ಸಾಕು. Yes. ಆ ಫೈಲಲ್ಲೇ ಇಟ್ಬಿಡಿ ಮೇಡಮ್.
Lords, it's a case for monitoring of investigation. Last date of your lordships, on the last date of hearing, your lordships are pleased to ask for instructions report.
What investigation, sir?
The petitioners were victims of a sexual assault in terms of the POCSO, your lordships. There was a mob violence
Oh, correct, yes.
because the victims complained about certain land grabbers ಅವ್ರು ಬಂದು ಮನೇಲಿ ಬಂದು they have
ಇವ್ರಿಗೆ
committed sexual
ದೀಪ್ತಿ
assault.
ಆಳ್ವಾಗೆ ಡೈರೆಕ್ಟೆಡ್.
Yes, Your Lordship.
Literally that the allegation is that though minor exists, POCSO has not been invoked and EIR has been done against the minor. In the complaint itself, my lord,
Also FIR.
the complaint itself do not say that she is a minor and the minor has been adulterated. Therefore, my lord, it is not a lapse of investigation or agency that they have not invoked these sections.
Will
And-
direct reinvestigation.
Investigation pending is it, not investigation. not
Then
been completed.
continue ಮಾಡಿ.
We will include that.
Continue ಮಾಡಿ, place it before the court. We'll see what is to be roped in.
Section 7 and 11, sexual harassment.
Two, we'll see. The learned SPP submits that the matter is still at the stage of investigation. What offences would come in or what would be deleted is a matter when the final report would be filed. He would submit that the final report would be filed looking into the averments made in the petition as well. Therefore, list this matter. On the 2 months bitakla? List this matter on in the September end one date.
Lordships, if I make on submission, couple of hearings before this, Your Lordships specifically asked them as to why POCSO was not invoked because there was
ಇನ್ನು investigation ಇದೆ, wait. List this matter on October the 1st for further hearing at 4 PM.
Lordships, the connected matter where the minor is also made an accused in the FIR, that Your Lordships on that ground alone, please to
ಈಗ
stay the
stay
proceedings.
ಮಾಡಿದ್ದೀನಲ್ಲ.
Stay ಮಾಡಿದ್ದೀರಿ.
ಅದು
That's as per
same,
your
both-
own
both same.
authoritative pronouncement
Yes,
on
sir,
Raghavendra case.
Both. Yes, next.
That may be, stay may be extended.
Interim order subsisting will continue to the next date of hearing. Yes.
Great.
54.
Entire arrears is deposited.
Entire arrears ಕೊಟ್ಟಿದ್ದೀರಾ?
Deposited.
Deposited?
26 months it is
Deposited.
deposited, my lord.
7th
Another 3
August
months
it
is there, my lord. That has to be deposited.
Here, my lord, the issue is.
26 months deposit ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ.
ತಗೊಳ್ಳಿ ಅವರು.
Highly, my lord, the appeal is pending before the.
What appeal, what?
Appeal under the Domestic Violence Act.
No problem.
That, my lord, the interim order was passed in the initial stage where order of the Domestic Violence Court, my lord, is challenged with the appeal. Where, my lord, it stayed initially. Then, my lord, they come and file an application for seeking direction to deposit the amount. Then, my lord, the court has, without considering my objection, passed the order to deposit 50%, including the compensation. If, my lord.
I think 50% withdraw ಮಾಡಲಿ ಅವರು. The petitioner submits that pursuant, Learned Counsel of the petition submits pursuant to the order passed on 27/7/2026. The respondent petitioner has deposited 26 months arrears, 50% of which will now be permitted to be withdrawn by the wife. The registry is directed to transmit the said amount to the account of the wife without broking any delay.
One submission. This, my lord, were against an interim order before the appellate court.
We'll
If
see
matter
Ragli.
may be disposed of, my lord, directing the appellate court to dispose of.
ಅಷ್ಟೇ.
This may be made.
So and so. In the light of the submission, both the learned counsel appearing for the parties would submit that the matter be disposed with a direction to the appellate court to dispose the subject appeal within a time frame. In the light of said submission, I deem it appropriate to direct the concerned court to dispose the appeal with an outer limit of 8 weeks from the date of receipt of the copy of the order. The remainder of the 50% of the amount, ಅದೇನ್ ಮಾಡೋದು?
Transfer to.
The remainder of the 50% of the amount be transmitted to the appellate court for the appellate court to pass necessary orders for its release.
So also to pay the subsequent maintenance.
It is made clear that the maintenance that is awarded shall be continued to be paid to the wife unless the concerned court would modify the same. ಅದು ಗೊತ್ತಿಲ್ಲ. Unless the concerned court modify the same.
This, my lord, 10,000 and the compensation is paid. Then, my lord.
Unless the concerned court would modify the same. Yes,
It's not
next.
pressed for the compensation.
ಇದು ಏನು?
What's the,
Interim order ಉಂಟಾ?
there is no interim order grant.
First time, awaiting service ಅಂತಿದೆ?
Lordships are directed notice.
Second
my lords,
petition,
and,
R2 is entered appearance.
ಮಧ್ಯಾಹ್ನ ಕೇಳುವ? ಒಂದೂವರೆ ಆಯ್ತು.
56 my lords, FIR is challenged. Cash sheet is filed on 5/8/2026.
ವಿಜಯ್ ಶಂಕರ್ ಗೌಡ, ಶೇಖರ್ ಗೌಡ.
56 ಅಲ್ಲಿ.
56, ನೀವು ಅಪೇರ್ ಆಗ್ತಿರೋದು 56 ರವಿಶಂಕರ್ ಸರ್?
55 and 56.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಂತೆ? ಎರಡರಲ್ಲೂ CC ಆಗಿದೆಯಾ?
Second 56 ಅಲ್ಲಿ ಮಾತ್ರ 55 it is still.
ಆಯ್ತು 55 will hear,
Almost
56
completed.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಆಯ್ತು.
Yes. 55 ಮಧ್ಯಾಹ್ನ, 56 ಚಾರ್ಜ್ ಶೀಟ್.
Please.
Yes, sir.
55 non-executive.
One indulgence, my lord.
Huh?
Vacating, I had moved the memo, my lord.
69 settlement.
ಬೇಡ, ನಾಳೆ ಮೂವ್ ಮಾಡಿ.
Please, my lord.
Serial number 69 settlement parties are present.
ಊಟ ಮಾಡೋದ್ ಬೇಡವಾ?
4 o'clock.
ಸಾಯಂಕಾಲ 5:15 ಬರಕ್ ಹೇಳಿ.
My lords, one submission, my lords. My lords, it was a date given matter today and it has not
Sorry?
come up.
Date given matter.
7A matter, my lords. Failed trap matter. And it was a date given matter for today which has not come before.
7A ಗಳೆಲ್ಲ 14th ಬರುತ್ತೆ. 14th ಮೇಡಮ್? 14th ಡೇಟ್ ಕೊಟ್ಟಿದೆ. ನಿಮ್ಗೆ ಯಾವಾಗ ಸಪರೇಟ್ ಆಗಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು?
No, my lords, it was given as 11/8, my lords, but it
Let's
has
see.
not been
ಯಾವ
received.
ನಂಬರ್ ಕೊಡಿ ನೋಡಿ. ಮೆಮೋ ಮೇಲ್ ಡೇಟಾ?
No, my lords.
It's my date ಅಂದ್ರೆ let's see madam it what it's ಬಂದಿಲ್ಲ.
Wait, my lords.
Case number. Right.
2025 matter, my lord. Matter was listed twice, could not be reached. There is no, not even stay, my lord.
No stay,
No stay.
no stay ಹಾಕೋಣಕ್ಕು. Next week,
Any date may kindly be given,
Wednesday, Thursday.
please. Another matter, my lord. Notice was issued. No.
W issued against the accused, my lord.
ಬೆಳಗ್ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಲಿಲ್ಲ?
I am went to Devanhalli, my lord.
Went to Devanhalli. Now go back to Devanhalli. You came from Devanhalli,
Please, ma'am.
go back to Devanhalli. Yes,
Please.
and come back tomorrow morning. ಕೊಡಿ. Yes.
It's a pending matter, ma'am.
ಆಯ್ತು ಕೊಡಿ ನೋಡ್. ನೀವು ದೇವನಹಳ್ಳಿಗೆ ಹೋಗಿದ್ರಿ. ಕೊಡಿ.
ಇದರಲ್ಲಿ notice was issued, my lord. There is no stay.
ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಇವತ್ತು ಕೊಟ್ರೆ ಮೆಮೋ ಸಿಗಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಮೂವ್ ಮಾಡಿದ್ರೆ ಹಾಕ್ಸೋಣ. ಅಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇರಿ ಪ್ಲೀಸ್. ಕರೆಕ್ಟ್ ಅಲ್ಲ, ಈಗ ಜಸ್ಟ್ಮೆಂಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡಬೇಕು.
Milords, list 3, serial number 3, milords. Milords, I have intimated the petitioner.
ಯಾವುದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್?
There's some inconvenience.
ಕರಿತೀನಿ ತಾಳಿ, ಫಸ್ಟ್ ಅದೇ ಕರೆದು ಬಿಡ್ತೀನಿ,
Please.
ಆಮೇಲೆ ಮೇಡಮ್ ಅದೇ ಕರೆದ್ಬಿಡಿ.
List number 3, further hearing, still number 1.
That's, this is the matter, my lords, the checking the drink and drive, my lords. We assaulted, while checking the drink and drive, my lords, drink and drive, the petitioner was a bank manager, my lords. A drink and drive check ಮಾಡಬೇಕಾದ್ರೆ ಅವ್ರ ಮೇಲೆ ಪೊಲೀಸರ ಮೇಲೆ ಕಾರು ಡ್ಯಾಶ್ ಮಾಡಿ ಅವ್ರಿಗೆ
307 ಹಾಕಿದ್ದಾರೆ.
It was heard extensively, my lords. No urgency, my lords.
ನೋ ಅರ್ಜೆನ್ಸಿಯಾ? ನಿಮ್ಗೇನು ಅರ್ಜೆನ್ಸಿ? ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಈಗ,
ಅದಕ್ಕೆ ಬೇಡ ಅಂತ.
ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಬಂದು ಹೋಗ್ಲಿ. ಎಸ್, ರಿಸರ್ವ್ಡ್ ಅಂತ ತೋರಿಸಿ. ಸ್ಟೇಟ್ ತಾನೆ, ಇವ್ರಿಗೇನು ಗೊತ್ತಿಲ್ಲ ಬಿಡಿ, ಅವಾಗ ಕೇಳಿ.
SPP ಅವರು.
ಜಬೀವುಲ್ಲಾ.
Still number 2.
Lord, defamation, my lord. My lord, on the last occasion, they wanted apology. I have given apology, my lord, 8/7/2025.
Correct.
Apology letter I have given.
ಆಮೇಲೆ
Nothing survives, my lord.
My lord,
ನಥಿಂಗ್ ಸರ್ವೈಸ್. ಅಪಾಲಜಿ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ.
ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ ಹೇಳಿ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿ.
ಕಾಂಪನ್ಸೇಷನ್ ಎಷ್ಟು ಬೇಕು? 1 ಕೋಟಿಯಾ?
ಸಾರಿ, ₹1.
₹1?
ಆಮೇಲೆ
₹1?
the case in the trial court proceed the against accused number 2 ಮೇಲೆ.
ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಮಾಡ್ಕೊಳ್ಳಿ. ಇವ್ರದ್ದು ₹1 ಸಾಕಾ? ಎಸ್, ಅದು ಡಿಸ್ಪೋಸ್ ಅಂತ ಮಾಡಿ ಹೇಳ್ತೀನಿ. It will not be applicable to accused number 2.
Please, leave it.
Great.
ಅದು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The petitioner is before the court calling in question the proceedings in so and so. During the subsistence of the petition and the hearing of the respective learned counsel for the parties, the learned counsel for the respondent complainant had submitted that if the petitioner would tender an apology by filing an affidavit of apology, it would suffice, leaving open the issue of compensation. The affidavit of apology is placed before this court, in terms of which the learned counsel for the complainant submits that nothing could, the court need not answer other issues qua accused number 1, except the compensation, which also would leave to the discretion of the court. It is made in the light of the said submission, contra submission. The proceeding stands obliterated qua the petitioner accused number 1 it is made clear that this would not become applicable to the other accused in the fray. Yes. Compensation ಬರಿತೀವಿ ಬಿಡಿ ಆಮೇಲೆ.
Bill number 3.
This is also, my lords, it was heard at length, my lords.
ಅದೇ 2000 ರೂಪಾಯಿ ನೋಟು.
2000 rupees
ಹಾ.
notes exchange of
2022 ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದು.
Subsequently also, my lords, 3-4 dates it was heard and we have given.
ಅದೇ 2000 ರೂಪಾಯಿ ನೋಟ್ ಅಲ್ವಾ?
ಹೌದು.
8 notes of the 2000 rupees.
2000 rupees, 10 lakhs rupees.
Today there is some
Idralli
inconvenience.
they received the information from the
But
office of the Prime Minister.
Today there is some inconvenience, my lord, therefore.
ಆಯ್ತು, ಫೈನಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಫೈನಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇನ್ ದ ಸೇಮ್ ಸ್ಟೇಜ್. ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿರಿ ಮೇಡಮ್. ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಎಸ್ ರಾಹುಲ್,
Please,
ಗೇರ್ ಅಪ್ ಫಾರ್ ದ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಎಸ್.
please.
Number 4.
Respondent, my lords. Next week, my lordship, senior is held up in another court.
SBM was closed in the year 2017. Check pertaining to the SBM. We presented it in the year 2020.
ಎಸ್ ಸರ್, ಫೈನಲಿ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ, ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಕೀಪ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
Please.
ಅದು ತುಂಬಾ ದಿನ ಆಗಿದೆಯಲ್ಲ ಇರಲಿ. ಎಸ್.
5.
ಮಹೇಶ್.
Same matter wherein my lord, ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಪೇಪರ್ ನಾನೇ ಕತ್ಕೊಂಡು ಹೋಗಿದ್ದೀನಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಸಂಬಂಧಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆನ್ ಲಾಸ್ಟ್ ಒಕೇಶನ್.
ಹಾ, ಕರೆಕ್ಟ್.
Raise for some time and.
ಪ್ರೆಸ್ 6.1 ಏನು?
ಅಲ್ಲ 5, serial number 5.
5, ಎಸ್. ನೀವು ಯಾರಿಗೆ?
For respondent number 2, my lord, complaint.
ಎಸ್, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಲ್.
Vacating stay state ನವ್ರು ಹಾಕಿ.
Release the matter from the status of being part heard. List the matter in the usual course. State ಹಾಕಿರೋ vacating stay na. The matter is extensively heard. There is no warrant of vacating the interim order at this juncture. The matter would be heard post for admission. Interim order subsisting is made absolute. Yes.
Okay.
Next.
Bill number 6.
ಇದು ಅಷ್ಟೇ ಸೇಮ್. Release the matter from status of being part heard. Post the matter for admission. Interim order subsisting will continue. Next.
7.
My lord, appear for the petitioners, my lord. This is a matter pertaining to the commercial transaction. I request for short date accommodation, my lord. Any time in the next week, my lord.
Release the matter from status of being part heard. Post the matter for admission. Yes. Interim order ಇದ್ರೆ continue ಮಾಡಿ.
Grateful.
Vacating, they filed IA for vacating in this matter.
You already filed?
Yes, your lordship. It's on record.
Post the matter under the caption hearing on interlocutory
It may be
applications.
fixed, your lordship.
Next week we'll see. Yes, I'll get them posted.
8.
Grateful.
In this case, accused number 10 is a practicing counsel and appearing for accused number 1 in a matrimonial dispute.
Eager, you are the advocate, is it? Then keep this. Yes. Post the matter next Tuesday in the next Tuesday in the same stage. The only thing is you have appeared for the accused.
Accused number 1.
You are made accused number 10. All right. Let this be there. ಇದು ಯಾವ್ದೋ ಬರದ್ನಲ್ಲ ಆರ್ಡರ್ ಇದು.
My lords, yes, my lords, this is a matter
Bail
pertaining
matter.
to Muda, my lords, where
ಅಲ್ಲ,
we have.
bail matter I have written.
Yes, my lords. And here we have already given the points for consideration in writing, my lords, 4 points for consideration, it's already been given. I think.
That's all right. Release the matter from the status of being part heard. Post the matter for admission, writ petition, criminal petition. Post the matter for admission on 14th.
Obliged.
ಏನು?
We have challenged the predicate offense also, my lords. And
ಅದ್ಯಾವ್ದು ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ. Tag along with so and so, list them both on 14th.
Next week.
Predicate offense ಹೇಗೆ? ನಂಬರ್ ಕೊಡಿ. ಹಾ. ಅಲ್ಲ, ಇದು ಹೆಂಗು ಪಾರ್ಟೆಡ್ ಬೇಡ, ನನ್ ಮುಂದೆನೆ ಬರುತ್ತೆ.
Please. The predicate offense, if we succeed, my lords, this may not survive after that. Punishment.
ಅದು ಮದುವೆ ಬಿಟ್ಟಿತ್ತು ನೋಡಿ.
Obliged.
Yes, yes. FR. ಸುನಿಲ್.
We filed it today, my lords.
ಸರಿ, ಅದು ತಗೋಬೇಡಿ, ಮೆಮೊ ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟು ನಂಬರ್ ಕೊಡಿ.
Let's continue. 55.
Lords, petitioner is labeled as the accused number 7. The allegations contained.
You want the label to be changed?
No, I have no difficulty. I shouldn't. The label should be changed that I should be released from the status of being an accused.
Exactly. Yes.
Lords, the complaint does not disclose my role. When the remand application is filed, they say that I am also involved, I am a farmer. Lords, then the allegation was made at the time when the remand application was made, saying that some documents were recovered from me. Then when I made an application seeking bail, the learned judge specifically asked them whether there is any recovery from him. Because allegation is that accused number one has taken some impersonator and got the property registered of somebody else in their name. I have no role to play in this. Now, as against the specific question, they said that no, we have not made any recovery from him. That's the reason which is recorded by the learned judge while granting the bail. Now, I have been labeled as an accused number 7. Absolutely nothing to do with this matter. I have no pecuniary interest. I have no interest in the property.
You're a public servant.
No, I'm a farmer in the same village.
Farmer?
Millards, yes. This is a property pertaining to Shidlagatta, Millards.
ಎಷ್ಟು ಎಕರೆ ಇದು?
No, this is about 8 acres. I own a property, Millards. I am myself a farmer. I am owning properties. I am tethering cows.
Ancestral property of the complainants. Millards, he got it, Millards. Millards, these petitioners colluded each other, Millards, created false documents and got the land registered in the office of the sub-registrar. Millards, investigation is still going on. Millards, the materials are yet to be collected. Millards, the petitioner being a habitual offender.
Habitual?
Yes, he is involved in 6 cases. He is already convicted in 2 cases. Millards, the CDRs have been.
Same?
Yes, Millards, CDRs have been collected.
Records
Let them show the investigation papers, what materials they have collected.
CDRs were collected
Madam,
to
this
show that Millards, he has participated in the registration in the office of the sub-registrar. CDR.
ಅಲ್ಲ habitual ಅಂದ್ರೆ ಯಾವ ತರ?
Millards, he has already convicted in 2 cases. List of cases and convicted cases also I have given.
ಆಯ್ತು ನೋಡಿ. ನಾಳೆ ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀನಲ್ಲ ನಿಮ್ದು ಅದೇ ತರ.
No difficulty, Millards. I can understand this plea being taken in respect of a bail application, that he is a habitual offender, etc. The question is this: do you have any materials as against me for having been involved in this case?
Let me be satisfied by
Very well,
looking at
Millards.
it. Yes, we'll take it day after tomorrow, fresh
Lots.
matters. Yes. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. The learned HCGP has handed over the papers of investigation. List this matter day after, ಹೇಳಿದ್ನಲ್ಲ, in the fresh matters list.
Please, Millards.
Yes.
List number 4, pronouncement of order. Seal number 1.
ಜೈಲೇ ಇದ್ದಾರಾ? ಇವತ್ತು. Yes. All bail granted ಎಲ್ರಿಗೂ. ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಎಲ್ಲೆಲ್ಲಿದೆ ಅದು, ರೆಗ್ಯುಲರ್ ಬೇಲ್ ಯಾರ್ಯಾರು ಜೈಲಿದ್ದಾರೆ, ಆಲ್ ಗ್ರಾಂಟೆಡ್. ಎಸ್. ಜನರಲ್ ಕಂಡೀಷನ್ಸ್. ಎಸ್. ಏನ್ ಬೇಕು ಮೇಡಮ್? ಇದು ಇದೇ ಕೊಟ್ಬಿಡ್ತೀನಪ್ಪ. Odd itself will be released. Yes. ಎಲ್ಲದರಲ್ಲೂ odd itself will be released. But by about 5:30. Operative portion ಬೇಕು ಅಂದ್ರೂ ಅಷ್ಟೊತ್ತೇ ಆಗುತ್ತೆ. ಅದು ಆಗ್ಲೇ ಬರೆದಿದ್ದೀವಿ. ಯಾರ್ಯಾರು ಜೈಲಿದ್ದಾರೆ ಅವ್ರಿಗೆಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಕಮ್ಯುನಿಕೇಟ್. Communicate.
T7.
7A, Millards.
Millards, the investigation in crime number 63 of 96, Millards, was handed over to one Arun Kumar, Millards, on 11th April 2026. That is at page number 43 to 44, Millards. The alleged demand which the complainant has made against it.
Objections ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ.
Is on 22nd April.
No problems.
Investigation was handed over to Arun Kumar.
ಆಯ್ತು, wait, we'll see. The learned counsel B.B. Patil seeks time to file statement of objections. ಎಷ್ಟು ದಿನ ಬೇಕು?
That's on 14th, before 14th.
By 14th. List the matter on 14th along with the other cases.
Please,
yes. Next.
T8.
For the petitioner in this case.
Nagesh, Nageshwarappa. SP ಅವರಲ್ಲಿ
Total two is
ಹಾ?
total two ನಲ್ಲಿ
ಮುಗ್ದಿದ್ರೆ ಬರಕ್ ಹೇಳಿ ಮುಗಿದ ಮೇಲೆ.
Yes.
Meantime, next.
59.
Accused number 1 and 2 are different. Charge sheet has been filed for section 418 of IPC. Just point out to two documents. Page number 147 is the sale deed. ಅದರಲ್ಲಿ last paragraph. Page number 147.
Your A1 and A2.
A1 and A2.
Yes, sir.
The consideration is shown. Rupees 7,54,650 by check number so and so dated 28/2/24 drawn on so and so in favor of Shamala Salyan, who is none other than the mother of the.
Correct. You are the children. No. Who is Shamala Salyan?
Shamala Salyan is mother of Mr. Neev Salyan, based on whose representation the registrar has filed this complaint.
Get the complainant. Yes. Who is the complainant?
The complainant is a registrar. A
Yes.
may just point out to one other document.
Why you have not described the registrar as the where is the complaint?
Complaint allowed is at page number 22. ಅದರಲ್ಲಿ ಉಲ್ಲೇಖ ಒಂದಲ್ಲಿ ಈ ನೀವ್ ಸಾಲ್ಯಾನ್ ಅವರು ನೋಂದಣಿ ಮಹಾಪರಿವೀಕ್ಷಕರು.
Yes, one HCGP, two emergent notice.
In fact, the petition filed with accused number 3 has been.
Accused number 3 then role ಇರಲಿಲ್ಲ ಅಂತ.
But the entire consideration has been received by them. His own mother has received the consideration. She is not arraigned as an accused. In fact, a civil suit was filed 1 year prior to filing this.
Which is that petition where A3 stayed? Tag along with so and so, list them both on 19th in the fresh matters list. Next.
60.
Manjunath, let the SPP come. I've asked him to come. Pass over.
61.
ಬಂದ್ಮೇಲೆ SPP ಅವ್ರಿಗೆ ಫೈಲ್ ಕೊಡಿ ಅದು ನೋಡಕ್ಕೆ. ಎಸ್ ನಿಮ್ಗಲ್ಲ ಸರ್ ನೀವಿರಿ. ಎಸ್ Then why are you running away from the promise? Wait. What's the relation between you and her?
We were in a relationship, my lords.
ಅದೇ ಹೆಂಗೆ ಅಂತ ಕೇಳಿ.
Boyfriend, girlfriend. Boyfriend, girlfriend.
ಅದೇ ಹೆಂಗೆ ಅಂತ ಕೇಳಿದ್ ಗೊತ್ತು.
Met at some event and we got to know each
ಅಷ್ಟು
other.
ಕೇಳಿದ್ ಅದಕ್ಕೆ ನೀವು ಬಾಯ್ ಫ್ರೆಂಡ್ ಗರ್ಲ್ ಫ್ರೆಂಡ್ I know all that. ಅದಕ್ಕೆ 69.
My lords, one aspect I'd like to point out, my lords. In the FIR, in page number 20, my lords, she admits that her engagement is broken on 23/8/2025, my lords.
23/8?
2025. I am married on 23/11/2025, my lords.
To whom?
To a different person. Engagement is broken, relationship is ended, my lords. Now, if she actually.
Engagement with you, is it?
No, my lords, with a different person, someone else.
Then
now the learned SPP contended that engagement was broken because of me, my lords.
Correct, correct.
If that was true, she could have filed the complaint right then and there, my lords.
When
Now,
did she file it, sir?
2/6/2026.
You got married by then, na?
Yes, my lords.
statement, my lords.
ಇದ್ದೇ ಇರುತ್ತೆ ಮತ್ತೆ. Relationship ಇತ್ತು, that was there.
That was there, my lords.
For how long?
For a brief period of time, my lords. By the time this incident happened, we were not there in relationship anymore.
Correct, sir. But 2020 ಇಂದ ಗೊತ್ತು ಅಂತ ಹೇಳಿದಾರೆ.
2020 ಇಂದ ಗೊತ್ತು, 24 ಇಂದ ಒಂದು ವರ್ಷದಲ್ಲಿ ಒಂದು ವರ್ಷ ಇರಬಹುದು ಸ್ವಾಮಿ. ಒಂದು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್.
The petitioner is the accused, the respondent, the complainant. The two have had a relation. The two are known to each other from 2020 through 2026. The relationship between the two had blossomed into it being physical as well in the year 2024, and the said relationship ends in the year 2025. The complainant was already married and was in the process of getting divorced. The petitioner also gets married on 2/11/2025. But the complaint with regard to instances that have happened,
23/11/2025.
23/11. ಬೇರೆ ಯಾರನ್ನ ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ, 11 ತಾನೆ. 23/11/2025. The instances that have happened in the year between 2024 through 2025 is complained of on 2/6/2026. The complaint itself indicates that the two have had such consensual relationship between the two. Since the petitioner was married, since the petitioner after consensual ಸಾಕು in the if further proceeding, further investigation is permitted, custody ಅಲ್ಲ,
Custody ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದೀರಾ?
Custody ಇದೆ ಸ್ವಾಮಿ.
If further proceedings are permitted to continue in the case at hand, notwithstanding the aforesaid acts being consensual and except the allegation, no other allegation being present in the case at hand, the further investigation should remain stayed. The petitioner, on the ground that the relationship has broken 8 months ago, is now in prison on account of the registration of a crime for offence punishable under Section 69. This court is repeatedly coming across cases where the relationship breaks and the person who was in a relationship is taken to custody, all on the plea of such complainants. And the concerned courts are also turning down the bail applications on the ground that the offence is the one punishable under Section 69 without looking into the law as to whether they are consensual acts between the victim and the accused for ages. In that light, it becomes necessary to release the petitioner from prison. Release the petitioner from prison. The registry is directed to communicate the said order to the prison authorities to enable the release of the petitioner without broking any further delay. Further investigation in the case at hand shall remain stayed in the light of the judgment of the Apex Court in the case of Dhruvaram Mudalayar Sonar, 2018-19 SCC page 191.
Great.
62.
Petitioner, my lord, during the period 2021 and 2023.
SLAO?
Please note this. Lord, here, my lord, why, my lord, I have sought this, my lord, now, my lord, it's 34 weeks pregnant, my lord. It's the advanced stage, my lord. And my lord,
bail ಕೊಟ್ಟಿಲ್ವಾ?
bail move ಮಾಡಿದೀವಿ. But ಏನಂದ್ರೆ, at this stage, my lord, every day they are calling, so it is causing undue stress to her. And my lord, and now she is arraigned as an accused number 4, my lord, annexure N1, my lord.
What is the allegation against you?
Lord, the allegation is that, my lord, there are 2 court decrees on the basis of compromise, on the basis of a specific performance suit, but on the basis of which, my lord, Khata entries were directed to be changed. My lord, the first Tahsildar, my lord, rejects it. My lord, an appeal is filed under 136(2). My lord, in the appeal, there is a direction that I should get the entries affected. My lord, I do it in furtherance of the court decree and in furtherance of the appeal. Now, my lord, what they say is I should have appealed that order. Lord, Tahsildar cannot, my lord, under 136(3).
136(3).
136(3). Lord, it is a suo moto by the DC.
No, we'll see, yes. ಈಗ 17A approval ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ sir. And my lord, 17A approval is given in August 26.
No, 17A approval, if I stay andre, all the accused will come in a B line.
Please.
Then,
Lord, 17A approval is only against the A4, my lord.
ನಿಮಗೆ?
That is, I am the A4. And on the basis of that, in an existing FIR, they add me as an A4, my lord.
17A approval ಬೇಕಾಗುತ್ತೆ ಆಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ.
ಹೌದು.
ಅದು ಬೇಕೇ ಬೇಕು.
ಇಲ್ಲ, approval ಗೂ ಅದೇ ಕಾರಣ. They have given that I have not filed them.
There's 13(1)(2), sir.
Please. Lord,
anyway, we'll exempt you from appearance before
please,
the court.
My lord, that limited, my lord, till, my lord, the local.
That I will do.
Please, my lord.
Yes. The petitioner is before the court calling in question the registration of a crime, calling in question the proceedings in
crime number 2 of 26. Annexure N, my lord, page 99.
Proceedings in crime number 2 of 2026 registered for offence punishable under so and so. apart from the merit of the matter, the learned counsel for the petitioner submits that the petitioner is in the 34th week of pregnancy, which is an advanced stage, and repeatedly being called for the purpose of investigation. Investigation in Madhaka.
In this case, they're issuing, and my lord, no notice is being issued on phone call.
Investigation or to before the concerned court. The petitioner is thus exempted from being called before the concerned court for the purpose of trial, and in the garb of investigation, the petitioner, the state, if the lokaयुkta, if the investigation is continuing, shall not harass or take coercive steps against the petitioner. Yes.
Grateful. Notice, my lord, perhaps. Please, please.
ಲೋಕಾಯುಕ್ತಗೆ ಇದು ಮಾಡ್ಬಿಡಿ. ಬಿ ಲತೀಫ್ is directed to accept notice. Next.
Grateful.
Yes. ಮುಗಿತಾ ಇದು? ಎಷ್ಟಿದೆ ಪಾಸ್? ಮುಗಿಸ್ಬೇಡ.
Passed over matters. Number 2, seal number 3. Along with 82.
80, along with it. Yes.
Seal number 6.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಜನ್ ಮಾಡ್ಬಿಡಿ.
Seal number 31.
For the respondent, my lordship.
First list, madam, second list. Oh, ಆಮೇಲೆ ಮಾಡಿ. Yes, pass over ಮಾಡಿ.
46.
Waiting for the respondents.
You have challenged the constitutional validity.
Please, my lords. Section 7, my lords. Section 3 and section 7, my lord. Two mechanism, my lords. One is applicable for non-Indian entities under section 3, that is governed by, my lords, related by the National Biodiversity Authority. And section 7 entities are Indian entities which are governed by, my lords, the State Biodiversity Authority.
Yes, sir.
That is SPB. For section 7, nowhere says, my lords, before, my lords, I access any biodiversity, I should pay what they are calling is, my lords, access to benefit sharing, ABS. That is, my lords, not in the act at all. It's only with respect to, my lords, entities which are covered or governed by, my lords, section 3 and governed by, my lords, NBA. That is National Biodiversity Authority. That I will demonstrate, my lord, from the section itself. May I read, my lord, section 3 for this purpose, my lords? Because section 55, which make it as an offense, refers to section 3, section 4, and section 7, my lords. Section falls under section 7 falls under, my lords, subsection 2 of the section 55. So first I will read, my lord, section 3. Certain persons not to undertake biodiversity related activities without approval of the National Biodiversity Authority. No person referred to in subsection 2 shall, without previous approval of the National Biodiversity Authority, obtain any biological resource occurring in India or knowledge associated thereto for research or for commercial utilization or for biosurvey and bioutilization. Persons, my lords, that is subsection 2, the persons who shall be required to take approval of the National Biodiversity Authority on subsection 1 are the following, namely, a person who is not citizen of India, a citizen of India who is a non-resident, and C, body corporate, association or organization not incorporated or registered in India. Second one, incorporated or registered in India under any law for the time being in force, which has any non-Indian participation in its share capital or management. So, my lords, section 3 governs, my lords, non-Indian entities in general, my lords. Section 4, 5, my lords, are relating to, my lords, research and transfer of research related, my lords, results. That is not covered. When we come to, my lords, section 6, which is governed by, my lords, section 3, that is NBA, it's applicable to intellectual property, and that's also not the case in the present case. And we'll come to, my lords, section 7, my lords. Section 7, prior intimation, my lords. I will emphasize these words because the words used in, my lords, section 3 are prior approval or previous approval, my lords. And section 7 are, my lords, prior intimation to State Biodiversity Authority Board for obtaining biological resources for certain purposes. No person who is citizen of India or a body corporate, association, organization which is registered in India shall obtain any valuable resources for commercial utilization or bioresources or bioutilization for commercial utilization, except after giving prior intimation to the State Biodiversity Board concerned, my lords. It's an intimation, nothing, not a approval or a permission, my lords. Now, my lords, they are embarking on two of the, my lords, rules made by state government, my lords. That is, in
Now,
my first petition, my lords,
what is that you have challenged, sir?
My lords, I have-
Complaint is registered,
complaint is
which
registered,
is
my lords.
in CC 210 of 2022
Please, my lords.
for offenses punishable under the Biodiversity Act.
Section 55, my lords.
All right.
Please, my lords.
Yes.
Lords, allegation is that I have not paid ABS, my lords. That's access to benefit sharing.
Correct. This, in that wake, you have challenged the constitutional validity of the rules 2005.
15, yes, my lords.
Rules 2005 and sharing regulations 2014
Please, my lords.
on the score that it does not apply to
Indian entities. my
Indian
lords.
entities.
If it is made applicable, this is beyond, my lords. So what is the power given?
That's all.
Please, my lords. My lords, I will show, my lords, section, rule 15, my lords. These are provisions of law, my lords. Then rule 15, sub rule 5, my lords. A written agreement duly signed by an authorized officer of the board and the application shall govern the access, such application shall govern the access allocation. Form of agreement shall be decided by the board, my lords. Act says, my lords, I have to just give intimation. Then they make rule under the act, which says, my lords, I should enter into an agreement. And agreement format has to be decided by the, my lords, the board. That's what they say. And my lords, agreement is page number, my lords, 136, my lords, which says, my lords, one clause. This is part of the agreement, the draft agreement, what they have shared with the all the petitioners. If the applicant chooses to pay according to regulation 3 of the guidelines on access to biological resources and associated knowledge and benefit sharing regulation 2014, he must refer to the rates of benefit sharing prescribed under so and so, so and so, so and so. So they incorporate, my lords, this access, my lords, ABS regulations in the agreement, which is not in the act, my lords. And the regulations, my lords, which are made by the central government, are specifically referred to persons who are covered under section 2, section 3, subsection 2, not persons who are covered under section 7, my lords. This is my case on, my lords. Rules,
That's
my lords.
all.
Please, my lords. There are other two issues, my lords. One is, my lords, after this, my lords, this is criminal cases filed under, my lords, the old act. Now, my lords, whole act is amended. All criminal provisions have been removed. Now everything is made civil, my lords. My respectful submission
Now it is permissible.
not permissible.
Not
It is
permissible.
made civil, my lords. Liability is civil. There is no imprisonment, and there is no provision for taking cognizance of the act itself, my lords.
Your
This is
Lordship,
just like one I decided that TV9 matter. Exactly. Well, yes, you had argued. CBI, I think Kirti Reddy had appeared. Yes, madam. ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಅವ್ರು ಬ್ಯುಸಿ ಇದ್ದಾರೆ ಮಾತಾಡ್ತಾರೆ.
Your Lordship, if I
ಅವ್ರ
may,
ಕಾಪಿ ಇಸ್ಕೊಳ್ಳಿ.
State government is also party.
ಕೀರ್ತಿ ರೆಡ್ಡಿ ಮೇಡಮ್,
Your Lordship, if I may.
give the TV9 judgment which you and Rahul Reddy had appeared. Yes, it's covered by that.
Rules, my lords,
Insofar
go
as
beyond-
that is concerned.
Rules go beyond, my lords, statutory provisions. That's one, my lord. Then we have, my lords, amendment to the provisions, my lords. Criminal act is been removed. There is no cognizance can be taken. No, cognizance cannot be taken by as of today, my lords. And third one is, my lords.
So
here-
now it's fine. Now it can't be done at all.
Lordship, there's a
Now
small-
that was a case where it was remanded back.
Please.
The court had quashed it and sent it back for a fresh cognizance to be taken.
Please.
Fresh cognizance was taken, but by then the law had changed.
Please. In
Your
this
Lordship,
case, my
small
lord, cognizance is
clarification, Your
taken, my
Lordships.
lords.
Here,
That was the case. TV9's case was that.
Please. Section 58, my lords, which my lords had given power to take cognizance. No court shall take cognizance of any offences under the acts except as on a complaint made by the central government or any other authority or officer authorized by the on behalf of the government. Any benefit claimant has given notice to but not less than 30 days in the prescribed manner of such offences, his intention to make a complaint. It's a private complaint, my lords, by the private person. One is by the, my lords, government itself, my lords. That's the second contention. No? Third is, my lords, even if they are, my lords, saying that there is some reference in section 23 or 24 of the Act, which speaks about, my lords, biodiversity. It has to pass, my lords, test of the Constitution under 265. There has to be triple test that a person who is paying, at what event it is paid and what date it has to be paid. It has to come in the Act, my lords, not in the rules or regulations made by them, because definition also says 366, Article 366, 28. Taxation includes any impost or imposition except from the persons. And they have been relying, my lords, on two main documents, my lords. One is, my lords, International Convention, Nagoya Convention, which says, my lords, if a person is taking biodiversity from one country to other country, person who is taking it out of the country should pay it, my lords. No international convention can make it compulsory for a nation to make a rule that its own citizens should pay tax to it. And also, my lords, based on international convention, there cannot be any conviction in a criminal law. That's my submission, my lords. I will submit, my lords.
Yes, synopsis list of authorities kodi. Yes, sir.
Your Lordship, if I may just give a small clarification. Your Lordship, this case differs slightly from the TV9 judgment on the point that the TV9 judgment pertained to decriminalization of the particular offence under section 560. But however, in this case, it is not decriminalized, but rather imprisonment as a punishment has been reduced to just penalty, Your Lordships.
However, same thing.
Indeed.
There also it was
which
same
can
thing.
take cognizance.
Your Lordship,
Same thing
however,
there.
section 61, which was the erstwhile law, continues to exist, which says that no court other than the magistrate shall take cognizance of the
That was
offences.
that. It is the same thing.
Indeed, Your Lordship.
Yes.
Your Lordships, here, just to clarify the particular position that was taken by my learned friend. Your Lordships, here, I would like to bring your attention to section 23 and 24 of the Biodiversity Act, Your Lordships. Your Lordships, while it was rightly pointed out that section 6 states that prior intimation to the Biodiversity Board is what is required under section 7 of the Biodiversity Act. Section 23 and 24 govern the aspects as to the grant of the permission, Your Lordships. Under section 23, if I may read this, Your Lordships, the functions of the State Biodiversity Board shall be to regulate by granting of approvals or otherwise requests for commercial utilization of biosurvey or bioutilization of any biological resource. Your Lordships, in the words of the petitioner in their own petition, they have accepted that they are undertaking commercial utilization of biological resources. That is the prima facie ingredient required for satisfaction of 23B. So when I'm granting the approval, Your Lordships, when the power is granted or a functional authority is granted to a State Biodiversity Board to grant the approval can be with certain conditions whatsoever. And here in this particular aspect, Your Lordships, the rules and regulations, we tend to impose the ABS in a format which is mandated by the government only, Your Lordships. And there was also a particular notification given across to all these wrongdoers to actually even come bona fide and make the payment of ABS by way of a retrospective effect in the year 2023. Prior to filing of the cases, this opportunity was given for all the offences that you have committed. Come across, make the payment of ABS.
Compounding.
Indeed. Compounding notification was passed in the year 2023. So ex post facto compounding. Your Lordships, however, here in this particular pointer, merely because they state that the State Biodiversity Board does not have the power under section 6 and 23B, please kindly look into section 52, Your Lordships. 52A. 52A, Your Lordships.
That's a new act.
No, Your Lordships. It is a part of the old legislation itself. Section 52A. Section 52A is inserted by way of amendment in the year 2010, Your Lordships. Section 52A speaks about appeal to the National Green Tribunal. Any person aggrieved by any determination of benefit sharing or order of the National Biodiversity Authority or a State Biodiversity Board under this Act or under the commencement of the National Green Tribunal Act may file an appeal before the National Green Tribunal established under Section 3. Your Lordship, this particular order pertains to imposition of benefit sharing alone, Your Lordships. If at all they had the inconvenience, there was an appellate power that was given across. And Your Lordship, it is the genesis of a statute that when an appellate authority is constituted for a particular concept of benefit sharing imposition, it means that the statutory authority has the functional authority and the power to impose that benefit sharing fee. Section 52A is.
Ultra virus.
What is this?
Your Lordship.
Merely because you create a remedy of filing an appeal and appellate authority is created, you can do anything, impose anything,
Lordship, it is-
just because they can go in appeal?
Indeed not, Your Lordship.
No,
But
sir.
however, the functional interpretation of the statute is also to be looked into, Your Lordship. And this particular statute
No,
is
the
not.
submission, the purport of the submission was the statute creates an appeal, they can file an appeal,
Your
we
Lordship,
can do
it
anything.
it
as
is
well.
not for that reason, Your Lordship. However, it is to understand that the genesis of the act contemplates that the biodiversity authority has the power to impose the particular benefit sharing fee. That is where the genesis was drawn across, Your Lordships. So here, under that basis, Section 23B read with Section 6 allows for the State Biodiversity Board to impose ABS. And when that particular ABS is not paid, there is an offence that is duly constituted under the enactment, Your Lordships. And by virtue of that, under Section 61, the cognizance of the offence was required to be taken. Your Lordship, the 2023 amendment, what it does is, from the aspect of making it a cognizable and non-bailable offence, it reduces that particular thing to a mere offence of non-cognizable.
Payment of fine.
Indeed, Your Lordships. Penalty is what is imposed right now.
It's exactly.
But however, Your Lordships, here the particular requirement that is to be looked into is that they have challenged the wires of the power of the authority to impose ABS. And that by alone, Your Lordship, it requires to be standing and it is well established under the statute, Your Lordships. And that given the stance, the same may be, kindly be looked into by this honorable bench.
We'll see.
There are two documents I have given. One is it's a spiral binding. In that, my lords, page my lords 24, my lords,
Madam.
which extract my lords.
Madam. ಇದು biodiversity amendment ಇದೆ. Amendment 2023 ಇದೆ.
I have the old act.
51 is old is there. What is the new one?
New act.
New
I have
one.
new act.
What you have annexed to the objections, new one or old one? 2002 Act.
They have annexed, I have not.
You have annexed it to the objections. I just now saw it here.
Yes, in one of the state objections.
Now, yeah, this objection.
R1 and R4. It is add amended.
Your Lordship, we have amended the rules, Your Lordships. The Karnataka biodiversity rules has been amended.
2023.
Not the amended act, Your Lordship. It's the Karnataka biodiversity rules that has been amended.
Madam. Rules. Rules. Okay.
Your Lordship, there's a list of citations that we are placing on record.
Okay. Yes.
Your Lordships, here, in the Divya Pharmacy judgment, which was determined by the state of Uttarakhand High Court, there in that particular aspect, a similar petition was alleged with regard to the power of the State Biodiversity Board to, impose this ABS fee. In that matter, the court categorically says that the State Biodiversity Authority's power is inherent under Section 23B. And that is one of the strong bases on the basis of which we are, submitting before the Honorable Court that it is well within the wires of the constitutional authority under the statute scheme to impose ABS fee.
So, furthermore, my lords, this particular judgment is also not challenged before the Honorable Supreme Court.
It's become final.
It's attained finality.
It is
Now
considered
the
by
issue,
a different division bench. I have referred to it.
it's already
What happened before the division
more
bench?
recent tegra, my lords.
So it is an interim order, 10-page interim order.
That's not the interim order.
No, division bench, my lords.
Division bench by interim order stayed it.
No, it says, my lord, it cannot, the law laid down in the Divya Pharma cannot be accepted with reasons, my lord. It's a detailed.
No, is it reversed?
Not reversed.
No, it stayed.
Not stayed, my lords. It only says, my lord, different division bench, my lords. Different high court.
So
Says, my lords.
different high court. This is not a division bench.
No, this is not
Divya
division bench.
Pharma
Divya
of-
Pharma is single bench, my lords. It was, my
Uttaranchal
lords,
is not.
it was relied on by my lords before the Himachal Pradesh High Court, my lords.
That's
Two division-
2018-1035.
Please. In 2025, my lords, two division benches, different division benches, say that, my lords, Divya Pharma cannot be relied on. I'll refer to, my lords, two documents, my lords, in spiral binding. One is, my lords, Article 5 of the Nagoya Convention, my lords. The spiral binding.
Division bench of which court?
My lords, in my compilation, my lords, at page number 97, my lords.
This compilation? This one?
Yes, my lords, there is judgment compulsion. That's the first one. Yes.
This report ashte idu.
No, report, my lords, it refers to, my lords, Article 5 of Nagoya Convention.
No. Where is the judgment?
Judgment is, my lords, in the compilation, this compilation.
We'll do that.
97 page number. At page number 110, my lords,
Not sure.
is the discussion on Divya format.
Apex court.
It is by the division bench of the Himachal Pradesh High Court.
Himachal Pradesh division.
Yes.
Yes.
110, my lords, at page number, at para number 31.
That's Justice Ramchandra Rao.
I have not seen. Sorry.
April 2024.
Please.
That has taken a different view.
Please, miss.
Divya pharmacy is not followed by Himachal.
Yes. And also
It's
next,
only by
one more
Uttaranchal.
division bench.
Yes.
It's on the same line, my lords, same findings of it.
Your lordship.
And also, my lords, Divya Pharma was deciding, my lords, the civil liability, my lords. So maybe interpretation when it comes to, my lords, criminal liability, based on that when we are doing it, my lords, it has to differ, my lords. And it has to, my lords, satisfy the test of, my lord, 265, my lords. That's my submission. And so one more submission
It's
is
about
based
the
on this
applicability. Divya Pharmacy
compilation, my lords.
confirms the applicability of fair and equitable benefit sharing on the Indian entities as well. Now, this power is not just restricted with the vested with the National Biodiversity Authority. It is also subsequently given to the state biodiversity boards.
That's
And
what-
the reason why the main primary objective behind the enactment of this legislation is to bring the fair and equitable benefit sharing. Until and unless that is done, Miloj, the entire objective of the legislation will be defeated. Now, they are, in order to trying to escape the benefit sharing obligation, they are trying to get the entire petition squashed. However, which will go against the objective of the entire legislation.
Your lordship, and in their
We'll see.
own petition, they
Intent
state
of
that this
legislation, my lords.
legislation is in purview of the international obligation that India has. And they themselves have admitted that they are carrying out commercial utilization. Your lordship, here the access benefit sharing, the clarification that is there is it is an ABS fee that is being collected across. And your lordship, it is 0.01%, your lordships, which is for 100 rupees, it is maybe 1 paise.
So
that
it's
is
not the
actually-
question of
Indeed.
quantum,
Indeed.
the
Your
question
lordships,
of
but-
power.
Indeed, your lordships. Here, the particular premise that comes across is this ABS fee is something that is going to be utilized for the purpose of the persons who are cultivating these
No,
particular
I
aspects.
understand the object behind it, but power.
Indeed. Your
Yes,
lordships,
I will refer to
23B, your
article,
lordships.
Let's
23B is where the existence of that power is categorically present, and Rule 15 of the Karnataka biodiversity rules, your lordships.
Yes.
Under 23B, read with Rule 15, the power becomes inherently viable, your lordships.
2 points on the spiral binding, my lords. Page number 24, my lords. Nagoya Convention, Article 5. It speaks as in accordance with Article 15, paragraph 3 and paragraph 7 of the convention, benefits arising from the utilization of genetic resources as well as subsequent application commercial utilization shall be shared in a fair and equitable way with the party providing such resources, that is the country of origin of such resources, or a party that has acquired genetic resources in accordance with the convention. It's only speaking about, my lords, if I am taking my lords bioresources from other country, I should share some benefit, my lords. If somebody else is taking, other country people are taking from India, that should be taken, my lords. And also, my lords, before the parliamentary subcommittee, they are only saying, my lords, regulated activity is not access. Regulated activity is, my lords, commercial utilization. Therefore, my lords, putting embargo at the stage of, my lords, taking approval or giving intimation that at the time of giving intimation itself you should pay is wrong, my lords. And subcommittee report is also had
You are
given
there
its
in
parallel
this?
funding.
I appear in one of the matters.
Oh.
Yes.
Because I appear in 46.10.
In addition to what he said,
Please, I'll just add 2 more points and Milords. Not 2 things, Milords. First thing, Milords, now the penal provision has been decriminalized, which was subject to challenge. Milords, your lordship has elaborately considered in TV9 judgment.
Yes.
Milords, how it has to be interpreted. Milords, there is one more judgment of the Honorable Apex Court, Milords, on interpretation of statutes, which says if the amended provision, Milords, marches towards decriminalization, even the pending offences, Milords, I'll just give it, ma'am.
Kodi, yes.
Milords, the pending offences also, the interpretation of the courts should be in tandem and march along with the amended provisions, my lords. That would make my case, my lords, decriminalize, my lords, which makes it liable.
All right.
Great.
Yes. Not reserved. Yes. Ellardu hakbidi. Reserved. Yes. We'll see. ನೀವು ಯಾರಿಗೆ objection, sir? Yes.
I may be permitted to give a note, my lords.
Please.
Great.
If my lord's permit, will file a brief synopsis.
Further hearing 112.
Cell number 51 also is passed over, my lords. A CBI matter, which my lords had indicated that my lords would be reserving it. 51, my lords. Senior counsel Sandesh Chowda is appearing. Couple of submissions to be made.
My lords may recollect.
Last time ಮಾಡಿದ್ರಲ್ಲ submission.
ಇಲ್ಲ ಇದರಲ್ಲಿ interim order ತಾವು ಕೊಟ್ಟಿದ್ರಿ statement of objection ಹಾಕಿಲ್ಲ ಇನ್ನು pleadings are not complete but they try to point out that issue based res judicata this has been considered at the time of investigation.
That's a submission. That's
yes,
not.
my lord, but the 4 points, my lords, which have been raised now are events which have taken place subsequently, my lords. The first issue that has taken place now is, my lords, at the time when the challenge took place, the account had been declared as fraud. Investigation.
That is now quashed.
Now that, my lords, a coordinate bench has set aside. So even if we go by their own circular, my lords, if the fraud circular goes, the criminal proceeding won't lie. That is one aspect as a change in circumstance, my lords. Now the second aspect was at the time when it was challenged during investigation, it was against an unknown public servant and also for the PC Act. So a contention was taken if you have not named the public servant, then how do you proceed against him? My lords was pleased to observe that it is still at the stage of investigation. At this stage, that contention you can't take up. Now a charge sheet is filed against 5 individuals, private individuals, my lords, 2 companies, 3 individuals, and the cognizance which is taken is for 420 and 120B against individuals. So now we don't even have a public servant. We neither have the PC Act, my lords. That was the second aspect, my lords, insofar as change in circumstance which has taken place. Now the third aspect, my lords, wanted to know about CBI by virtue of the circular referring it to the, bank referring it to the CBI for investigation. My lords had held by virtue of section 35
That
of the
35A.
My lords, 4 developments that have taken place after that, my lords. One is the division bench ruling
Of what?
of, my lords, the Madhya Pradesh High Court on the very point of saying, on the basis of that circular, could you have complaints registered? They again fall back, my lords, on the same coordinate bench, how coordinate bench has viewed it, my lords. There the argument before the coordinate bench was 2 known methods under which CBI gets power and jurisdiction. One is, my lords, under the Act. 5 and 6, my lords, conferring power and jurisdiction to investigate. Second is the constitutional court's power to refer it to CBI. These are the only 2 modes known, my lords, under which it can be conferred. The third mode, my lords, which has been done now through this circular, RBI conferring powers to the CBI. Now, my lords, the answer to that is under the Banking Regulation Act, RBI can't confer powers to the CBI. That was the line of argument, my lords, by which the coordinate bench and also now the division bench, my lords, of the Madhya Pradesh High Court would hold that CBI, they won't get power and jurisdiction merely because the bank refers it. This is the aspect. And that even my lords had an occasion to consider in Union Bank of India.
Correct. Al 35A alli, what was 35A
They
alli?
asked
It
for
should
a
be
transfer to the CBI, my lords. touched upon 35A, pointed out it is a circular, you can't confer
No,
jurisdiction.
I did not say about circular. I said 35A does not confer any power.
I'm sorry.
That's all. No circular reference in that.
So 35A does not give any power is what my lords held. So these are developments which have taken place, my lords, post my lords order, my lords, on
Is
the
CBI a party here?
CBI.
Please, my lord, this was the matter your lordship was pleased to
correct.
reserve in the
Madhyana.
morning.
Which is the last one. And here R2 gave, bank is still not represented, my lords. They set the law in motion by giving it to CBI.
That's
So
all right,
reading was not complete.
Hmm.
That's the reason probably colleague asked for time, my lords.
And Samparit.
So, my lords, 4 points. It is not issues which are res judicata, but issues which now, my lords, have opened up in view of the developments that have taken place, my lords.
Lords, what my learned friend has argued, senior friend has argued, Lords, the same argument was canvassed in the earlier round. Lords, on the same issue of 35A, power of the RBI to hand over investigation to CBI by virtue of master circular, your lordship was pleased to negate it. Lords, that binds the petitioner, both by virtue of issue estoppel and by res judicata. Lords, insofar as the coordinate bench's judgment is concerned, my lords, I brought to the attention of your lordship how it was interpreted and how, my lords, your lordship intended, your lordship had put across in the morning forenoon session. No, your lordship said that it was for the bank which did not have the power, not the CBI.
No, both have gone to the Supreme Court. Bank has gone,
Yeah,
CBI
both
has
of them
gone,
have
my lords.
gone.
Only notice is ordered, no stay of
One
this.
distinct.
But that has a catastrophic
Yes, but
effect.
lot of, if that is accepted, lot of cases which has been instituted on the complaint given, my lords, may have to go. And precisely, my lords, precisely it went on the issue of power and jurisdiction of CBI. Now, if power has to be given to CBI, my lords, it has to be given under the Delhi Special Police Establishment Act itself. RBI can never confer power. That was precisely the argument there. RBI is conferring power to CBI, which cannot be done, my lords, even in view of the lists or schedules under the constitution. How would RBI give it? It's the central government which has to give power to the CBI. This was the argument, and this was the argument that had been accepted, my lords. And now it is pending consideration in Supreme Court on this point.
We'll see. Yes, you make your submissions.
At least the pleadings, my lords, if
Let
they file
that
their
complete.
objections, I will know what their
Correct,
stand
yes.
is.
List the matter on 28th for further hearing at 4 p.m. Objections, if any, by the CBI by then. Emergent notice to the
Bank.
respondent. Agide, notice
How
agide.
do, they've not yet come.
We have paid the process.
Process paid. Process. has-
When?
No, your lordship
Today.
I don't know what this.
ಮತ್ತೆ?
Either. I will check it. I'm sorry.
Lordship may grant us the liberty to serve to the bank. We'll just
You serve, no problem. ನಿಮಗ್ ಕೊಡ್ಬೇಕಾ?
Allah, we'll intimate the bank.
No problem. Yes, petitioner shall also serve on any panel advocate representing. Which bank is this?
Union Bank, my lords.
Union Bank of India. Yes.
In Madhya Pradesh, it was UCO Bank, UCO, my lords. They did the same thing and then it was quashed. The charge sheet was quashed on that score.
We'll see. Yes.
Deeply obliged. my lords.
Right.
Further hearing 112.
Even the interim order to be extended.
That will continue. SPP ಅವರೇ ನಿಮ್ದೆ.
UAP Act. Wanted to invoke UAP Act. The session judge has set aside saying that it is not under.
ಯಾರು ಬಂದಿದ್ದಾರ? ನೀವೇ. Awaiting the appearance of the respondent. Heard the learned SPP awaiting the appearance of the respondent next Friday. 21st. Already, sorry, 20th.
113.
That's appear for the
ಏನಿದಲ್ಲ
petition.
ವಿನಯ್?
This is a DRDO dog matter, your lordship.
Dog.
I need to go on that.
What has happened?
Lordship on the last occasion had directed that
Investigation is on.
Yes.
charge sheet be filed before your lordship before. any-
ಗೊತ್ತಾಯ್ತು. ಅದು ತಗೊಳ್ಳಿ ಮಾಡಿ. That's a report. Report is ಕೊಡಿ. Let me see this.
One we have left.
Huh?
One we have left. Against two others there.
ಇನ್ನು ಯಾರನ್ನ ಬಿಟ್ಟಿದ್ದೀರಾ, ಯಾರನ್ನ ಮಾಡಿದ್ದೀರಾ?
I think there's no charge sheet against one matter.
2 and 3 are.
There are two petitioners before your lordship.
Against accused number 2 you have?
I think two.
The cleaning supervisor. All right. Let it be filed before the court.
Yes, we have not.
ನಿಮ್ಗೆ
We don't have a report.
ಅಲ್ಲಿ ಸಿಗುತ್ತೆ.
Your Honor, I have.
No impleading applications is not a PIL. I told you in the last occasion itself. Yes.
Lordship permit us, my lord, we'll file it.
The petitioner, this court on 23/6/2026 had passed the following order. Pursuant to the order passed by the court, the investigation has now been concluded and the accused number 2, the petitioner number 2 is drawn as an accused. File madli or you challenge it if you want to.
Yes.
Lordship,
The-
that accused number 2, I'll not press with regard to accused number 1. Your
One,
lordship,
they have not even charge sheeted. So 1, 2 is liable, let 2, whatever.
If I want to file a protest, I'll do that there under 175(3).
my request.
ಅಲ್ಲ, ಅಲ್ಲಿ
I'm told it's a highly diluted charge sheet is what I've been informed
May I
about.
ಇದು diluted.
But that is only in voluminous, but the sections have all been deleted
Lordship,
is what I'm told.
my request, your lordship, is insofar as accused number 1 is concerned, since there's a statement made before your lordship that they dropped in the charge sheet.
ಅಲ್ಲ, charge sheet ಇದೆ ಇಲ್ಲಿ. They let them file the charge sheet.
So let that be recorded, qua accused number 1, the proceedings may be
Let
dropped.
let
Accused
you
number-
file the charge sheet. The charge sheet be filed before the concerned court. The
Get it filed tomorrow itself.
contents of the charge sheet, but I'll take it on the next occasion.
Please.
Unlike, I'll take it on 20th.
Please.
List the matter on 20th. By the charge sheet be filed before the concerned court. Will not record anything. Next time we'll see. By then you will also get the copy.
In the same stage, may I request the same stage?
Oh, for the hearing, very much.
Deeply obliged.
114.
Hearing for the respondent.
Appear for the appellant.
Has to.
Oh,
Because the,
ಯಾವ್ದಿದು?
but RFAs.
ಈಗ ಹೋಗ್ಬೇಕಲ್ಲ ಅದು. Now I have no. In terms of the
We were also
order so
waiting-
and so, let it
We were
be.
also waiting, my lord, to see whether, but unfortunately.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Me taking it now will be dangerous.
No, that we cannot. my lord.
Yes, madam, ಅದೆಲ್ಲ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದಾರೆ ಅದು ಮಾಡ್ಬಿಡಿ. Same order. We'll close it.
It has to go to the district court. my lord,
ಅದೇ what the courts have been
No, no,
are
Nelamangala.
passing, same order will pass. Yes, sir. Heard Land Senior Counsel Srinivas Raghavan. Yes. Next. Now come to
Serial number 6, my lord, your lordship passed over. For me to get records.
ಅಲ್ಲ 6 ಅಲ್ಲ ಇವ್ರದ್ದು ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ. I think you have to look into that and let me know.
2 applications rejected.
Huh.
One is allowed, one is rejected.
Partly, we just wanted all the evidence.
ನಾಳೆ ತಗೊಳ್ಳಾ? ಮಂಜುನಾಥ್, ನಾಳೆ ತಗೊಂತೀನಿ.
The serial number 6, my lord, your lordship passed over in the morning.
6 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲ?
Second list. ಅದ ರೆಕಾರ್ಡ್ಸ್ ತರ ಕೇಳಿದ್ರಿ ತಾವು.
ಹಾ, ಏನದು?
ಅದರಲ್ಲಿ nothing, there is no records because the investigation has not been taken up. The issue, my lord, is that the DC has given a permission for complainant to excavate the sand, and the village people have an objection to it, and these are the villagers.
ಅದು ಸ್ಟೇ ಕೊಟ್ಟಿರ್ಬೇಕು ನಾನು.
Let's take it.
If DC has given permission, now what can be done?
No, that is, they, in fact, my lord, petitioner.
How can you blame them, Mantha?
No, because they are coming and obstructing the complainant to excavate the sand. That is causing a nuisance.
Allah, if permission is not granted in accordance with law,
It is granted.
then produce everything.
I'll produce it.
Get the records.
Yes.
Get the entire records next Tuesday. Yes, fresh matters. Continue, ma'am. ಏನಿದೆ?
Orders 63.
16?
Krishna, my lord.
Chamber. Yeah, NVJ.
66.
Seeking direction to the passport authority to renew my passport. ಇಲ್ಲಿ ಐಎ ಹಾಕಿದ್ದೀನಿ, ಐಎ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಐಎ ನಲ್ಲಿ ಪಾಸ್ಪೋರ್ಟ್ ಆಫೀಸಿಗೆ ನಾನು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕು ಸರ್. ಐ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಪರ್ಮಿಟೆಡ್.
ಇಂಪ್ಲೀಟ್ ಮಾಡಿ ಫಸ್ಟ್ ಮಾಡಿದ್ರೆ ತಾನೇ ಆಗೋದು.
ಪರ್ಮಿಷನ್ ತಾವು ಪರ್ಮಿಷನ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಬಂದಿರೋದು.
ದಿ ಅಫೆನ್ಸ್ ಏನು?
341.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
ಮಕ್ಕಾ ಮದೀನಾಗೆ ಹೋಗೋದಿದೆ. ಇಬ್ರು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and 7
ಹೋಗ್ಬೇಕು ಎಲ್ಲರೂ?
ಇಲ್ಲ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and 7 ಮಾತ್ರ ಅಷ್ಟೇ ಪಿಟಿಷನರ್ಸ್.
The petitioner shall implead the regional passport officer as a party respondent to these proceedings. The petitioner to amend the cost. Eagle madi. Amend the cost rate.
I may also be permitted to correct the name of the petitioners in the main cost title.
Main cost list.
ಇದು NOC ಮ್ಯಾಟರ್ ಇದು ಹಾಫ್ ನೇಮ್ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. as per charge sheet ಹಾಫ್ ನೇಮ್ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಹಾಫ್ ನೇಮ್?
ಹೌದು, ಅರ್ಧ. ಮೊಹಮ್ಮದ್ ಸಮೀವುಲ್ಲಾಗೆ ಸಮೀವುಲ್ಲಾ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಎರಡು ಪೆಟಿಷನರ್?
ಎರಡು ಪೆಟಿಷನರ್ಸ್ ಇಬ್ರು.
ಸಮೀವುಲ್ಲಾ ಅಂತ ಒಬ್ಬರೇ ಇರೋದು?
ಮೊಹಮ್ಮದ್ ಸಮೀವುಲ್ಲಾ ಒಬ್ಬರೇ ಇರೋದು, ಒಬ್ಬರೇ. ಅವ್ರ ಹೆಸರು ಮೊಹಮ್ಮದ್ ಸಮೀವುಲ್ಲಾ. ಇನ್ನೊಬ್ರು ಆಫ್ತಾಬ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಹಿಸ್ ನೇಮ್ ಇಸ್ ಸೈಯದ್ ಆಫ್ತಾಬ್ ಆಸ್ ಪರ್ ಪಾಸ್ಪೋರ್ಟ್. ನಾಳೆ ಪಾಸ್ಪೋರ್ಟ್ ತೊಂದರೆ ಆಗ್ಬಾರ್ದಲ್ಲ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ಅದಕ್ಕೆ? ಇಲ್ಲ ಮೆಮೊ ಹಾಕಿ, ಏನಾರ ಒಂದು ಹಾಕಿ.
ಆಯ್ತು, ಮೆಮೊ
ಓರಲ್ಲಿ ಕೇಳಿದ್ರೆ ಆಗಲ್ಲ. ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ.
ಕೊಟ್ಟಿದ್ದೀನಿ, ಡಾಕ್ಯುಮೆಂಟ್ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್, ಅನೆಕ್ಷರ್ ಮಾಡಿದ್ದೀನಿ. ಪಾಸ್ಪೋರ್ಟ್ ಎಲ್ಲ.
ಎಸ್, ಅಮೆಂಡ್ ಮಾಡಿ ಮೆಮೊ ಕೊಡಿ, ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
A2 is before your lordships. A1's petition.
Vacating stay.
Vacating stay.
Yes, sir.
A2 is before your lordships. A1's petition must be tagged.
Must be tagged. Kodi ಏನು?
Arising from the same charge sheet. Madam.
The registry to tag number kodi, Samir. Who has moved the matter? Nivena. Vacating stay da. Learned the registry to tag so and so along with criminal petition and list them both on Tuesday the next and to in the same stage.
Tuesday,
Yes.
Wednesday or Thursday?
Wednesday in the same stage. Yes, next.
Interim order.
That will continue. Yes, next.
For the petitioner, my lord, I have not received the copy for vacating stay and objection, my lord.
What's the offense?
199, 324, 352. In the court below, my lord, the petitioner is the plaintiff and the
Scientist.
plaintiff, my lord.
Plaintiff.
Civil matter.
Statement of objection copy.
Vacating stay? Counsel for the respondent serves the copy of the application seeking vacation of the interim order and the objections. Next Tuesday, same stage.
Much obliged.
Next.
69.
For the petitioner in this case, my lord, both in this matter, petition number 1 and respondent number 2 has settled the dispute.
Offense ಏನು?
490.
49.
Yes, ಕೊಡಿ. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಆಗಿದೆ ಸರ್.
490 ಎಲ್ಲಾಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
Before ಆಗಿಲ್ಲ, ಇವಾಗ ಅವರೇ ಔಟ್ ಆಫ್ ದ ಕೋರ್ಟ್
ಎಲ್ಲಿದೆ ಕೊಡಿ, ಜಾಯಿಂಟ್ ಮೆಮೊ ಎಲ್ಲಿ? ಸುಮ್ನೆ ಹೇಳಿದ್ರಾಗಲ್ಲ, ಫೈಲ್ ಎ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರ?
ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮೇಡಮ್ ಇವ್ರು HR ಅಲ್ಲ, HR ಮೇಡಮ್, ಈ ಪ್ಯಾರಾ 7 ಆಮೇಲೆ ಪ್ಯಾರಾ 7 ಇಂದ 2 ಪ್ಯಾರಾ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಸಾಕು, ಮಾಡಿ ಕ್ಲೋಸ್. ಎಸ್.
Today they have handed over.
Today we are paying rupees 10,50,000 to the petitioner, respondent number 2, my lord.
Yeah, last al bariri, the learned counsel for the petitioner hands over a demand draft of rupees 10,50,000 to the respondent.
Number
who
2.
Respondent who is present before the court. Close ಮಾಡಿ.
Remaining amount to the balance amount has to pay the MC petition.
ಇಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ, ಅಲ್ಲ, ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿದೆ?
In 12 lakhs rupees.
Another 12 lakhs, the learned counsel for the petitioner undertakes to pay it before the authority. Sorry, before the concerned court. Yes. Next.
Order sheet. Sir, order sheet. 70 withdrawal.
In terms of
71.
stay. ಏನ್ ನಾಗರಾಜ್ ಸ್ಟೇ ಇದೆಯಾ?
ಹಸ್ಬೆಂಡ್ ಗಿಲ್ಲ ಮಲಟ್ಸ್.
ಹಸ್ಬೆಂಡ್ ಕೊಡಲ್ಲ ಸರ್.
ಮಲಟ್ಸ್ ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಆಗಿದೆ ಮಲಟ್ಸ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಮಲಟ್ಸ್.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಮಲಟ್ ಎಸ್ಟರ್ಡೇ ದೇ ಫೈಲ್ಡ್ ಮಲ R2 ದೇ ಫೈಲ್ಡ್ ವಕಾಲತ್.
ಏನ್ ನೀವೇ ಎಲ್ಲ ನೋಡ್ಬಿಟ್ಟಾಗಿದೆ?
ಮಲಟ್ಸ್ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗಿದೆ ಮಲಟ್ಸ್. ಮಲಟ್ಸ್ ಐ ಜಸ್ಟ್ ಹ್ಯಾವ್ ಟು ಪಾಯಿಂಟ್ ಔಟ್ ಒನ್
ನೇಮ್ ಹೇಳಿ, ವಕಾಲತ್ ಹಾಕಿರೋದು ಯಾರು ಅಂತ.
ದಟ್ ಐ ಡು ನಾಟ್ ನೋ ಮಲಟ್. ಇಟ್ ಶೋಸ್ ಓನ್ಲಿ R2 ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಮಲಟ್ಸ್. ಈ ಕೋರ್ಟ್
ಆಯ್ತು, ನೋಡ್ತೀರಾ ಮೇಡಮ್? ಎಂಟ್ರಿ ಮಾಡಿದೆ. ಎಸ್.
in-laws it is there.
In-laws ಇದೆ 2 weeks IO. Next.
Malots, any date may be given.
ಬೇಡ, ಬರ್ಲಿ ಬಿಡಿ.
72.
72 and 72.1. What happened?
72.2 ಅಲ್ಲಿ
72.2 ಬೇರೆ ಇದೆಯಾ?
There are 3 items. 72 is the recall. 72.1 is the dictation order in that ROC case. And 72.2 is just for the perusal of the court, because I have to take this court to the pleadings in that matter for arguing that recall application in 72. So Millard may kindly.
It is just or what, Millard? Prayers may be seen, but there is one more submission. We were little hesitant to make that submission. In that matter, which are all connected as her own statement, my lord was pleased to make a submission on the, make a note that this matter be listed before some other judgment. I don't know why that has
Which
happened.
one?
Millard, that matter.
332 of 24.
I have made that order.
Yes.
Millard, what has happened is, Millard, I'll explain. Millard, Justice Uma has passed that order. I'm not seeking recall of that. I'm not pressing that recall application here. That matter I have sought tagging only to demonstrate from that pleading, to demonstrate that my lords have quoted in your lordship's order certain portions. So to demonstrate that only, the pleadings in that petition have to be shown. And that I cannot demonstrate otherwise.
Which one is 72.2 is it?
I'm not seeking any education
No, have I
on
said
that.
72.2 to be posted before any other?
Yes.
Why?
No. Earlier, my lords had recused in that matter.
Then
so
how
that,
can I hear it
No,
now?
I'm not seeking any adjudication on that. Only to demonstrate that this was the prayer in that petition to argue my 72, item
Friend is
72.
appearing in that matter.
I make a statement that I'm not seeking any adjudication on item 72. 72.2.
No, you may produce any pleading by way of a memo or whatever, but not the petition itself in which I have said not before.
Then my lords, my detail, no issues.
Other pleading, you could have always produced it along with the
But
memo.
the prayer and the entire pleading.
Whatever
of that
you could have
petition.
produced, why
Very good,
petition
I'll
to
do
be
that.
tagged?
I'll do that, my lord. No issues. My lord,
Yes, sir.
may record my statement to that effect, that I'm not pressing any hearing on that.
No, but let it not be listed along with that, and once I have said that and not taking it again.
Very.
on 4/9/2024.
My lord, my lord,
So
even on the previous
let her
occasion, my
not
lord, I
press
had
this application,
mentioned it.
Not press this application for recalling. Then it will be closed.
This is already disposed, is it?
It is
Even-
disposed.
Even otherwise, my lord, that because it is Justice Uma's order, so it has to even otherwise go to someone else or a special assignment or
Because I've
otherwise.
already said not
That's
before,
what-
let
that's
it
what-
not come before.
No, no, that was not the intention at all, my lord.
No, that's all right, but
Yeah, not.
whatever, not intention,
Let's be detailed, no issues.
whatever. This court in WP, in the subject, ಇದು ಯಾವ್ದು ಗೊತ್ತಾ madam? WP 14332 of 24 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ, 72.2. The subject petition is now disposed. Prior to its disposal, the court had, this court had observed that the matter be posted before any other court. The matter was posted before Lordship Justice Uma, and the matter has been disposed. Now recalling of the order cannot be done by this court in the light of the order dated 4/9/2024. If the remedy, if the petitioner is wanting a recall of the order, it should be posted before any other court.
My lord, my submission to that effect, that I am not pressing any recall before this court, may kindly be recorded. I have, my lord said
No,
directed on the
even
previous
hearing
occasion.
that matter is ahead.
No, not hearing, my lord.
Then why is it brought here now? It is
My lord-
recall and correction of the order dated 19/1. There's an application.
My lord, there is an application, but I'm not pressing that. And on the previous occasion, my lord had not directed tagging. Your lordship has only directed that matter be placed along with those petitions.
But this has come
And
now.
the sole intention was that because Justice Uma in her orders says something which has to be demonstrated from the petitions or pleadings on record, and my lords have relied upon that order. So just for the purpose of demonstration, nothing else. So
No, let this
and
not
I
be
myself
tagged.
would have, when your lordship would have
Correct,
called.
you would have filed a memo along with it for the pleadings or whatever. Recall, I cannot do it. Let
No,
any
no,
other court.
I'm not at all pressing for that. I understand that, madam.
Yes.
Thanks.
Now,
My lord,
what about 72.1 and 72?
My lord, 72.1 is the dictation,
Ah.
that ROC matter. My lord said specifically posted this matter today is for dictation.
Then you'll have to wait
Very
till the end of the board.
Very.
Yes.
No. Obliged.
Then 72.2 I may.
72 point order madadnalla ಈಗ ಇವೇನಾರು ಮಾಡಿ.
He can,
Yes.
he is discharged.
This is yes. Post immediately after service of notice upon the respondent.
Interim order.
That will continue.
Please.
24,
Same order.
75,
74 line, ಯಾರು ನೀವಿದ್ದೀರಾ?
Respondent number 2.
Learned counsel,
Filed,
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದೆ.
name code.
Learned counsel so and so submits that she has entered appearance for the respondent registry to print the name of so and so is appearing for the respondent. Then what's the matter?
Lordship, it is falsely implication of the press reporter in the atrocity case, my lordship. Lordship, granted interim order earlier date, my lordship.
All right. File your vacating stay, madam, if you want to. Yes, 2 weeks IO.
Please, my lordship.
Objections, if any, by the next date. Next.
75,
This matter was directed to be listed on 19th.
For the
This matter had
petitioners,
come up yesterday. Kitty party,
ನೆನ್ನೆ ತಾನೆ. 19th ಅಲ್ಲಿ ಹೇಳಿರಲ್ಲ ನಾನು.
19th.
Your,
Please, my lords, because it's inconvenient for me also today, my lords.
you also, ನೀವು arbitration na?
How's my lords? My senior is engaged.
Let him be there only. High court is important or arbitration is important?
Because my lords, it's a.
Where petitioners here, respondents ಎಲ್ಲಿ?
Well, I'm ready for the matter.
Hmm.
Well, a similar complaint was registered by another complainant. My lordship was pleased to direct that matter to be investigated by
Pay
CID.
ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
My lords, may
I will
kindly have
dismiss
on
it otherwise.
20th. Kindly have it on 20th, my
It was
lords.
a very subtle way of taking adjournments that I will not.
No, my lords, that is not the.
List the matter on
Intent, my lords.
19th.
My lords, may kindly have it on 20th. 19th.
No, 19th in the fresh matters list. In the event there would be no submissions made
My
by
lords, the
any of
only
the
reason
council.
I'm saying is 20th because.
You
until
get ready, sir.
On 17th.
Any of
to
the
19th,
council, the interim order would stand automatically
My lords,
vacated.
may only entertain one request. Kindly have it on 20th or any date thereafter after 19th, my lords.
No,
Because
no,
19th
yes.
is only one date is inconvenient. My lords, because senior is.
18th.
No, my lords, 17th, before 17th or after.
I am surprised you're choosing the dates. I'll vacate the interim order right away.
My lords, please. my
Nothing
lords.
doing. 19th, if you want to come, come. Otherwise, I'm going to vacate the interim order.
Please.
Next. ಎಲ್ಲಾರು ದುಡ್ಡು ಇಸ್ಕೊಂಡ್ಬಿಡೋದು ವಾಪಸ್ ಕೊಡಲ್ಲ ಇಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳೋದು. Yes.
76,
Lord, office objection, my lord. Lord, production of order sheet ಅಂತಿದೆ. Page number 87, my lord. Annexure D. ನನಗೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಸ್ ಪರ್ ಸೆಕ್ಷನ್ 99 ಐ ವಿಲ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಟು ದ ಸೆಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಂತ.
ಒಂದ್ ನಿಮಿಷ, ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
The acknowledgement my lord from the junior
For what?
justice court. I had requested
Office
for
objections overruled Monday, fresh matters.
one sambal
Urgency
submission.
ಉಂಟಾ?
ನಾಳೆ ಚಾರ್ಜ್
ಆ ಟೈಮಲ್ಲಿ ಯಾಕೆ ಹಾಕ್ತೀರಾ ನೀವು? ಇಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇರ್ತೀರಾ?
ಅಪಾಲಜಿಸ್
ಚಾರ್ಜ್ ಬಂದಾಗ ಅರ್ಜೆನ್ಸಿ.
ನೋಡಿ ಇದು ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್.
109 ಸರ್.
ಇಲ್ಲ my lord, it's not 109.
ಏನಿದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ?
115 sub clause 1 190.
118 ಬಿಟ್ಟಾಗಿದೆ.
118 is for 1 to 7. I am J8 in this case.
You are 8?
Yes. In the covered by idem my lord, it might be allowed. My lord, another submission my lord.
Covered by ಯಾಕೆ sir? On what ground?
It is a petty offense my lord. Less than 1 year ಇದೆ. And another thing my lord, the other accused 1 to 7 in the CMM court, they have already pleaded guilty. I received this instruction this morning my lord. That is the reason I didn't get the certified copies, but on typed copy ready ಮಾಡಿದೀನಿ ಆರ್ಡರ್ ಏನಿದೆ.
ಓ ಇದು JJ Act.
JJ Act.
Oh, what is a petty offense and other things? Yes. Yes. Yes, madam.
ಕಾಲಿನಿಂದ ಒದ್ದು ಅಂತ.
That is all.
Allegation.
ಆಯ್ತು, it's a petty offense. It can't be tried for the board. Will covered ಅಂತ close ಮಾಡಿ.
My lord, one submission.
Complainant ಯಾರು ಇವರೇ ಅಲ್ಲ?
ಇಲ್ಲ my lord, ಬೇರೆ
Then complaint ಬರ್ಲಿ.
My lord, he is a student. They have already pleaded guilty. He may not come also my lord if any date is fixed.
Complainant is also a student.
No my lord. He is not a student.
Then tomorrow without hearing the complainant it is
agree,
quashed ಅಂದ್ರೆ.
I'll leave it to the court.
Entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ my lord.
Office objections overruled. Insofar as the present petitioner accused number 8, juvenile number 8 is concerned, the issue stands completely answered by judgment rendered by this court on February the 3rd, 2026 in criminal petition 6143 of 2023. Therefore, awaiting the appearance of the emergent notice to the complainant returnable by 28th, there shall be an interim order of stay of all further proceedings by the petitioner till the next date of hearing.
Submission my lord. I'll carry out amendment in the prayer my lord. ಅದು mix ಮಾಡಬಾರ್ದು ಬಿಡಿದ್ದಾರೆ. It is only for J8.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
Grateful.
Next.
77.
My lord, I seek my lord, your lordship's indulgence my lord, to appear through VC. Split up as against A3 to A5 my lord, split up my lord, have produced the entire judgment on the ground that material evidence is not being examined.
Offense ಏನು sir?
My lord, 399 402 sumoto complaint. Sumoto complaint.
The petitioner is before the court calling in question. Will pass an order day after tomorrow.
Please.
Yes. Day after tomorrow in the fresh matters list, office objections overruled. Yes.
Please.
78.
Yes, Sunil. ಏನಿದು?
This is the dispute in the Codes family my lord.
ಅದೇ 4-5 ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಎಲ್ಲಿ?
Yes my lord. Plus in this matter my lord.
There are 5 matters pending.
Other
Supreme
matters
Court ಏನೋ adjourn
Supreme
ಮಾಡಿದ್ನಲ್ಲ
Court,
ನಾನು?
my lord, not regarding this matter. That's regarding some other partnership dispute, trust matter.
Criminal and
All
civil
civil
both will
matters.
get closed ಅಂತಾನೆ ಇದೆ ಅದರಲ್ಲಿ.
Even my lords in the bail cancellation matter, they themselves made the submission before the honorable.
ನೀವು ಈ ಕಡೆ ಇದ್ದಾಗ
In the
ನೀವೇ
bail
ಮಾಡಿದ್ರೆ.
in this case, bail was granted. We have moved the Supreme Court for cancellation, where we appeared and we submitted, my lords. As far as cancellation, the bail is concerned, this may be taken up.
Supreme Court order ನಾನೇ ಕೋರ್ಟ್ ಮಾಡಿ ಮೊನ್ನೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ದೀನಿ.
That's a different.
ನೀವೇ ಈ ಕಡೆ ಇದ್ರಿ.
No, I was not.
You are not.
After the direction of the
No,
honorable
this is
Supreme
for
Court,
quashing.
they moved it for cancellation
No,
of bail.
they are praying for
Unless-
quashing of the proceedings of A1.
Unless we are before
Where
this
my
honorable
this
court.
coordinate-
my lords,
ಇಬ್ರು ಹೇಳಿದ್ರೆ ಹೆಂಗೆ?
Please.
no, apologies.
Well.
Yes, now we are before this honorable court, my lords, not for pursuing this matter, my lords. Now mediation is going on before the Supreme Court, my lords.
ಹೌದು.
Now my lords, the trial court is insisting for the HBC in spite of the stay granted to by the stay granted to the co-accused by the Sessions Court, my lords. That's why my lords, if
ಯಾಕೆ why in hurry there?
ಇಲ್ಲ September 2nd ಗೆ HBC ಗಿರೋದು ನಾವೇನ್ ಹರಿಯಿಲ್ಲ. September 2nd ಗಿರೋದು ಇದು ಸರಿಯಲ್ಲ ಹೇಳಿ.
even my
Supreme
lords,
Court
they
ಅಲ್ಲಿ
are-
Supreme Court ಅಲ್ಲಿ ಯಾವತ್ತಿದೆ?
well, in Supreme Court, bail cancellation was on 2nd September, my lords. 2nd September. Sir only appeared before the honorable Supreme Court for cancellation of bail.
Yes.
HBC.
We'll take it another day.
Please, HBC
List on 24th in the fresh matters list.
Please.
Second ಗೆ ತಾನೇ ಇರೋದು next.
2nd September HBC.
Office objections overruled. List 24th fresh matters next.
Please. Would your lordship permit us to
ಅಲ್ಲಿ ಅವತ್ತೆ ಹಾಕಿ
respond number 2, my lord?
ಬರೋಂಗಿಲ್ಲ actually.
Please.
ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಲೇಬೇಕಾಗಿದೆ ಈಗ. There is no provision like caveat in
There's no
482.
provision, my lord.
Nobody should appear. If they
Even
appear,
bail matter
cost
also,
impose
my lords,
ಮಾಡ್ತೀನಿ.
we are not
Without
appear.
notice appear ಆದ್ರೆ cost impose ಮಾಡ್ತೀನಿ.
This one case.
Then caveat ಇದು.
No, caveat is
Then,
not there. Provision
not
for
there,
caveat
and
is
how
there.
can you appear?
That's what you.
Anybody, everybody I keep saying, now on I'll impose costs.
My lords, in their matter, we are not appeared, my
my
lords.
lords,
Even my
your
lords, they
lordship,
themselves.
That,
questions
I will,
there.
I will write that judgment and then,
victim can appear at any stage and also.
seriously.
Lords,
Yes,
they are-
sir.
they
There's
are
no
taking two
concept of
stands.
caveat here, sir.
No caveat.
Then how can you appear without even issuance of notice?
Victim can always.
Victim can come and seek vacation of the order, not stop the proceedings by, if there is a
if your
caveat, fine.
I will.
This is exactly what Sandesh Chowta also tried to argue when
No.
coming for the respondent. No.
On the
Because
Supreme Court
they
said
are
victim has
taking
every right. my lord, he
two
need
stands,
not.
my lords.
No.
They are before the Supreme Court and
He
before the mediator, my lords. So they are
No, this
telling
time
the
has come
mediation.
that I will write a judgment now. So
But
that
your
you
lords may
stop.
kindly consider this.
No, no,
Victim,
sir.
Supreme Court said
Victim can
need
appear,
not,
sir.
Stand outside and wait. He can participate in the proceedings.
Ah, no.
This is what Supreme
No,
Court says.
no,
We'll
no.
produce it.
Nothing. Yes.
Before Supreme
There's
Court,
no
my lords, it
concept
is-
of caveat. Yes.
It was adjourned because of their submission only, my
Yes.
lords. So we have also considered it.
trust
And my
matter
lords,
is
even
there.
before the
Our
magistrate
senior counsel
also.
Sandesh Chowta also had appeared once like this, and then he said, yes, there is no provision for caveat.
There's no provision.
Then.
No provision. But my lords, victim can always come and appear before the
You
court and
come,
place the
sir,
materials.
after the order, ಬಂದು ಹೇಳಿ vacating stay ಹಾಕಿ ಏನ್ ಬೇಕಾರ್ ಮಾಡಿ.
This question.
It becomes a caveat jurisdiction. If I go on hearing everybody, which jurisdiction the law does not confer, then.
Only on that, Supreme
Equity,
Court-
ನೀವು ಬನ್ನಿ ಅಂತ ಕೂತ್ಕೊಳ್ಳೋದು. No, no,
Oh,
sir.
no. Your lordship.
Nothing.
Please, we'll cancel. Grateful.
19.
Nine, 90. 79.
79. My lords, 353-2. During Ganesha festival, my lord, we installed the flex.
Office objections overruled in the meantime.
Great.
ಜಾಸ್ತಿ objection ಇದ್ರೆ wait.
Respondent number 2 age, my lord, is police officer. His age is not forthcoming in charge sheet also. His police officer, second respondent.
Police station.
RMC Harried is the police station. Yaradana word on the bitogide anta officer. I'll comply, my lord.
Comply with the office objections to be complied with Monday fresh matters.
Great.
Yes. Monday ಕೊಡೋಣ. First comply ಮಾಡಿ.
80.
My lords, there is a matter which is tagged and it is listed on 25th.
Let's tag along with so and so list on 25th.
My lords, in the main matter, my lords, serial number 80, your lordships on the previous occasion extended the interim order, but it does not reflect in the order sheet.
Interim order. First interim order ಕೊಟ್ಟಿದ್ದು date ಏನು?
In item 80, it's there.
Fast.
My lords, it was on.
19/6. The order dated 19/6/2026 shall continue till the next date of hearing.
25th.
Yes, next.
81.
Monday, fresh matters. Yes. Huh? Oh, 1 minute, 1 minute. FIR is from Tamil Nadu. Put it.
CCB channel.
SPP ಅವರೇ, ಇದೆ that Tamil Nadu case. Farooq.
Like he's withdrawn once and then come back.
Allah, he is the accused here. He is drawn as accused number 9 in this. Yes, Velan.
My lord,
You are
I'm
appearing for
in-
him.
No, my lord, no, I'm appearing in item 100 one.
He is now the accused number 9.
It is still, I think, it's the same matter.
Same matter. Same matter.
Withdrawn once before your lordship and then.
Yes, he has filed it here now. But the FIR is Tamil Nadu.
Again. Same with the same case.
Pass over. No, we'll send it. Ide agide. Yes, next. 82.
Tomorrow, my lord, he's on his legs, my lord, portal number 3.
Let him come on his legs here only.
For the respondent number.
Yes, Vijay Raj.
My lords,
82
I-
jete tag.
I have to file my objection.
82.1.
Last time also you told the same thing.
Covered, one date, serve ಮಾಡಿದ್ದಾರೆ, copy serve ಮಾಡಿದ್ದಾರೆ 30th.
Lords,
Just I need some time, my lords.
My lords,
Just
private
one 10
complaint
days,
referred
my
under
lords, because
156.3. I'll just
5144
demonstrate, my
they are
lords,
not
2
served the
minutes.
copy.
Private complaint referred under 156.3, my lords, there is no compliance of 1 or and 3. And there is no affidavit also, my lord.
No, my
2
lords.
minutes, I'll just point out.
No, I have filed the affidavit, my lords. Before the PCR, I have already filed the
Verifying
affidavit.
affidavit ಹಾಕಿದ್ದಾರೆ, my lords.
No,
Affidavit
so
Verifying
there-
affidavit.
covered.
ಬೇರೆ ಏನಿದೆ ಗ್ರೌಂಡ್?
My lords, 154, 1 and 3.
ಆಯ್ತು,
There
ಆಮೇಲೆ
is no affidavit.
ಆಮೇಲೆ
ಅಷ್ಟೇ, my lords.
ಅದು ಅಷ್ಟೇನಾ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಿಲ್ವಾ?
Covered, my lords.
What is covered? What is covered?
Ashok versus state.
ಯಾವುದು?
Ashok versus state, my lords. My
ಹಾ.
lords have laid down detailed.
All right.
I would just take 2 minutes to
Just
complete
point
the
out.
facts, my lords.
Yes, sir.
14/3/2017, I entered into sale agreement with the accused number 1 company.
Hmm.
On 31/3/2011, they entered into joint development agreement with one by name, with one company, Maneta Infrastructure Limited, who is none other than accused number 32 in the said complaint.
Hmm.
Now, in the said joint development agreement, the said accused number 32 has called himself, has referred himself as owner and developer.
Hmm.
Where because he is coming under the definition of owner,
Hmm.
whereas in the construction agreement that has been executed
Hmm.
with the complainant, my lords.
Hmm.
And thereupon, my submission before this honorable court and even before the trial court is that when you come under the definition of developer, you got the expertise in the field of development, real estate development, residential, commercial, everything. And when you are aware of the fact that the project shall not be completed on 31/12/2018,
Hmm.
you have entered into a joint development agreement
Hmm.
with the builder,
Hmm.
who is none other than accused number 1.
Hmm.
And thereupon, I had availed loan from State Bank of India.
Hmm.
Beginning with the-
You are a home buyer.
I'm a home buyer.
Ah.
I have a loan in the ratio 5:20:75. Then subsequently, the office bearers of accused number 1 company, they'll inform me to do the loan takeover with ABHFL Bank. I consider the request. I do the loan takeover with ABHFL Bank in the ratio 10:90, my lords. Now, all 90% amount, there is a nexus between the builder and the accused number 1. All the 90% has been dispersed, and the project is a standstill project as on today, my lords.
My lords,
There are Supreme Court judgments, even the recent judgment, Himanshu and others versus Union of India. There is, because when there is a nexus between the builder and the accused number 1, then the case has to be taken up because it is a public exchequer, my lords. Even if it considers 1 crore rupees ticket size of one flat, there are about 800 flats, my lords. It is about 800
No,
crores.
you are one home buyer.
I'm only, just out of the record, just I'm making a sub.
ಇಲ್ಲ ಔಟ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್ ಏನಿಲ್ಲ, ಎಲ್ಲ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂಡ್ ಲೈವ್.
ಆಗ್ಬೋದು on the record. Well, as I need some time to file all my objections because in 82.1, the landowner has.
ಯಾರು ದೀಪಕ್?
Yes, my lord.
Serve ಮಾಡಿಲ್ಲ, copy serve ಮಾಡಿಲ್ಲ.
ಕಾಪಿ
sorry,
ಸರ್ವ್
my
ಮಾಡಿ
lords.
ದೀಪಕ್ ಅವ್ರಿಗೆ.
Martin sir.
ಇದು ಟ್ಯಾಗ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3
3, my lords.
3 in list number 1 or list number 2 along with this 82 and list them all on 28th or saka
28 ಆಗ್ಬೋದು sir.
28th at 3:30 p.m. for further hearing.
Much of it.
Yes, interim order may be extended, my lords.
Objections if any by the interim order subsisting will continue till the next date of hearing.
Much of it.
Much of it.
Yes, next. ಬಂದಿದ್ಯಾ ತಗೊಳ್ಳಿ.
230 mood matters. Next matter. Number 1. Vishal Deske.
Permission, serial number 85, I'm withdrawing, madam. Same list.
85
List number 2,
withdrawing, yes.
and I may be permitted to file fresh challenging charge sheet.
In terms of, yes, next.
Appearing for petitioner in this case.
230 Mahmood matter.
Section 74 of BNS is the offense, my lord.
Section 74.
74, my lord.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ sir.
ಇಲ್ಲ ಅಲ್ಲ.
It's a case of civil dispute, my lord, given criminal color.
Why civil dispute, sir?
That's, the complainant is neighbor, my lords. ಮನೆ ಪಕ್ಕ ಆ ದಾರಿಯಲ್ಲಿ ದನ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತೇಳಿ ಅಲಿಗೇಷನ್.
ದಾರಿಯಲ್ಲಿ ದನ?
ಮನೆಗೆ ಹೋಗೋ ದಾರಿಯಲ್ಲಿ ದನ ಕಟ್ಟು ನಮಗೆ ಓಡಾಡಕ್ಕೆ ಅಡೆತಡೆ
ಹಸು ಸಾಕಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಎಷ್ಟು?
That I don't know, my lords.
ಏನು ಗೋಶಾಲೆ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ ಅಲ್ಲಿ?
Also, my lords, there is a delay of 4 months, my lords, in lodging.
ಹಸು ಕಟ್ಟಿದ ಮೇಲೆ 4 ತಿಂಗಳಾಗಿದೆಯಾ?
After the alleged
The main
incident.
time. Yes, next.
Great for me.
Number 2.
Yes.
Case correct.
No representation, dismissed. Yes.
Your Lordship, the complainant was a Tahsildar. He listens to some of the other persons in the
Listens
village.
to?
Yes, Your Lordship.
Ah.
There are two persons named Loki Gowda and B. Mayappa. ಇವ್ರು ಫೋನ್ ಮಾಡಿ ಉಳುಮೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿರೋದನ್ನ ಕೇಳಿಸ್ಕೊಂಡು FIR ಮಾಡಿದ್ದಾರೆ. They haven't even verified it ನಾನು ಮಾಡಿದಿನಾ ಇಲ್ವಾ.
Who is in possession of the property?
I am in the possession.
You are the owner of the property?
In WP number, sorry, ಸ್ವಲ್ಪ pass ಮಾಡಿ.
Tag same order.
15204 of W idrali. Now already we have asked the we have filed a writ petition seeking prayers. I have given a copy, Your Lordship.
Not to interfere.
Yes, we have already filed, Your Lordship. That is
In
still
the
pending.
meantime.
Great.
State. Office objection ಇದೆಯಾ?
ಇಲ್ಲ, Lordship.
Number 3, Jai Kumar Ji.
ಎಲ್ಲ ಜಿ ಈ ಕಡೆ ಆಗ್ತದೆ. ರಿಟ್ ಪಿಟಿಷನ್ KLR ಲಿಸ್ಟ್ ಬೇಕು ಮೇಡಮ್. ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬಂತು, ಕಾಸ್ ಲಿಸ್ಟ್.
ಕಾಪಿ ಕೊಡ್ತೀರಾ?
ಉದಯ್ ಕುಮಾರ್ ಜಿ ಹೇಳಿ.
This case, my lord, wherein which petitioner is an lease owner of the flat, my lord. We have been leased the flat to the complainant, provided he has not paid the amount as well as he has not given a portion of the flat, my lord. Under these circumstances, they have filed, complaint has filed a case and in which 420 has been invoked and it has been registered. Subsequently, in 138, I mean, he has issued a checks to the extent of that.
230 ಮೂವ್ ಮಾಡಿದ ಯಾಕೆ?
230 ಮೂವ್ ಮಾಡಿದ ಸ್ವಾಮಿ. ಅವ್ರಿಗೆ HL ಎಂಪ್ಲಾಯ್ ಆಗಿದ್ದಾರೆ, ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲೇನಿಲ್ಲ.
On HCGP to emergent notice in the meantime. Next.
Stay, my lord, in this case.
ಅದೇ ಕೊಟ್ಟಿದ್ದು.
Stay,
First time ಬರ್ತಾ ಇದ್ದೀರಾ ಕೋರ್ಟ್ಗೆ?
Enter. Much.
Yes.
Number 4, Sindhu HL.
In the meantime ಹೇಳು HR ಗೊತ್ತಾಯ್ತಲ್ಲ. In the meantime.
Petitioner, my lord, there was a commercial transaction between.
There was.
Yes.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿ.
And the agreement was for 1 crore, my lord. The duration was for 60 days. Even after the lapse of 60 days, he had paid only 55 lakhs out of 1 crore, my lord. So for money recovery suit, he has filed a OS suit.
ನೀವು ಹಾಕಿದ್ದೀರಾ?
No.
He has filed.
He has filed, and simultaneously he has filed an.
The respondent complainant is said to have instituted a suit in OS 7107 of 2022 for the purpose of recovery of money from the hands of the petitioner. Simultaneously has sought to set the criminal law into motion for the offence punishable under section 420 of the IPC. In the light of the civil suit, in the light of the proceedings, in the light of the criminal law being set into motion for the purpose of recovery of money which is already pending before the concerned civil court in OS 7107 of 2022, there shall be an interim order of stay in the case at hand till the next date of hearing.
Much obliged, my lord.
One
I may be
HCGP to
permitted
emerge.
give sheet, my lord.
ಅಲ್ಲೇ ಎಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ.
Yes, ma'am.
Number 5,
Much obliged.
Anand Bharvi.
Offenses 420, madam. This petitioner, madam, husband accused number 1, madam, has sold the property to the complaint in the year 2022, my lord.
Who is the complainant?
Complaint is the purchaser, my lord.
From the husband?
From this petitioner husband, my lord, accused number 1, my lord. She has not signed any document, my lord. The same property has been mortgaged by the accused number 3, my lord, to the Apex Bank, my lord.
Apex number 3 ಯಾರು?
Accused number 1 of the director, my lord.
Now who is your
wife of the accused number 2?
Your accused number 2.
Wife of the accused number 1, my lord.
Your husband has done it?
Yes, ma'am.
You are not the signatory to anything?
No, madam. I have not signed any.
What's your name?
Supriya Rajesh, madam. Sale deed is annexure AM C, madam. Objection, page number 21.
The counsel for the petitioner submits that the complainant is a purchaser of the property from the husband of the present petitioner. And the present petitioner, not being a signatory, is not aware of any of the transactions. Therefore, it is for the husband, accused number
1, my lord.
Accused number 1. And accused number 3 ಯಾರು?
One of the director, my lord.
Accused number 3 to answer the allegation and not the wife of accused number 1, the present petitioner, without being signatory or privy to any of the transactions. In that light, only against the accused number 2, the present petitioner, the proceedings shall remain stayed.
Number 6, Maltesh.
Offense number 69, 79.
4 o'clock, 2:30 hour proceeding is ಕಟ್ಬಿಡಿ.
Offense number 69, 79, 315 and 316. my lord.
ಯಾವ್ದು 6?
6, serial number 6. my lord.
ಏನು offense?
69, 79, 315 and 316.
ಎಲ್ಲ 9 ಏನಾ? 89?
The petition number 1, my lord, there was an affair between, my lord, the second respondent, my lord, petition number 1. My lord, when the petition number 1, my lord, came to know, my lord, the earlier affair of, my lord, respondent number 2. No, the relationship, my lord, is spoiled, my lord. Lakshmi kindly
Paused,
peruse- spoiled, my lord. The
Spoiled.
relationship, my lord, spoiled.
Yes.
On that basis, my lord, he lodged a complaint as per the page number 20.
There's a monetary transaction also.
Monetary
in the
transaction
issue.
is also, my lord, she has mentioned. In the statement, Lakshmi kindly see, my lord, in page number 23.
ಎಷ್ಟು ಇಸ್ಕೊಂಡಿದ್ದೀರಾ?
15 lakhs.
ಅಲ್ಲಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು 2,99,000 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನನ್ನ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ.
ಏನ್ ಹೇಳ್ಬಿಟ್ಟಿ?
ನನ್ನ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಮೈ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ದ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್. ಆಫ್ಟರ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ಶಿ ಲಾಡ್ಜಸ್ ಅ ಕಂಪ್ಲೇಂಟ್ ಕ್ಲೇಮಿಂಗ್ ಮೈ ಲಾರ್ಡ್ 15 lakhs. ಮೈ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 20.
ಅದು FIR ಆಗಿಲ್ವಾ?
ಅದು FIR ಆಗ್ಲಿಲ್ಲ. It's dated ಮೈ ಲಾರ್ಡ್
1 HCGP 2 emergent notice. There shall be an interim order of stay in so far as the offences under section 69, 79. In so far as other offences, the same would be considered after the appearance of the complainant. 1 HCGP 2 emergent notice. Next.
Please.
Number 7, Akash Bishop.
Offense under 316, 318 BNS, my lords. The parties are intending to settle and they are present before the court. My lords, there is another case, my lords, in serial number 111 of second list, my lords. It is also for reporting settlement. Same issue, my lords.
Yes.
Same crime number.
Erdu closed on account of settlement. Yes.
Second respondent filing wakalat, my lord.
Yes, next.
Order sheet signatures.
Number 8,
Thus appearing for the petitioner, my lords. Thus the petitioner is a visually impaired person. He was selected for the post of typist, my lords. My lords, a medical opinion was sought for, my lords, from the competent board. That is the Tumkur board, my lords, and it has given that he is 40%, there is a disability, my lords. Notwithstanding that, further medical opinions are sought, wherein there is some difference of opinion, my lords. On that, now they have filed, this is the second FIR they have filed, my lords.
First FIR ಯಾವುದು madam?
First FIR at page number 32, my lords.
ಅದೇನಾಗಿದೆ?
ಅದು ಹಾಕಿದೀವಿ ಮೊನ್ನೆ the other day your lordship said that you would dispose of the matter ಅಂತ ಹೇಳಿದ್ರಿ. ಆ 20th ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಅದೇ ಅವತ್ತೇ ಲಿಸ್ಟ್ ಆಗಲಿ.
My lords,
Tag this petition along with number ಕೊಡಿ madam. List on 20th in the fresh matters list.
WP.
Number. Yes, next.
Still number 9, CH-14.
My lords, there is threat of arrest in this matter.
Arrest?
How the phone ಮಾಡಿ they are unnecessarily troubling us.
Bail ತಗೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ, my lords.
Why?
They are unnecessarily calling upon me, my lords. So
Take
that
bail.
is the. ಅಲ್ಲ, is
This
the
is
visually impaired person.
complainant is high court, district court. ಅದಕ್ಕೆ. Certificate is a.
Let them not.
Certificate is a fraud. ಅಂತ allegation.
ಇಲ್ಲ.
Allegation.
My lords, kindly see page number 29, my lords. ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 40% ತುಮಕೂರು board, that's the competent board. If they're having any grievance under section 49, appeal is provided, my lords.
So you secured employment on the
I've
score.
not secured the employment.
When you participated in the interview?
Yes.
Appointment ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ ಇನ್ನ.
ಯಾಕೆ ಆಗಿಲ್ಲ?
My lords, that's what they're saying, that there is difference of opinions, my lords. One medical board, if it states that
crime
there is.
register ಮಾಡಿದ್ದಾರೆ ಈಗ.
ಹೌದು. My lords, kindly see the
List
earlier.
on 20th along with so and so, there shall be an interim order of stay of further investigation by the petitioners to the next date of hearing.
Much obliged.
Yes.
Number 9, CH-14.
This case for the petitioners seeking mandamus, my lord.
ಅಲ್ಲ ಯಾಕೆ 230 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
ಎಸ್ಟರ್ಡೇ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ ಇದು.
ಸೊ
ಅದರಲ್ಲಿ ವಿ ಆರ್ ಸೀಕಿಂಗ್ ಮ್ಯಾಂಡಮಸ್ ಸ್ವಾಮಿ. ಅದೇನಾಗಿದೆ?
ಕ್ವಾಶ್ ಆಗಿದೆಯಾ? ಕ್ವಾಶ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಕ್ವಾಶ್ ಆಗಿಲ್ಲ, ಅದು ಸ್ಟೇ ಅಂತ ಆಗಿದೆ ಸ್ವಾಮಿ.
CH-14.
ಸಾರಿ.
ನೀವು ಬೇರೆ ಶೇಷಗಿರಿ ರಾವ? No representation. List on Monday, fresh matters. Next. Atif, maintainability, second criminal petition.
Yesterday I withdrawn that first petition.
what's
That was
the matter?
challenging the affair. There
Then-
was an interim order, not the charge sheet was filed.
Offense.
Annexure key,
Offense.
non-cognizable offences, blood of section 115, 351, 352.
Very heinous, sir. How can we, interim order as, in the meantime, next. Overruled, office objection is maintainability stands overruled ಅಂತ ಮಾಡಿ ಆಮೇಲೆ in the meantime.
Till number 11, Venkatachalapati M.
Offenses 420, my lord. Petitioner has aged about 80 years, my lord.
80.
80 years, my lord. He is counting the days, my lord.
ಇಲ್ಲೇನ್ ಕೌಂಟಿಂಗ್ ನೋಟ್ಸ್ ಆಗಿದೆಯಾ ಮತ್ತೆ?
The allegation is that the complainant had purchased the site in survey number 114 situated at Adur village, Kerpur.
ಯಾರು? Who is the vendor?
Lord, when the RTC stands in the name of the petitioner, my lord, which is at page number 60.
ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ ಕಾನೂನು
He had executed a general power of attorney in favor of accused number 1, my lord.
You are drawn as accused number what?
I'm as accused number 4 in this case.
The petitioner is said to have executed a general power of attorney in favor of accused number 1, who is said to have sold the property in favor of the complainant, which has now become the subject matter of the list. The learned counsel submits that for an offense to become punishable under section 410, there is no transaction between the accused and the present complainant and the present petitioner. In that light, only insofar as the present petitioner is concerned, there shall be an interim order of stay. A copy of this order shall be issued only after compliance with the office objections. Yes.
Preliminary hearing, till number 12, Yatish Till.
Matter was listed yesterday, my lord. Really, we are seeking for mandamus, my lord. By oversight. Stay ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ mandamus ಏನಕ್ಕೆ ಅಂದ್ರೆ ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ 2 years ಆಗಿದೆ, ಅದನ್ನು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಷ್ಟೇನಾ?
ಇದಕ್ಕೆ ರಿಲೇಟೆಡ್ ಆಗಿ OS ಸೂಟ್ ಇಂಜಿನಿಯರಿಂಗ್ ಸೂಟ್ ಫೈಲ್ ಆಗಿದೆ. ಮೋರ್ ಓವರ್ ಅವ್ರ ಪೊಸಿಷನ್ ನಮ್ಮನ್ನ ವೆಕೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಇದು
420 ಅಫೆನ್ಸ್ ಇದೆ.
This court on 10/8/2020, there is an inadvertent typographical error in quoting an interim order that does not relate to the present case. The present petition was preferred only for a direction to the
respondent.
Only to the direction to the jurisdictional police for filing of a charge sheet in crime number, for filing of a final report in crime number 100 of 2024. In the light of the passage of 2 years, the petition had been preferred. Therefore, the order date 10/8/2026 in the form that it is found is recalled. List the matter tomorrow in the fresh matters list. Dispose, madam. Deepthi madam, just look into that. Why crime number 100 of 2024? Why charge sheet is final report is not filed despite 2 years? 420 is the offense.
Please.
Yes.
Reporting settlement, till number 13, this PB.
Appear for the petitioners.
Offense.
Respondent number 2.
My lords, 318, 336 and 340, my lords.
Sorry.
Serial number 13 as well as 14, my lords.
Both cases I am for.
Yes. Okala takidira?
Yes.
Venkataramaredi. Yes. All right. Yes.
Reporting settlement. Till number 104. Praneet GN. Hundred and five.
Sure.
This case I am for petitioner, my lordship.
Offense ಏನು?
Offense 416, 470, 504, 503. Private complaint, my lordship. RFA ಅಲ್ಲಿ settlement ಆಗಿದೆ.
ಎಲ್ಲಿದೆ? Page.
Page number subsequent ಆಗಿದೆ, ಅದನ್ನ ಕಾಪಿ ನೆನ್ನೆ ಹಾಕಿದ್ದೀನಿ, ಸೊ ಫೈಲ್ ಹಾಕಿದ್ದೀನಿ.
ಕೊಡಿ, ನಿಮ್ ಕಾಪಿ ಕೊಡಿ. The parties to the list were before the civil court, before the bench in RSA, wherein the parties have entered into a settlement The settlement also records the closure of the present proceedings. In that, the settlement reads as follows: in the light of the said circumstance, disposed quashed.
All the accused. ಒಬ್ರು ಮಾತ್ರ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು, ಅಲ್ಲಿ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೆ.
All the accused, yes. All the accused ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲ, ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
Quashed ಅಂತ ಮಾಡಿರ್ತೀನಿ, ಏನು ಅಂತ ಬರೆಯಲ್ಲ.
please, madam.
Leave it, yes. Next.
106.
Latif. ಏನು offense?
Promise to marry.
Come on, merit, sir.
I'll argue.
Day after tomorrow, fresh matters. They are respondent here, Sumant.
Yes,
Anyway, there will be no objection. We'll pass orders on merits day after tomorrow.
please.
Yes.
107.
Bailable offense. Both the parties are present.
Against the medical officer,
Medical officer. Yaru?
hospital doctors ಮೇಲೆ
Who's medical officer?
complainant.
Complaint is present.
Yaar accused yaru?
Accused with the
Offense ಏನು sir?
offense is 115, bailable offense, 115.
ಅದೇ ಇರ್ಲಿ ಅದಲ್ಲ. ಮೆಡಿಕಲ್ ಆಫೀಸರ್ ಹೆಂಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ?
ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡಿದ್ರು ಅಂತ ಮಾಡಿ.
ಎಸ್ ಕೊಡಿ. ಟೇಕ್ ಇಟ್.
Order sheets.
ಮಾಡಿ.
Please, please.
Order sheets. 108.
Appear for petition.
Child marriage restraint.
Child marriage act.
Where for the.
ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಸೆಟಲ್.
ಅಲ್ಲ ಮ್ಯಾರೇಜ್ ಆಗಿದೆ, ಮೇಜರ್ ಆಗಿದೆ.
ಆದ್ಮೇಲೆ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಬರೋದು. ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಸೆಟಲ್ ಇಟ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ನಿಮ್ಗೆ. We have given up the settle the dispute qua one and the complainant. Child marriage act will not.
ಅಲ್ಲ ಆಫ್ಟರ್ ಬಿಕಮಿಂಗ್ ಮೇಜರ್ ದೇ ಆರ್ ಮ್ಯಾರಿಡ್ ಅಂಡ್
ಅದ ನೋಡಕ್ ಹೇಳ್ದೆ. ಮ್ಯಾರೇಜ್ at the time, marriage after 18 ಆದ್ರೆ it will not come.
ಮ್ಯಾರೇಜ್ ಆಫ್ಟರ್ 18. I produced documents also.
ಆಯ್ತು ಇರಿ ಒಂದ್ ನಿಮಿಷ. Wait, pass over. ಕೌನ್ಸಿಲ್ 5:30 ಮೇಲೆ ಬನ್ನಿ. ನೆಕ್ಸ್ಟ್
109.
ಗುರುದೇವ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಮೇಡಮ್. ಇಲ್ಲ ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 20th. ಎಸ್ ನೆಕ್ಸ್ಟ್
110.
ವಿವೇಕಾನಂದ್
376 my lords. I'll keep
day after tomorrow fresh matters.
Great.
Come on merits.
Great.
Yes. 111 Akash. ಆಯ್ತಾ ಸರಿ.
104. Settlement.
My lord, POCSO.
8 of POCSO.
8 of POCSO is all right. Where are the parties?
My lords,
Point settlement.
Complainant ಎಲ್ಲಿ?
my lords, complainant is judge. My lords,
Preparing for R2.
it is not present before this honorable court, my lords. Last time your lordship said that it cannot be settled because of POCSO. It should be heard on merits.
Section
8 POCSO, not 4 or 6. Can be done. Will you keep the parties present?
Please, my lords.
Certainly.
Thursday? Please, ma'am.
Day after tomorrow at 4 p.m. Yes.
Much obliged.
ಇಲ್ಲ 3:34.
Further hearing. Till number 115.
Petitioner. My lord, the offences are under the
Okay, for
SC/ST
respondent number 2 in
Prevention
this
of
case.
Atrocities Act.
Press.
Last date of hearing, my lord has given a small dictation also, where the civil
For
disputes
the
are pending
respondent number
between
2, my lord, press time.
Press time, no grants time.
Senior is out of station.
Out of station, why?
I will file detail my lord, objection.
ಹಾಕಿಲ್ವಾ ಇನ್ನು?
I can file my
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
last 7th
7th?
7th of this month.
7th of this month? 7th ಆಗೋಯ್ತು.
File ಮಾಡಿದ್ವಿ.
ಮಾಡಿದ್ದೀರಾ?
File ಮಾಡಿದ್ವಿ.
ಎಲ್ಲಿದೆ ಕಾಪಿನೇ ಇಲ್ಲ. ಇದೆಯಾ?
ಇನ್ನೊಂದು ಕನೆಕ್ಟ್.
when do you want?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಬರ್ತಾ ಇದೆ. 18th ಗೆ ಡೇಟ್ ಇದೆ.
ಯಾವುದು?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ SLP ಪೆಂಡಿಂಗ್ ಇದೆ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ SLP ನ? ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನು ಸಂಬಂಧ?
ಸಿವಿಲ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಸಿವಿಲ್ ಮ್ಯಾಟರ್ ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. List this matter on 16th.
After 18th.
list the matter on 17th at 4 PM for further hearing. The respondent in the event would not make submissions on the said date, orders would be passed on hearing the counsel for the petitioner. Interim order subsisting will continue till the next date of hearing. Yes. Supreme Court case को ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
116.
ಇದೆಯಾ?
Pertaining to the
Locus, sir?
Yes, yes, I'll just finish. Well, it's senior Mr. Zoeb. He had given the whole compilation of 16 judgments, my lords, on the basis of which they would say they would have locus to even file protest. My respectful submission, my lords, not one amongst the 16 judgments that have been given dealt with the issue of locus of ED to file protest. My lords, all those judgments which have been given are in the context when quashments have been sought, my lords, in the High Court. Under 482, can they be heard? There, my lords, the answer was they can be heard under 482. Now, my lords, we only have one judgment, my lords, which deals with this particular issue, whether ED has locus to file protest. Now, this is a judgment which has come out from the Bombay High Court. On the last occasion, my lords, I have given it.
ED has no locus.
They hold that ED has no locus to file protest, and very reasoned order, my lords, to say who can file protest. They say 3 categories of persons who can file protest. ED can never file a protest. I'll just rely on that one judgment and show, my lords, that matter went up to the Supreme Court. It had its second round, and even in the second round, they reiterate the same. And this is the only judgment in my respectful submission, my lords, which dealt with the issue whether ED had locus to file protest. Now, this judgment, my lords, I have given it on the last occasion. State of Maharashtra, no? My lords, Directorate of Enforcement versus State of Maharashtra. The last time's compilation that we said we wanted it back in. It's dated 21st December 2020, my lords. Kindly notice the informant in that case, my lords, is respondent number 2, Akbar Travels, my lords. Informant. Now they set the law in motion. My lords may also notice respondent number 4, my lords, Naresh Kumar Goyal, because second round comes with his petition, my lords. So 2 rounds were there in that. The precise question that came up for consideration, my lords, would get at page 3, paragraph 2. The question is, my lords, the short question that arises in the aforesaid petition is the locus of the petitioner ED in a closure report filed by the state of Maharashtra before the magistrate in a case registered at the behest of respondent number 2, Akbar Travels. So whether they have locus was the point. Then, my lords, that was a case where after the complaint was given, it ended up with a B report. As soon as B report was filed, ED filed their application for protest, my lords. The learned magistrate would dismiss it, and then, my lords, it goes to the revisional court and then comes to the High Court. Now, High Court, after formulating this, my lords, page 5 may be noticed, my lords.
That was, it was held that ED has no locus.
No locus.
It goes to the Supreme Court.
Yes, my lords. SLP gets rejected. After SLP gets rejected, my lords, in the meanwhile, the B report which was filed came to be accepted. So since the B report was accepted, this respondent number 4, my lords, Naresh Goyal, he files a writ petition in the High Court for the quashment of the PMLA proceedings. Again, while considering that, they narrate the whole sequence in saying how ED did not have locus, and which has been confirmed by the dismissal of the SLP. So we have the 2 rounds, my lords, and these are the only cases which dealt with the locus of the ED to file protest. Now, while dealing with it, my lords, the High Court had the occasion of saying who can file protest. 3 categories that is spelled out in the judgment itself, my lords. I'll just point out which those 3 categories are. My lords, they go on the issue of saying victim and interested person, aggrieved person. My lords may notice page 7, my lords. Category, fourth line. One is victim, interested person, aggrieved person. Then the definition of victim as seen in the CRPC, my lords, is extracted, who a victim is. Virtually to point out, ED does not come under the category of a victim, my lords.
Yes.
Thereafter, my lords, party interested, my lords would get at paragraph 6.
Yes.
And then, my lords, the submissions made on behalf of respondent number 4 at paragraph 8 may be noticed, my lords. It's at page 10, paragraph 8.
Yes.
It commences with Mr. Ponda, learned senior counsel. He points out, my lords, the reason why ED can never be an aggrieved party or a victim for them to file protest. Reliance is placed on Bhagwat Singh case, my lords.
Yes.
And now, paragraph 11, page 13. This was the contention taken on behalf of the ED. ASG takes the contention to say that they can file their protest, but what the court would hold is, having heard ASG for the petitioner, learned counsel for the respondent, and having perused several judgments relied upon by the respective parties, the answer to the question raised in the aforesaid petition with respect to the locus of the petitioner ED in a closure report filed by respondent number 1, State of Maharashtra, in a case registered at the behest of respondent number 2, is in the negative for the reasons set out hereunder. Then, my lords, reasoning, paragraph 13 at page 15. Then paragraph 14 may be noticed, my lord. 17, it's thus evident that an informant complainant is entitled to a notice before any orders are passed on a closure report by the magistrate, whereas an injured or in case of death, the relative of the deceased can be heard even without notice, where a police files a closure report or a C summary report in respect of a complaint. Thus, the three categories of persons whose locus has been recognized are complainant, injured person, or the relatives and heirs of the deceased. Then, my lords, victim, they deal with it. And finally, my lords, the court, at paragraph 17, the petitioner ED claims to be an injured victim in a representative capacity of the victims. According to the petitioner ED being a victim of economic offences which are serious in nature, having large repercussions on the economy of a country, would have locus to be heard before the closure report is accepted. According to the petitioner ED, they're interested persons.
I've seen the entire judgment.
Entire thing. Yes. This, my lords, is taken up to the Supreme Court. My lords would have the SLP order, page 26, 26/9/2022, page 26.
Dismissed.
And my lords, there one sentence is there.
However, question of law, if
any raised.
It's now raised.
No, if any raised, then, my lords, it goes to a second round. Now, the second round, my lords, would get at page 28, because, my lords, after this order, in the intervening period, there's acceptance of the B report. Therefore, my lords, the quashment of PMLA proceedings, which are sought in criminal writ petition at page 28.
They are quashed.
Yes, my lords. And they notice this entire sequence in saying how ED has no locus. Now, in the 16 judgments which have been placed before this court, my lords, not one judgment has dealt with the aspect of whether they have locus for a protest. All the judgments are, my lords, 482 inherent powers that the court has. Court may permit them to have a say before the High Court, but not for a closure report, my lords. Closure report is only these three categories of persons. This, my lords, is my respectful submission on the locus aspect of it, my lords. And on the other aspect, I've already concluded, my lords. I will not.
May I respond, my lord? My lord, may I please have for a moment the date of the judgment which my learned friend relied upon.
2022.
2020.
2020, yes.
2020. My lord, may I take one very significant date that took place, my lord, on 27 July 2022 is when Vijay Madanlal Chaudhary came into And the judgment clarified that if the predicate goes in
This
its
was
entirety.
rendered when Vijay Madan Lal was not in.
In fact,
not
it
yet
was rendered, not only that, my lord, in fact, it was rendered when the Bombay High Court view was, even if the predicate goes PMLA investigation, nothing will happen. Please have that judgment of Babulal. My lord, I've just sent it across, my lord. If I may just give the citation. Babulal Verma versus ED 2021 SCC online Bombay 392. And if I may read only two paras there, my lord. Para 28, even if the predicate offense or scheduled offense is compromised, compounded, quashed, or the accused therein are acquitted, investigation of ED under PMLA does not get affected, wiped away, or cease to continue. It may continue till ED concludes the investigation and either files the complaint or closure report before the court of competent jurisdiction. This is Babulal Verma, para 28, and then permit me to read para 34 also. So the law as it was emanating or holding in Bombay was that, my lord, has the judgment? I'm sorry, my lord.
Yes, yes, no, not yet come. Ab boliye.
Very well, my lord. Para 34, in view of the aforesaid discussion, it is clear that even if the investigating agency investigating a scheduled offence has filed a closure report in it, and the court of competent jurisdiction has accepted it, it will not wipe out or cease to continue the investigation of respondent number 1 in the offence of money laundering being investigated by it. The investigation of respondent number 1 will continue on its own till it reaches the stage as contemplated under section 44 of PMLA. If my learned friend says this is the position he wishes to abide by despite Madan Lal Chaudhary, then I have no objection, my lord. But it can't be, because today Madan Lal Chaudhary says if the predicate goes in its entirety, clarified in Pavana Debut, that PMLA case will not survive. That is what Pavana read with Madan Lal says, my lord.
But by the time the second judgment was rendered, Vijay Madan Lal was there and it was referred to on the B report.
Second judgment being, my lord?
Second judgment, that is Bombay High Court, same. The other one, where the B report was accepted and the case closed. There the complainant comes before the High Court.
Yes, my lord.
In that, Vijay Madan Lal is referred also.
Yes, I have just received the judgment. I'll take a look. But my submission is this. Now, today, please have one more decision where my learned friend said in my compilation, there is no judgment which deals with this issue. My lord, may straight away have page 113 of the compilation which I had originally handed over, my lord, regarding the locus, the issue of locus, my lord. That was a, please have, my lord, that Madras High Court judgment, division bench, in Assistant Director, Enforcement Directorate versus
So what is the
State.
date of the Madras High Court judgment?
Yes, my lord. This is
28/10/2024.
28th October 2024.
This is also confirmed with, I mean, like SLP is dismissed.
SLP is dismissed. And while dismissing the SLP, I will just, I've also placed that SLP dismissal order, my lord. There is nothing about no question of law, etc., being left open or anything, but SLP is dismissed. But this was a case, if my lord will have page 116, para 10, closure report was filed by the state police.
My lords, even in that, question of law is left open.
134.
Page 130.
It will be decided here.
Yes, I can correct it. Now, please see, my lord, page 116, the issue was identical. Closure report filed by the state. Magistrate accepts the closure report. ED becomes the petitioner in revision petition, and the ED's locus is questioned. So the issue is, the situation is not different at all. It is akin to the ED stepping into the shoes of whether it is an injured party or an interested party or not. Para 10, my lord may see at 116. My lord will find the closure report was filed by the state police, and at para 11, my lord, the magistrate.
No, Zoeb sir.
Yes, my lord.
You spring into action in terms of a predicate offense.
Yes, my lord.
The predicate offense goes. Then what investigation will you do once the foundation goes is one thing.
Yes.
Now B report is accepted and closed. because your existence itself is in terms of a predicate offense and the predicate offense gets closed, can you be considered to be aggrieved is what is said.
No, therefore, my lord, will please come back to my petition. When a closure report is filed, we file a protest petition. We tell the court at that
Correct.
stage.
You file a protest petition. Correct.
At that stage, we file a protest. So we
No,
have
it
two
is not
scenarios.
like in other cases where after 5 months, 6 months, you file ECIR when
I bow down.
when
I
nothing
bow
was
down.
pending.
It is not a case of a non-STCIR, my lord. It is a case where substantial investigation
So
done.
there was no here the crime was at the stage of acceptance of the B report or otherwise you filed a protest petition.
One and a
Yes,
half
my lord.
years
Yes.
later. 1.5 years later.
But it was pending still.
Report was pending.
B
1.5
report is
years later, they filed the protest.
So it is not that they filed, they registered an ECIR or whatever.
No, this is not that case.
In vacuum, one thing. And they did file their protest petition during the pendency of the proceedings before the court. That is why we'll decide whether locus is there or not.
Yes. Now, my lord may see the impugned order in 3992, which is where we are the petitioner, goes by the fact that, and I will just read one line at page 44, direct in view of the above ratio, considering the facts and circumstances of the case, ED is not a victim or aggrieved person. ED has initiated proceedings against accused person or has an efficacious remedy to initiate separate proceeding under PMLA. Therefore, it appears that the learned magistrate was not aware that I can't initiate separate proceedings under PMLA based on this predicate offense. Although the entire foundation of the reasoning goes, it is still following that Babulal law. Babulal is long dead, my lord. For argument's sake, if the ED is permitted to file protest petition, this court lacks jurisdiction to decide the claim of ED. However, the present case is purely personam in nature. We point out that here it is that all the facts that we found, which shows large scale misappropriation of public property, whatever it is, it has to be looked at by
That on the merits you have argued. We'll consider about locus.
Yes, only on local. My lord, my submission is this order does not look at the merits of our protest
Zoeb
petition.
sir, if I hold that you have locus, I'll have to send it back.
I bow down, my lord, because
to be heard for the protest petition to be heard on merits. If I hold you have no locus, nothing need be said.
I bow down.
Yes,
Now one
that's
more.
all. We'll consider it.
Yes, my lord. Now, my lord, only
Not
one more
reserved.
submission, my lord. Suppression was argued. May I just show one because my
Don't worry about that.
I must only point out one thing because my lord, something it's my responsibility. My lord, may have only a one
All right.
page.
No, don't take it without reply. You please reply. No worries.
Yes, I'll take only 5 minutes by the
No
clock.
problem. No problem.
My
Yes.
colleague may just hand over a one pager I have prepared for the court's consideration, my lord.
Good,
It's a note rebutting allegation of suppression. And my submission will be there is no possibility of suppression of material which already stands disclosed. Neither would ED want to suppress, nor would ED be found guilty of suppression on the facts of this case if that one pager is handed over.
Yes, sir.
And I've tried to, my lord, demonstrate that material which we are alleged to have suppressed was already placed on record, my lord. Lord, I'm just waiting for that one pager to reach, my lord. Now, my lord, may please see. On 7th January 2026, the criminal CRLP 101 was filed under 482, seeking quashing of the second FIR, my lord. That is 632 of 2025 and our 662 letter. 7th January, my lord, this honorable court passed an order prima facie observing that once the foundation of the ECIR stood extinguished on account of B report, further proceedings would be without jurisdiction. So, my lord had held that earlier FIR goes, B report filed, ECIR goes, therefore your 66-2 you can't continue. prima facie view, my lord, it's an interim order stay. On 12th of January, ED filed a statement of objections in writ petition criminal 16675, my lord, wherein the filing of the protest petition against the B report letter of 10th December under 66(2), which led to registration of the subsequent FIR, specifically disclosed at page 17 of our counter affidavit. My lord, I'm not taking, my lord, to that page. I have personally checked it. These facts, which we are alleged to have suppressed, specifically disclosed before this honorable court in the collateral proceeding. Therefore, there can be no intention. I am today on intention, my lord. There could never be any intention to suppress the facts that already.
Why are you getting into tension, right? Yes, yes, Zoeb sir, yes.
Lord always manages to keep it lighthearted. Malad, there was no question of any intention to suppress because we had already disclosed in writ petitions 16675. Now, please see, Malad, one more thing. On the 2nd of March 2027, another criminal CRLP 3447 was filed by Embassy East Business Park. Mr. Virwani seeking quashing of the subsequent ECI and production of records.
Where Panindra sir had appeared.
Yes, my lord. Including a copy thereof, on 2nd March, this honorable court passed an order directing no further precipitative steps in that. On 7th March 2026, this petition, my lord, that is 3992, was filed by the ED against the order dated 28th January 2026, rejecting ED's protest petition on lack of locus standi. On 12th of March, now this subsequent development is extremely important, my lord. On 12th of March, the writ petition seeking quashing of the first ECIR was tagged with CRLP 3992. That is at page 378 of my convenience compilation, my lord. There is a formal judicial order of tagging. So on day one, my lord, this honorable court, aware of the connected nature of the proceedings, tagged it with the petition where we have already filed a statement of objection, bringing on record all these materials today which we are alleged to have suppressed.
So there is no question of suppression.
No question of suppression. More so, have I benefited anything from the suppression? 27th March, the interim order is passed against me, which is continued, my lord, in my petition also. So not only is there no suppression, I've not derived any benefit from this. And my lord, to be very fair, there can be.
You tell me, what would the ED get by suppressing?
I bowed down, my lord. And my lord, sometimes, my lord, petitions are filed with focusing only on the issue at hand, which was no locus, and therefore we filed it. It is not
suppression. Suppression I may not buy, so don't.
Yes, but I just wanted to, my lord, clear the air that one should not feel that there is any kind of anything which is not above board is being done.
Now this submission AQI is 1. Unlike in Delhi.
Yes, yes.
Yes.
But these days we are lucky, my lord. The AQI is not so bad in Delhi also.
Air quality index. He wanted to clear the air.
Deeply obliged. I'm grateful, my lord.
Yes, sir. It is now at 1, so no problem.
I'm grateful.
Will not buy the suppressions. Not to worry. Yes. And what would the ED get by suppressing? What's the suppression? What's that?
It was just argumentative. I think we'll leave it at that.
Yes, yes. No, but since he had made that submission, he is entitled to.
Innone matter to say that I had said that in another matter may not lie in suppression, because we can be two different. But anyway, your lordship.
Yes, let us not.
If it wasn't a connected case, of course, but it's a connected case.
All right, heard reserved. Yes.
I'm so grateful. Deeply obliged.
ಒಂದು ನಿಮಿಷ ಅದನ್ನ ತಗೊಳಕ್ ಮುಂಚೆ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ, ಇಲ್ಲಾರ ಅದು ಮುಗಿಯಲ್ಲ. ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಅಡ್ಮಿಷನ್ ಇಂದನಾ? ಎಸ್.
Is continued.
83. Yes.
For petitioner, my lord. MCL is settled ಆಗಿದೆ, my lord.
ಕೊಡಿ.
Report.
MCL ಸೆಟ್ಲ್ ಆಗಿದೆ.
376 ಅಪೆನ್.
498.
376, my lord.
ಅಲ್ಲ 376
Yes, madam. 376 ಆದ್ಮೇಲೆ ಮದುವೆ ಆದ್ಮೇಲೆ
ಮದುವೆ ಆಗಿದ್ದೀರಾ?
ಮದುವೆ ಆಗಿದೆ.
ಹಾ.
ಮದುವೆ ಆದ್ಮೇಲೆ MC ಪಿಟಿಷನ್ ಹಾಕಿ MC ಪಿಟಿಷನ್ ಕ್ಲೋಸ್ ಆಗಿದೆ.
MC ಪಿಟಿಷನ್ ಏನಾಗಿದೆ?
13B ಹಾಕೊಂಡಿದ್ದೀನಿ madam.
ಮ್ಯೂಚುವಲ್. ಇದು 376
madam. ಅದೇ 2 ಪಿಟಿಷನ್ ಇದೆ. ಒಂದು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಸೆಟಲ್ಮೆಂಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋಣ, ಅದನ್ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರೆಯೋಣ.
ಅಲ್ಲ ಮದುವೆ ಆಗಿ ಟರ್ಮ್ಸ್ ಅಂಡ್ BMC ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
ವೆಯ್ಟ್ ಮೇಡಮ್, ಆಸ್ತಿ SPP ಟು ಕಮ್. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ವೆಯ್ಟ್ ಇನ್ನೊಂದು 15 ನಿಮಿಷ ಬಿಟ್ಟು ತಗೊಂತೆ.
84.
Not 498 AM.
ಏನ್ ಪ್ರದೀಪ್ ಇದು?
Not husband and father-in-law.
ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಹಾಕಿರೋದು ಯಾರು?
Not the respondent.
ಅದಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
But in fact, my lord, 6th time, my lord, they're seeking adjournment in this matter, my lord. It appears that they're avoiding, my lord, this bench.
ಹೌದಾ?
Please, my
Oh.
lord, that is the, my lord, submission I'm making, my lord. In fact, my lord, 6th time, my lord, in fact.
Awaiting the appearance 11/8.
On last occasion, I did not appear, my lord.
Awaiting the appearance. Awaiting, how many times, sir?
Lord,
At the
every
request
time
of the respondents list on so and so. ಏನ್ ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಾ?
stay could, my lord, absolutely no allegations, my lord, in fact.
ಹಸ್ಬೆಂಡ್ ಇದೆಯಾ?
Husband idare. Lord, 18/4, my lord, she left the matrimonial home. 23, my lord, I filed a divorce petition. And 28, my lord, I sent a, my lord, legal notice, my lord, that informing about the, my lord, the pendency of the divorce proceedings, my lord. And 16/6, my lord, she files a complaint to the police saying that, my lord, there is some misunderstanding between the family members. So therefore, they requested the police to, my lord, sort out the issue. Thereafter, my lord, I was summoned. I went to the police station. Lord, I made a statement to the police stating that, Lord, since the divorce petition is pending, Lord, we'll sort it out before the family court. Very next day, my lord, the present complaint is filed. Absolutely, my lord, the
ಎಷ್ಟನೇ ಕಂಪ್ಲೇಂಟ್ ಇದು?
second complaint.
Monday.
Lord, kindly see the memo, my lord, I have produced.
Will permit malicious prosecution against the wife.
Please, my lord.
Yes, sir. The ನಿಮ್ಮ ಹೆಸರೇನು? ಇಲ್ಲಿ ಹೆಸರಲ್ಲಿ ಯಾವತ್ತು ಹಾಕಿದ್ದೀರಾ ವಕಾಲತ್ತು? ಹಾಕ್ಬೇಕು.
Lord, fifth advocate
One
is
minute.
coming.
The respondent complainant, as and when the matter is listed, seeks time, changes the counsel. This modus operandi has resulted in the fifth counsel now seeking time to file his wakalat. There is no warrant. I cannot stop him filing his wakalat.
Please, my lord.
The wakalat, as a last chance, list this matter day after tomorrow in the fresh matters list. In the event no submissions are made by whoever is holding wakalat, the petition would be answered hearing the counsel appearing for the petitioner.
Please.
List the matter day after tomorrow, fresh matters list. ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳಿದ್ದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. ಯಾರಾದ್ರೂ ಇರ್ಲಿ ವಕಾಲತ್ತಲ್ಲಿ ಏನ್ ಅಡ್ಜರ್ಮೆಂಟ್ ಆದಾಗೆಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್. Some limit to nonsense.
Please, my lord.
Yes.
86.
For the appellate, my lord. I want, withdraw the case, my lord.
Withdrawn.
The case is not settled. Maximum try to settle the matter, but the.
But ಇದು ಬಂದಿರೋದು ಅದಕ್ಕಲ್ಲ, ಲೆಟರ್ ಆಫ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಂದಿರೋದು.
ಇದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ ಅಂದ್ರೆ 2 lakhs ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ದಟ್ ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್. ನಮ್ಗೇನಿಲ್ಲ, ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ವ್ಯಾನ್ ಟು ಕ್ಲೋಸ್.
ನಾನು ಇದು ಸ್ಟೇ ಮಾಡಿದ್ನಲ್ಲ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಮೇಲೆ, ಆಮೇಲೆ ಸ್ಟೇ ಮಾಡಿದ್ನಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇ.
ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಬೇಡವಾ ಅದು?
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಪ್ರಯತ್ನ
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ತೀನಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಮಾಡಿ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ
ಆಯ್ತು, ತಾಳಿ ನೋಡ. ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್
4 weeks ಟೈಮ್ ಕೊಡಿ ಸರ್.
ಆಯ್ತು, 27ಕ್ಕೆ ಹಾಕ್ತೀನಿ.
ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಫಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಸರ್.
ಯಾಕೆ?
ಅಲ್ಲ, ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ತೀವಿ ಸರ್. ಆಗಂಗಿದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡಿ.
ಕೂತ್ಕೊಳ್ಳೋಕೆ ಒಂದು ತಿಂಗಳು ಬೇಕಾ?
ಆಗ್ಬೋದು ಸರ್.
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 27th ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ನೀವು ನಿಂತ್ಕೊಂಡಾರು ಮಾತಾಡಿ, ಕೂತ್ಕೊಂಡಾರು ಮಾತಾಡಿ, ಇಲ್ಲಿ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡಿ. ಎಸ್.
87.
Hearing for the petitioner, my lord. It's a split up case, my lord.
Day after tomorrow, fresh matters list.
Much of.
Yes.
88.
That will continue.
But statutory bail
Huh?
has to be considered.
Has to be considered.
But he has taken 3 days time
ಯಾರು who has to consider, ಏನ್ consider?
ಅಲ್ಲ ಸ್ಪೆಷಲ್ ಜಡ್ಜ್ ಒಬ್ಬ ಚೇಂಬರ್ ಅಲ್ಲಿ ರಿಸೀವ್ ಮಾಡಿದ್ದು.
Oh, chamber charge sheet, that is permissible ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ
Default bail da?
ಡಿಫಾಲ್ಟ್.
In fact, I can place a judgment, my lord, which renders the identical issue. Whether the charge sheet can be filed.
ಅಲ್ಲ
Ultimately, my lord, it's.
ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಇಲ್ಲ. ನಾನು
ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಆದ್ರೆ you're on a very slippery slope.
3 judges bench ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ ಸರ್.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ರಿತು ಚಾಬ್ರಿ ಅದ?
ರಿತು ಚಾಬ್ರಿ ಅಲ್ಲ, ಇಡಿ ಕಪಿಲ್ ವಾಧವ.
ಸುರೇಶ್ ಕುಮಾರ್.
ಅದು ಕೊಡಿ SPP ಅವರೇ. ಯಾವ್ದು?
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ, ಅದು ಇನ್ಕಂಪ್ಲೀಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ.
Incomplete charge sheet ಅಲ್ಲ, ನಿಮ್ ಗ್ರೌಂಡ್ ಏನು? Charge sheet is filed before the in the chamber of the magistrate.
Yes.
That's all.
Yes,
For the purpose of numbering.
I'll be 3 judges bench ಒಂದು ಕೊಟ್ಟಿದ್ದೀವಿ. 2024 ಇಡಿ ವರ್ಸಸ್ ಕಪಿಲ್ ವಾಧವ.
Let's see. Day after tomorrow we'll take it.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
ಏನು ಕಸ್ಟಡಿಲಿ ಇದ್ದೀರಾ?
ಅಲ್ಲ ಆನ್ಲೈನ್ ಕಸ್ಟಡಿಲಿ.
302.
302 coupled with atrocities.
So just like that ಕಸ್ಟಡಿಗೆ ಹೋಗಿಲ್ವಲ್ಲ? Murder ಮಾಡಿ ಹೋಗಿಲ್ಲ allegedly.
Lordship may take the judgment, my lord, paragraph 5.
Day after tomorrow let me go through.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಆನ್ಲೈನ್ ಫೈಲಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಆನ್ಲೈನ್ ಫೈಲಿಂಗ್ ಇಲ್ಲ. ಆನ್ಲೈನ್ ಫೈಲಿಂಗ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ 853 ಗೆ ದೇ ಫೈಲ್ಡ್ ಇಟ್.
ಅಲ್ಲ ಆಫ್ಲೈನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಬಿಫೋರ್ in the chamber.
ಅಲ್ಲ ದಟ್ ಇಸ್ ಬಿಫೋರ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ರೂಲ್ 10 ಆಫ್ ದ ಕರ್ನಾಟಕ ಕ್ರಿಮಿನಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ವೇವ್ಡ್ ಆಫ್. ಯಾರು ಎಂಟ್ರಿನೇ ಕೊಡಲ್ಲ ಅವರು.
Day after tomorrow fresh matters.
Hearing on IA. 89.
Hearing for the petitioner, my lord.
ಏನ್ ಚೇತನ್? ಏನು offense ಏನು?
138, my lord. This is the same case where it was 3.5 and 2.5. Honorable Court suggested let it be settled for 3.
Oh, ಏನ್ ಮಾಡ್ಲಿಲ್ವಾ? ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಾ?
ಆಗಿಲ್ಲ, ಅದು ಅವರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಟಿಮೇಟ್ಲಿ
2.5 ಲಕ್ಷಕ್ಕೆ ಸೆಟಲ್ ಮಾಡಿ ಅಂತ ಹೇಳಿಲ್ವಾ? ಇಲ್ಲ 3 ಲಕ್ಷ ತಗೊಳ್ಳಿ ಅಂತ.
DD ready ಇತ್ತು. He has brought it also.
He has filed a civil suit. On the suit, my lord, there is a decree, my lord.
ಆಯ್ತು, we'll see. We'll hear it. List the matter on 7th September. Yes. Interim order subsisting will continue to the next date of hearing. Next.
90.
Oblige, my lord. Oblige.
90.
498.
90 vacating stay ಯಾರು ಹಾಕಿರೋದು?
R2.
R2 ನ ಅಭಿಷೇಕ್.
Application.
13 person. Torsela name.
She says 13-person application is filed.
You have appeared before the committee? Committee ಮುಂದೆ appear ಆಗಿದ್ದೀರಾ? ಆಯ್ತು, ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಅವತ್ತು ಬನ್ನಿ. ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಫಾರ್ಮ್ ಸಿ ತಗೊಂಬ. ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಆಲ್ರೆಡಿ. ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲಿ? There is no representation by the petitioner. Finally list the matter on 20th. Yes, next. 20. Yes.
91.
My lord, 91, my lords. Respond number 2 has lodged the complaint. SC/ST ingredients illa complaint ಒಳಗೆ page in. She was the secretary, petitioner was the secretary of the association of the apartments, my lord.
Stay ಕೊಟ್ಟಿದ್ದೇನೆ.
With the urgency because she is not able to travel abroad because the criminal case is working in a software company, my lords. This criminal case is.
Who has filed vacating stay?
State has filed, my lord. Respond number 2 has not appeared.
91 ತಾನೇ ಇದು?
91. Respond number 2.
Vacating stay ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ by HCGP.
ಹೌದು, you would have to kindly see the complaint page 18 for a moment, my lords. Page 18. No ingredients at all. Page 18 shows, my lords, complaint is filed after 6 months. So then 25 complaint is registered, my lords. 24 some incident allegation, my lords.
One chance ಕೊಡೋಣ.
Your lordship said the same thing on the previous occasion. ಹಂಗೆ ಹೇಳಿ ಒತ್ತಿಟ್ಟು ಸ್ವಾಮಿ last time.
Fresh matter ಹಾಕೋಣ ಅಂತ ಹೇಳಿ.
Last time your lordship were pleased to observe so, my lords. Kindly see page 18 last one
heard
sentence.
the learned counsel, senior counsel BP Hegde appearing for the petitioner. The counsel for the respondent has remained absent throughout. In that light, as a last chance, awaiting the appearance, list the matter day after tomorrow. In the event there would be no representation, appropriate orders would be passed on hearing the petitioner day after tomorrow. Not Yes.
Fresh matter.
Next. Fresh matters list. Yes.
Great.
Hemant, ideno. That will continue. Yes.
ಇದು ಬೋನೋಫೈಡೆ ಪರ್ಚೇಸರ್ A7
ಇದೆಯಲ್ಲ ಸ್ಟೇಟ್ ಹಾಕಿರೋದಾ?
ಅವ್ರು ಹಾಕಿರೋದು ಸರ್.
ವೈ ಮೇಡಮ್?
Conclusion of the trial and
ಕನ್ಫ್ಯೂಷನ್ ಹಾಕ್ಬಿಟ್ರಾ?
18 years delay ಇದೆ ಸರ್.
trial pending ಇದೆ.
Yes, sir.
Crime
My lord.
investigations.
Property belong to the proper family of the respondent number 2, my lord. They were impersonation, they sold the property.
ಯಾವಾಗ ಸರ್?
It was executed in 2007, my lord. This, my name was there, this notation was rejected by the Tashildar in the 2007 itself. They did not challenge for a period of 17 years. In the year 2020-24, my lord, they filed application before the Assistant Commissioner. Assistant Commissioner, without issuing a notice, he passed an order on the date of admission only.
ಏನು mutating their
The name of the petitioner. In the year 2024, his name is going to be.
ಯಾಕೆ ಸುಮ್ನೆ 17 ವರ್ಷ ಬಿಟ್ರಿ ಸೆಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ?
ಅದು ಎಲ್ಲ ಇದು ಏನು ಅಲ್ಲ ದೇಣಿಗೆ ಜಾಗ ಮಾಡಿರ್ಲಿಲ್ಲ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡ್ತಾರೆ, ಎಲ್ಲ ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ಅದು. ಅಲ್ಲ ನನ್ನ ಹೆಸರು EC ಇದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 29 ಅಲ್ಲಿ EC stands in my name since 2007 itself. They knowing fully well 3 ಸಲ ಕೇಸ್ ಹಾಕೊಂಡು 3 ಸಲ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ 3 ಜನದ ಹತ್ರ. ಈಗ ಇಲ್ಲಿ ಬರ್ತಾನೆ ಹತ್ರ ಆಮೇಲೆ ಬೋನೋಫೈಡೆ ಪರ್ಚೇಸರ್
ಅವ್ರದ್ದೇನ್ ತಪ್ಪು?
ಇಲ್ಲ ಅವ್ರದಲ್ಲ
ಮತ್ತೆ
1 to 6 is
your lordship may kindly see with
ಅಲ್ಲ ಇವ್ರದ್ದೇನ್ ತಪ್ಪು? ಪರ್ಚೇಸರ್ದೇನು?
my lord, your lordship, he is the person implanted the respondent accused number 1 to 6, created these persons and executed sale in his favor.
2007 ಅಲ್ಲಿ
ಅಲ್ಲ 7 ಅಲ್ಲಿ
your lordship may kindly say page.
ಮತ್ತೆ ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
my lord, is for come to know only in the 2024
EC
itself.
stands in my name. 29 page number 29.
My name was there in the RTC till 2024.
Who are you?
I am the grantee, my lord.
Grantee?
This is a Gomal property granted in my favor in the 1978.
1978. Who sold it?
Accused number 1 to 6 sold the property in favor of this person. This property belongs to family of the respondent number 2.
No question of vacating the interim order. Yes. Place the matter for admission. Interim order subsisting will continue to the next date of hearing. Yes, next.
Lordship, my date may be
23.
Barley.
138 proceedings you will allow.
ಯಾವುದು?
An application for respondent. 138 proceedings.
Vacating stay. Yes, sir.
Accusation is covered by the judgment, my lord. After taking cognizance, my lord, the complainant died. The complainant brother made application and he has been permitted to prosecute the proceedings. Lord, the issue is covered by
in 138.
138%.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದು ಯಾರು?
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದು accused.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದು ಯಾರು? ಕಂಪ್ಲೇನೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್ ನೀವು?
I am for the complainant.
Correct. Who is now bought in place of the complainant?
Brother of the complainant.
ಆಯ್ತಾ?
Because he has no issues.
Sir.
Please.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದು individual capacity, a particular person. How will brother come into the picture?
That is what, my lord, the
memo ಮೇಲೆ accept ಮಾಡಿದ್ದಾರೆ sir.
How will brother come in, sir? ಅವ್ರು ಎಲ್ಲೋ ಇದ್ದು ಅವ್ರು ಚೆಕ್ ಕೊಟ್ಟು ಅವ್ರದ್ದು ಹೋಯ್ತು.
ಅಲ್ಲ, legal hair are permitted. They have stepped into the shoes of the holder of the check. That is what the view taken by the.
ಕೊಡಿ ನೋಡೋಣ ಯಾವುದು.
ಮೆಮೋ ಮೇಲೆ ಇದನ್ನ
order ಮೇಲೆ reference was made and also our
G1 ನೀವಲ್ಲ sir.
and another one more judgment.
List on Tuesday in the fresh matters list.
Tuesday some inconvenience ಇದೆ.
Wednesday always. Wednesday in the fresh matters list.
Interim order.
Interim order will continue till the next date.
Reference was made, my lord, in hand. It has been answered.
Let us argue the matter to us.
Let's argue. You argue. Why do you want? Why do you drag me?
ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ, then I will ready to argue the matter.
Let's argue ಅಂದ್ರೆ ಕೋರ್ಟ್ ನು ಸೇರಿಸ್ಬಿಟ್ಟು. Yes, please.
94.
My lord, vacating stay, my lord.
90?
Offense is 376.
Consensual relationship, my lords.
Settlement.
Yeah, my lord, let me explain. The facts are a little different from what they portrayed to be. So the complainant and the petitioner know each other from school. School. The petitioner is the senior of the complainant. Thereafter, they are not in touch with each other. In 2023, they became friends through Instagram. In 2024, ever since 2020, they were on conversation on WhatsApp. In 2024, what happens? The complainant moves to Bangalore for work. They both are from Kerala. The petitioner is working in Chennai. He, on the pretext of meeting the complainant, for the first time comes to Bangalore. He proposes marriage to her.
First time?
First time when they When he comes to Bangalore to meet her, he proposes marriage. She refuses. He
Oh.
asks her, let's be friends with benefits. For that also
Friends
she-
with benefits?
Yes.
What is that?
My lord, he is asking her for physical relations.
Oh,
She refuses
that is
it.
friends with benefits, huh?
She
Okay,
refuses
yes.
it. Thereafter, he committed the offense of rape. My lord, after
You
there is-
accepted that friendship with benefits, huh?
Illa. It's forceful.
Forceful, friends is one thing, forceful the other. Hengagat.
Illa, my lord. Let me explain. My lord, the next
Oh, you
day.
explain, yes.
No, my lord. The next day, after the offense, there is I have filed a memo along with the WhatsApp chats.
Then
exchanged
what
with-
happened?
WhatsApp chats.
He
exchanged with-
began ghosting you, huh?
No, my lord. It's
Then, or
my
scene
lord,
zoning you?
Illa, my lord. It
Matte?
was forceful sexual assault.
ಅದೆಲ್ಲ
What I'm saying-
ಆದ್ಮೇಲೆ
ಇಲ್ಲ,
ಪ್ರಾಬ್ಲಮ್
my lord.
ಏನಾಯ್ತು?
My lord, they have exchanged some WhatsApp chats after the incident on the next day itself, wherein he admits to have committed the offense. My lord, the relevant page is at page number 6 of the memo, my lord. I have also submitted a video, screenshot.
Video?
Illa, screen recording of the WhatsApp chat in a pen drive, my lord. Adರಲ್ಲಿ, I have, my lords may please see page 6 of the memo. It is actually, they are conversing in Malayalam, but I've translated and attached the typed and translated copies in English. It's at page number 14, my lord. Adರಲ್ಲಿ, if my lords may please see, she says, I had no intention or interest to physically involve with you. And thereafter he says, so, he apologizes and he says he won't repeat it and he does not want to lose a friend like her.
Oh. Now you explain.
My lords, page
And
48.
let me add one more point, my
You
lord.
want to explain further?
No, my lord. She is diagnosed with borderline personality disorder and depression, my lord. She's in therapy.
Because of this,
She's in therapy since 2021. He completely had knowledge of that because he was friend. He knew everything and he's taken undue advantage of her situation.
It's page 48, the 164 statement. It is clearly shown that she stayed with the petitioner for 2 days in the lodge.
Lodge?
Yes, my lords. The offense is said to have taken place in the lodge.
Yes.
She was staying here in a PG. When the accused comes over from Chennai to Bangalore, she also comes along, stays with him for 2 days. On the 19th, the incident is said to have taken place. 19th, entire night she stays along. Morning she has the breakfast. Takes
ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಅದೆಲ್ಲ ಏನ್ ಡೀಟೇಲ್ಸ್ ಅವ್ರು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಕ್ಕೆ ನೀವು ಜಾಸ್ತಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತಾರೆ.
It is part of 164 statement. Then the accused, the petitioner pays 100 rupees for her to.
ಮತ್ತೆ ಜಾಸ್ತಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್
That
ಆಯ್ತು.
is irrelevant, my lord.
Absolutely. ಅಲ್ವಾ? What she explained was relevant. You are explaining irrelevant things.
Consensual ಗೆ ಅದು relevant.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. ಅದಕ್ಕೆ ಆಟೋಗೆ 100 ರೂಪಾಯಿ ಕೊಟ್ಟೆ, ಟ್ಯಾಕ್ಸಿಗೆ 100 ರೂಪಾಯಿ ಕೊಟ್ಟೆ. What is all?
My lord, he also states that you should have spoken to me once before approaching the police station.
Correct. He should have
That's what-
spoken to you.
It's message, my lord. It's forceful sexual assault, my lord. She's telling him you broke my trust, and he says sorry, I won't repeat it. I don't want to lose a friend like you.
164 statement.
ಕಷ್ಟ ಮುಂದೆ.
Well, it's 164 statement. It clearly shows that she was a consenting party. Otherwise, she wouldn't have come along with him.
No.
If it was a house, he was forcefully had taken her, that was different. She comes along, she stays with him in a lodge, in a private lodge. It's not that she comes to a house or somewhere which is known, but a private place which they come, she stays. That is not
This
disputed.
is friends with benefits problem. Yes.
After 11 days, she comes and files the complaint. Consensual relationship, my lords.
I heard reserved.
Stay me.
Reserve ಮಾಡಾಯ್ತೇನೆ.
Much obliged.
You want me to explain?
Illa, grateful.
Yes.
Yes. The transaction and 164 statement, if it's looked into. Much.
But difficult.
Well, it's
There's only one instance here.
one instance, my lords, but the 164 is clear that
We'll
she
see.
stays for both the days. Morning she has, that is what 164 statement.
We'll see.
None of the other witnesses, my lords, as my lords have held that the trial cannot happen without any, without any
Sir,
evidence.
ಲಾಡ್ಜ್ ಅಲ್ಲಿ ನೀವು ಯಾರು ವಿಟ್ನೆಸ್ ಇರ್ಬೇಕಾಗಿಲ್ಲ?
Well, a witness in that, at least if there is.
ಏನ್ ವಿಟ್ನೆಸ್?
No, my lords, I know, I understand.
And what, sir?
I understand the sensitivity, but.
ಸೆನ್ಸಿಟಿವಿಟಿ ಏನು? ಅದ್ರಲ್ಲಿ ವಿಟ್ನೆಸ್ ಯಾರು ಬರಕ್ಕಾಗತ್ತೆ?
Witness in the sense, at least circumstantial where if there was resistance, there is no witness to that effect.
That we'll see. Yes. Next.
95.
Lordship, appearing on the behalf of petitioner.
Huh?
Petitioner.
ಇದು ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ. ಎಸ್ ಸರ್.
Please, my lords. Available voice.
ವಾಯ್ಸ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಇಲ್ಲ.
ಕೇಸ್ ಇಲ್ವಾ? ವಾಯ್ಸ್ ಇಲ್ವಾ?
ಎರಡು ಇದೆ, my lords.
ಎರಡೂ ಇದೆಯಾ?
I'm asking for vacating the stay reason, my lords. Previously, when they got the stay, they portrayed the entire situation as if, so basically what has happened is there's a marriage.
You're not well, is it?
Not well.
All right. I'll take it on next Wednesday.
I can argue.
Yes, sir.
My lordship, there is a difference between the FIR produced before the chief judicial magistrate and official website, my lords. Submitting memo, the contradiction between the
FIR itself doesn't stand. I can only tell that as a complaint because
and also the
demand of
invoked
the dowry
sections
has
of-
not been reflected in the FIR.
Bada. It looks like I'm torturing you. Yes. Let's next Wednesday in same stage. Interim order subsisting will continue to the next date. Next.
96.
We're stay ಯಾರು ಹಾಕಿರೋದು?
Stay is
ನೀವು
there.
ಹಾಕಿದ್ದೀರಾ?
I seek for an adjournment,
ಅಲ್ಲ, ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಯಾರು ಹಾಕಿರೋದು?
both by state and rest.
State and matter.
Let's Amazon, section 79, my lord, safe harbor, sale of a book by Amazon, that becomes subject matter of a complaint, saying it has been sold for a lesser rate than what it would otherwise have been. According
No,
to,
without copyright, huh?
no, my lord, seller's agreement is
Seller's
there.
agreement with
It's
whom?
there. Yes, my lord. It's in compliance with the regulations of 2021. Under section 79.
Your
subsection-
Amazon seller is
Yes,
it?
my lords. We have about 3 lakh sellers, my lords.
What book did you sell?
My lords, this was a book which has been written.
Oh, this is that Ravi Belegari's
Yes, my lords.
Ah,
That
yes,
was
sir.
being sold
Ah.
in the Amazon at about 149 rupees, my lords. We have the seller's agreement
With whom?
with about 12 sellers. 12 sellers, my lords. We have given that list to the police also, who the sellers are. My lords, their grievance is, it ought not to have been sold in Amazon. That seems to be the grievance, my lords. But the
ಏನಾದ್ರು
agreement,
ಕಡಿಮೆ ಮಾಡಿದೆ, ಲಾಸ್ ಆಗಿದೆ ಅಂತನ?
My lord, ಈಗ problem ಏನಾಗಿದೆ? My lord, now the problem is, ನನ್ ಒರಿಜಿನಲ್ ಆಗಿ ನಾನ್ ಯಾರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ದೆ, ಅವರನ್ನ ಬ್ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ. Rest of all other, which is not engaged by me, agency. Total Kannada is a original agency hired by me, my lord.
That is not with, they do not have an agreement with Amazon.
They have. They even another 45,000 of books are sold by themselves. Now they blocked because of my complaint. I represent the complainant.
So that is.
Lord, may I permit seek an adjournment, my lord, day after tomorrow.
Right. Day after tomorrow. Let's day after tomorrow in the same stage. Yes.
interim order, my lord. The interim order.
Interim order will heard the learned senior counsel in the Madi. Day after tomorrow, same stage. Yes.
97.
Petitioner. Stay for 4 and 5, my lord. Stay
Vacating
only for
stay.
4. Vacating stay filed by the respondent number 2, my lord.
Really?
My lord, I just want to make one submission.
Malaysia.
There are 6 matters, my lord.
6 matters.
Only one is listed today.
Kodi.
Filing a
All
memo
are
that
case
all of
and
them,
counter case, my
One
lord.
nimsham, kodi.
that is what they've submitted and
What's
taken
the
interim
matter?
orders. The offense is, my lord, 70 stalking and assault and use of criminal force on women to disrobe, with an intention to disrobe, voluntary causing hurt.
That is
And
stayed, is it?
That is stayed.
By me?
Yes, my lord. All are filed.
De facto complaint, another counter case filed by the court, my lord, pending before the
Kodi
court.
numbers kodi alla.
Please, my lord. There are 6
9008
matters. 2
bar
filed by
2020.
ಅಲ್ಲಿ
me,
ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
4 filed by them.
All the 5 matters?
All 6 matters, yes.
Including this 6 or what?
Including this one, 6.
ನಾವು 4 ಮ್ಯಾಟರ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ, ಸೊ ಅವರು 2 ಮ್ಯಾಟರ್ ಅನ್ನು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, ಬಟ್
ಫಸ್ಟ್ ಇನಿಷಿಯಲಿ ಲವ್ ಫೇಲ್ಯೂರ್ ಮಾಡಿ ಆಫ್ಟರ್ ದ ಫೇಲ್ಯೂರ್ after financial transaction, after your political motive, that is
political
motive, that is the motive in this case.
Tag this petition along with, where are the numbers? All these, is it?
Please, my lord.
Illi,
I'll produce
each
one
page ಇದೆ, Chetan. Tag this petition along with all these. List them all on Thursday in the fresh matters.
Please,
My instruction, this case also charge sheet filed ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಗೊತ್ತಿಲ್ಲ, ನೋಡೋಣ, ಅವತ್ತು ನೋಡು.
Please, station.
Yes. Interim order subsisting, We'll continue to the next date of hearing.
Please.
Great.
Let all the 6 come.
Please.
Yes, next.
98.
I appear for the petition.
This is the Arcanet matter, GST whistleblower matter.
Oh. ಇವಾಗ ಎಲ್ಲಿ ಬ್ಲೋ ಮಾಡೋದು? ಸ್ಟೇ ಇದೆಯಲ್ಲ?
Say,
But he said he'll take assistance last time.
it is being
M.
told.
Kumar told the court that yes, sometimes they take assistance of these whistleblowers to know, otherwise it is impossible to trace
I
them.
understand, Manoj, but
Correct.
there is only one aspect to be pointed out. What has happened is last time, Mr. Hem Kumar has in fact told he is one of the informants, no doubt about it, we're not denying that. But what happens is another submission that was made by the other side was that at 8:45 PM, he gives the information, leaves the spot, he was not even there at the spot is what the submission made by my friend on the other side. The question is, I'm a driver, Manoj, I am nobody. Manoj, if the so-called petition was not even there, the informant name will not be given by any agencies to me. But I am making an allegation against one particular individual for his involvement in a crime. But that is a matter of investigation. But what happens is, in the, 1 minute, just 1 second. In the name of being an informant, that cannot be taken into advantage and people being threatened, Manoj, because the farmers in the Chitradurga district, the very next day have staged protest against this very individual.
Where are those? Where is that
I have
information?
produced all the relevant documents.
Ella idea?
Ella idem.
We have a counter to everything.
I
Our job is only to give the truck detail.
19th. 19th will take it. 19th fresh matters. Yes.
Intermodal.
99.
Intermodal will continue. 19th fresh matters.
99.
ಇದೆ ಇನ್ನೊಂದು ಬಾಕಿ ಇದೆಯಾ ಇದು?
I seek for an adjournment.
ಇಬ್ರು ಮಾತಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೋಬೇಕು ಅಂತ?
ಇಲ್ಲ. It's a request, my lord, because senior is not.
Well, the matter may be tagged with.
That's what it is to be tagged with 82.
Yes, my lord.
Tag the petition with 82. ಅದು ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ ಅವತ್ತು ಹಾಕಿ. Yes.
28.
Yes, yes. 100.
100.
But my lord, I beg to appear for the petitioner. My lord, the petitioner number 1 is an exceptional student. He is a rank holder for the first 3 years. He is a 4th year law student.
What is the problem?
My lord, a trivial 2 FIRs, case and a counter case has been registered.
Who has filed vacating stay?
State university, state money.
ಏನ್ ಸಮಾಚಾರ?
My lord, kindly take page 29, my lord. In fact, my lord, I would rely upon the decision of the apex court, where in case of these trivial matters, my lord, both the FIRs were quashed. In fact, my lord, I would plead that the FIR at my instance and also the FIR against me both be quashed.
Yes.
My lord,
Day
we
after
have
tomorrow
a long.
day after tomorrow in the fresh matters list. We'll
Oblige, madam.
close both. Yes. Next.
101. 14%.
ಜಯಂತಿ. ಏನಿದು? Forms issued. ಏನ್ ಮೇಡಮ್ ಇದು?
ಅದು ನಾವು ಮುನ್ಸಿಪಾಲ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೇಳಿ
ಸ್ವಲ್ಪ
ಹಾಕಿದ್ವಿ. ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವರು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
ಯಾರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ?
ಮುನ್ಸಿಪಾಲ್ ನಲ್ಲಿ.
ಯಾವ ಪ್ರಿನ್ಸಿಪಾಲ್ ಮೇಡಮ್?
ಮುನ್ಸಿಪಾಲ್.
ಅದೇ ಯಾವ್ದು?
ತುಮಕೂರು ಮುನ್ಸಿಪಾಲ್.
ಮುನ್ಸಿಪಾಲಿಟಿ. ಅದು ಕ್ರೈಮ್ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
ಅದಕ್ಕೆ ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ವಿ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಇದ್ರು ಅಂತ.
ಓ PCR ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರಾ?
ಹೌದು ಸರ್.
ಯಾರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
ಮುನ್ಸಿಪಾಲ್ನವರು ನಮಗ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಸರ್.
ಈ ತುಮಕೂರು ಮುನ್ಸಿಪಾಲಿಟಿ ಯಾರು ಇದಾರಾ? ಎಸ್
ದೇವರಾಜ್ ಅಪಿಯರ್.
Though the municipality is not the ಹಾಕಿದಾರಲ್ಲ ಎಲ್ಲ for 5, 6, 7 the learned HCGP for 1, 2, 3, 4 ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು ಇವರಿಗೆ. ಇನ್ಯಾವ ದೇವರಾಜ್? ಯಾವ ದೇವರಾಜ್ ಮೇಡಮ್? ಸರಿ, ದೇವರಾಜ್ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಕೊಡಿ ಕಾಪಿ. ನಿಮಗೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕೋ ಅವ್ರಿಗೆ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. ಆಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿವೈವ್ ಮಾಡೋಣ. ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲದೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಈಗ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಏನೂ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು.
ಕೊಡ್ತಾ ಇಲ್ಲ ಸರ್ ಅವರು. ಇಸ್ಕೊಳ್ಳಿ. SPP ಅವರೇ ನೋಡಿ,
ಲಿಸ್ಟ್
Date ಕೊಡಿ.
ಮುಂದಿನ ವಾರ ಹಾಕ್ತೀನಿ.
ಹ್ಮ್ sir.
20ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ. ಅಷ್ಟರಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿರಿ. ಆಸ್ ದೇವರಾಜ್ ಜಗದೀಶ್ ಸರ್, ಇನ್ಫಾರ್ಮ್ ದೇವರಾಜ್. ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿಸ್ತೀನಿ ಇಲ್ಲೇ. ಅದು ಕ್ರೈಮ್ ನಿಜವಾಗ್ಲೂ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ಮಾಡಿ. ಎಸ್, 20ನೇ ತಾರೀಕು ಬನ್ನಿ.
Sir, 102 ನಮ್ದೇ ಇದೆ.
102 ನಿಮ್ದೇನಾ? ಆಯ್ತು. 2ನೇ ತಾರೀಕು.
My lord, in this case, your lordship.
102 ಯಾರು ಇದಾರಾ?
Please, my lord, I am appearing for respondent number 6, your lordship, in this case.
ಏನು ಶಂಕರ್?
My lord, this is my lord, civil in nature, lordship. Initially, they are approached. My lord,
ಅಲ್ಲ, ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
PCR has been dismissed by the land magistrate. Detailed order has
For
been.
what reason?
My lord, it is civil in nature, lordship.
ಅಲ್ಲ, ಅದಿರ್ಲಿ. ರೀಸನ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, reason, my lord.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಮಾಡಿದಾರ, ಸಿವಿಲ್ ಅಂತ ಮಾಡಿದಾರ?
Civil in nature, lordship. Civil in nature.
ಪೊಲೀಸ್ನವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ, ಅವ್ರನ್ನ ತೆಗೀರಿ.
ಯಾರನ್ನ?
ಪೊಲೀಸ್ನವ್ರ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಡಿ, ತೆಗೀರಿ ಅಂದ್ರು ಸರ್. ಅವ್ರು ತೆಗ್ದಿಲ್ಲ ಅಂತ ನಮ್ಗೆ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಅವತ್ತೇ FR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ, ಅವತ್ತೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಾ? FR. ಶಂಕರ್, ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರ್ಬೋದು. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೆನಾಟ್ ಬಿ ಕ್ಲೋಸ್ ಇಫ್ ಇಟ್ ಇಸ್ ಡಿಸ್ಕ್ಲೋಸಿಂಗ್ ಸಮ್ ಅಫೆನ್ಸ್. ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಮಾತ್ರ ಕ್ಲೋಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
It is not like that, my lord.
ಎನಿವೆ, ಅವತ್ತೇ ಹಾಕೋಣ. ಅವತ್ತೇ ಹಾಕ್ತೀನಿ.
Please.
20ನೇ ತಾರೀಕು.
Please, your lord.
103.
Petition, my lord, Atrocities Act.
ಸ್ಟೇ ಇದೆ ಅಲ್ಲ?
Stay ಇಲ್ಲ ಸ್ವಾಮಿ.
ಕೊಡಲ್ಲ.
13th it is coming up for charge. My lord,
ನೀವು
case and
ಪ್ರಾಸಿಕ್ಯೂಷನ್
counter
ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ತೊರ್ತು ಕೊಡಲ್ಲ.
There's a case and counter case, my lord. On 26th, my lord, I give a statement. My lord, my statement is a page.
Where is your senior?
My lord, she is held
Well, for the respondent number 2 in this matter, my lord.
ಏನ್ ಪ್ರಾಬ್ಲಮ್?
With the petition.
Oh, this matter.
Third party is, my lord, to the property. Whereas the allegation is that, my lord, the
List on 16th, sorry,
13th it is
18th.
there for framing of charges.
The
Here before
concerned
charge.
court shall defer the
Previous injury.
injury ಇದೆಯಲ್ಲ, correct.
Ella simple in nature, my lord. Medical certificate, MLC is there.
List the matter on 18th.
The charges
ಇರ್ಲಿ.
13th, my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord, the medical
Grievous injury is.
Hello, my lord, the certificate says that it's simple in nature, my lord. The
My
medical.
lord, respondent number 2 herein, my lord. I may be served with the petition copy, my lord.
Copy ಕೊಡಿ first. Counsel for the petitioner to serve set of papers upon the counsel for the respondent forthwith.
My lord, page number, my lord, 31 simple in nature ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ certificate.
Grievous ಇರ್ಲಿ. ಕೊಡಿ.
All are in simple in nature, my lord.
ಅಲ್ಲಿ ಬರ್ಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು. Starts from, my lord, page number 87, my lord. All are simple in nature.
ಒಂದು ಸಿಂಪಲ್ ಇದೆ, ಇನ್ನೊಂದು ಪ್ರೀವಿಯಸ್.
ಡಿಸ್ಲೊಕೇಶನ್ ಆಗಿದೆ.
ಅಲ್ಲ, ನನಗಾಗಿರೋದು ಸ್ವಾಮಿ. ಫಾರ್ ದ ಪೆಟಿಷನರ್, ಹಿರಿಯಣ್ಣ ಇಸ್ ದ ಪೆಟಿಷನರ್.
ಇದು ಪೆಟಿಷನರ್ದು.
ಪೆಟಿಷನರ್ ಸ್ವಾಮಿ. ಸೊ ನಂದಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ. Recently they have given
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Case and counter case.
Please, my lord.
26 I give a statement before the.
ಹಂಗಾರೆ ಎರಡು ನಡೀಲಿ.
My lord, at least the charges may be kindly deferred.
No, case and counter case ನಡೀಲಿ ಬಿಡಿ. Yes, list on 18th. Next.
Please.
ಮುಗಿತಾ? ಧ್ಯಾನ್ ಸರ್ ಅದಕ್ಕೆ ಆಯ್ತಾ?
117.
81.
ಹಾ?
81 is passed to.
ಯಾವುದು?
81.
ಹಾ, ಫರೂಕ್. Petitioner is Farooq.
Farooq. Hussain Farooq.
Yeah, FIR Tamil Nadu. Alle. I have dismissed one case of his only.
That is earlier. He had come, but your lordship has run an interim order in one for one sub-register.
Sub-register, that is sub-register illi avaru sir.
That transaction happened here.
No.
This transaction.
No, this FIR registered in Tamil Nadu. He was summoned there. Adikke kottred sub-register.
Division bench of Madras High Court is monitoring the investigation.
Monitoring, and sub-register is given up by the division bench of I think the prosecution has indicated that nothing to do with the sub-register. Adadmele I continued the interim order.
In fact, they were looking for this present petitioner, was not available.
Yes sir. Advocate Supreme Court ಅಂತ ಹಾಕೊಂಡಿದ್ದೀರಲ್ಲ.
ಹೌದು.
Correct sir. Yes.
But in the application note, they say he was providing legal services to this trust.
Probably learn.
ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. for want of jurisdiction. I have dismissed same matter of his only.
This is of course your lordship, I think they had withdrawn it.
Yes, yes.
I withdrawn
withdrew
because
it.
I said I will
Wanted
dismiss
to
it.
dismiss it, then he's withdrawn.
Oh, I said I will dismiss it, adike withdrawn. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner. The petitioner calls in question a crime registered in before the jurisdictional police station in Chennai, and is wanting to project the jurisdiction of this court on the score that the offence has happened here. In the said case as well, in an earlier occasion concerning the same petition, the matter was a petition was withdrawn on the score that he would approach the courts at Chennai for seeking appropriate
He
relief.
went to Supreme Court, not.
He would approach ಅದಾಯ್ತು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ಬಂದ ಮೇಲೆ ಮತ್ತೆ ಚೆನ್ನೈಗೆ ಹೋಗ್ತೀನಿ ಅಂತ ವಿಡ್ರಾ ಮಾಡಿದ್ರು. So you were not there.
No, that order I've seen, Lord. That order says that was before he went to Supreme Court. He withdrew it then, went to Supreme Court. Supreme Court gave him two weeks of protection.
Whatever.
Then he's coming.
Would approach the apex court itself as the matter was pending before the apex court. The same crime is now sought to be questioned before this court on the score that the crime has happened here, or the property is transferred, property is situated here. The division bench of Madras High Court is monitoring the investigation conducted by the investigation conducted therein. Therefore, as in the earlier occasion, the petitioner is at liberty to approach the courts approach the appropriate fora in the jurisdiction of fora in Chennai or Madras. Leaving open the said remedy, the petition stands disposed.
170.
In my convenience compilation, my lords, I have crystallized the issues with the judgments and propositions.
Lords, I am filing my convenience compilation.
I was looking
with one.
ಪಕ್ಕದಲ್ಲಿ ಅವರಲ್ಲ sir. I am watching the full and not the other. Yes.
There was one mistake on my end, my lords. There's one mistake on my end, my lords. My Xerox of
in passing the impugned order.
No, my lords. The convenience compilation in the state. Xerox ಮಾಡುವಾಗ some pages went, I could not compile it. But tomorrow morning I'll have it done.
Sir, argument ಆಗಿದೆ ಅಲ್ಲ ನಿಮ್ದು?
Madam, we have just given, I'll just take your lordships quickly.
Take, yes.
Lords, if your lordships have compilation in.
Where is Prabhu, sir?
117.2.
Not coming? You will submit? Very good. Yes.
117.2. ಅದರಲ್ಲಿ ಒಂದು ಮೇಡಮ್ ಈ ತರ ಇದೆ, ಸ್ವಲ್ಪ ದಪ್ಪ ಇದೆ ಅಲ್ಲ. ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ 117.2 ಅಲ್ಲಿದೆ. ಅದೇ the impugned order also is annexed so that your lordships may. The impugned order is document 1 at page 17. That's what happens is the central government fixes the FRP, my lords, in accordance with the sugar control order. The FRP includes, my lords, for the season, harvesting and transportation charges. Then the cane commissioner, my lords, publishes the harvesting and transportation charges. It varies between 400 to 500 and 500 to some 700. He publishes, my lords, the FRP announced by the central government also. Subsequently, my lords, agitation starts in Belgavi by certain sugar farmers demanding additional price. Meeting is called on 7th of November. We attend the meeting, and my lords, there is a thing where we dispute. They say we'll decide on that. 8th of November, an impugned order at Annexure A is passed. Lords, if your lordship sees, in my compilation, lords, I have set out and
page 17.
Page 19 only they have given the chart.
Correct.
Lords, at the first glance, your lordship may kindly come to 9.5% in that chart. 9.5% Actually, not much of a dispute amongst us. Now your lordship should get 10.25%. There, at the first glance, your lordships will see the FRP fixed by the central government is shown as 3,550. The state government's price is shown as 3,100. And 50 and 50 is shown as payable as second installment, 50 rupees in the second installment by us, 50 rupees by the state in the second installment.
3,200 ಆಯ್ತು.
It looks as if they have reduced the price. But what they do here is, this is excluding the harvesting and transportation charges.
How much is that?
Lords, that comes to almost about 500, which we have 900 rupees, which we have set out in our writ petition.
So in all it becomes 4,000.
Yes. Now,
4,100.
Please come to page 7.
3,400 plus 900.
Please come to page 7, my lords. I've just said in the writ petition it is there. But my lords, if your lordship sees the columns which we have set out.
Financial impact.
Yes. In that, if your lordship kindly come to the first percentage of recovery is 10.15%. Lords, the FRP price is 3,515. Then, my lords, the HNT, that is, my lords, the harvesting and transportation declared by the state is 935. So what goes to the farmer is 2,580 as per the FRP, my lords. Now, Karnataka government declared net price to farmers, your lordships would get 3,115.
Correct.
There, the HNT, I have to add to that is 935. The total price payable becomes 4,050. The increase per ton is 535. Then, my lords,
per ton will be 535.
535 increase over the.
It's a huge impact.
It's, my lords, I have given, in fact, for one of the first petitioner, I have said expected crushing is 10.50. The overall impact is in one factory is 56 crores for 1 year for me. I literally have to shut down now. This is the impact. Now, my lords, there is one act which, my lords, is called as the Karnataka Sugarcane Regulation and Purchase of Supply Act. There, my lords, the steps under that act I have set out in my synopsis. If your lordship kindly come to page 13. The act, my lords,
Act ಹಾಕಿದ್ದೀರಾ?
Act ಅದರಲ್ಲಿ ಹಾಕಿಲ್ಲ ನಾನು. I thought, my lord, your lordship may take this act.
ಇದೆಯಾ?
Act I will just show.
Anyway, ಕೊಡಿ ಲಕ್ಷ್ಮಣ್.
No, my lords, I have set out the steps under that act. Your lordship sees at page 13 for a quick glance, my lords, under section 4C in my compilation, my lords.
Committee for calculation.
There is an expert committee.
Now, was this placed before the committee?
No. My lords, our entire case is the act prescribes first it goes to the expert committee under section 4C. That will, my lords, give a report on revenue realization. Lords, additional sugarcane price usually is to be declared after the crushing season is over. Because you are then going to get the revenue realization, which includes probably sugar, ethanol, all those things. Now, this committee will give a report to the Sugarcane Control Board. Lords, Sugarcane Control Board under section 4H will consider the factors, my lords, set out under 4D for deciding the sugarcane price. The board will then give its report or recommendation to the Commissioner of Cane Development. That has to be decided. And then, my lord, under section 9, the cane commissioner will declare the price, additional price over and above the FRP. And that will be payable in 2 stages. Now, what the state government has done under the impugned order is dehorse this act, procedure under the act, my lords. They straight away call a meeting of the farmers and the sugarcane factory owners, headed by the then Honorable Chief Minister, pass the impugned order on 8th, by which this price is affected, and expect us to praise. Now, what happens subsequently also we have set out, my lords. The next day, there are agitations all over. Some of the factories, my lords, there are agitations. Some, my lords, all of us are called to the Deputy Commissioner's office and to give an undertaking that we are agreeable to the price declared by the state government. And for that, one of the petitioners, the first petitioner in the 117.2, 15 minutes before is called as summoned to the DC's office because there was coercion on every sugarcane factory owner. They send an email saying that subject to what proposal we gave to the state government, we are not agreeable, we are agreeable, otherwise we are not agreeable. So in my synopsis, what I have set out is, there's three issues I have raised, my lords. If your lordship kindly come to the issues which I have set out, my lords, broadly, at my lords, page 6 of my compilation.
That I saw.
So for that, I have given answers and the judgments to say if in their statement of objections, at one hand, they refer to this act. Contradictory to that, they also say I use my executive power under 162 and pass this order, and refer to a judgment of the Honorable Supreme Court. Now, that Honorable Supreme Court's judgment also, if there is no act, my lords, yes, you can go under 162. If there is an act,
Of course, that's
you can't have 162.
That's too rudimentary.
Well, that's what their, my lords, I am only saying their act, they are justifying both the things. One, they say under the act, I will do.
Statute governs the field. Where is the question of 162?
162. And if they have any such power, dehors the act also, there should be some rational basis. Now, my lords, while fixing this
That is
kind of,
another submission.
this kind of a rate cannot be done. And this, usually the additional sugarcane price comes after the season is declared. That's the way I have set out, my lords. And document number 3 shows the harvesting and transportation costs.
Populist order.
That's now, of course, there is an interim order. Most of us, I think, my lords, have paid the sugarcane farmers on the rate, because, my lords, I can only fight the government. So far as the sugarcane farmers are concerned, if the government has declared and there is no interim order here,
You
so
have
far
to
as
give, yes.
we are bound to, my lords.
We'll
pay.
see.
Now,
Farmers ಕೊಟ್ರದೇನ್ ನೀವು ವಾಪಸ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
government ಕೊಡ್ಲಿ ನಮ್ಗೆ.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ.
Lords, if they, lords, it is they who took the bold step. Lords, they should. Farmers in the I can't, my lords. I can't even ask for my.
No, that can't be the effect of
Because
the order also.
Lord, what happens is, after this I issue a public notice, declaration ಮಾಡಲೇಬೇಕು. Farmers ಗೆ ನೀವು ತಂದು ಕೊಟ್ರೆ ಇಷ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ. I had to do that because of the government order. So I can't go behind the farm. My only worry is, for the next season also, the government will indulge in this.
ಅದಕ್ಕೆ next season ಅಷ್ಟೊತ್ತಿಗೆ we'll give the reason.
Please, my lord. And what happens is, this will be taken as a base price.
That we'll see. Next season ಅಷ್ಟೊತ್ತಿಗೆ we'll set it right.
There are other issues, my lords, regarding validity of that act and all that. Presently, we are not questioning that act. We are saying, under this act, you should follow this procedure.
We'll continue it day after tomorrow.
I will not take more than 10 minutes.
5:45 sir.
ಅಲ್ಲ, ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು ಸರ್. ಆಗಿ.
Yes. How long will you take? 15 minutes.
Take 10 minutes.
ಆಯ್ತು. And we'll take it at 4:30 day after tomorrow.
It is subject to lost inconvenience.
Friday. Friday ಆಗಲ್ಲ. Friday special court matters very difficult. ಇಲ್ಲ ಅಂದ್ರೆ Monday. Monday is fine. Monday is fine for all of you. Then Monday will start at 3:30.
3:30.
You are going to submit, right? You're not getting senior.
You only have.
No, you only should do it. Yes. On Monday.
No, what is the interim arrangement is there?
Monday ವರ್ಗ.
ಅಲ್ಲ, interim ಇದೆ already.
Interim order continue ಆಗುತ್ತೆ ಸರ್. ಅದು ಕೇಳಂಗೆ ಇಲ್ಲ. ನಾನು what is the interim arrangement ಅಂತ ಕೇಳ್ದಂಗೆ ಇಲ್ಲ.
ಕೊಡ್ಲಿಲ್ಲ, interim order ಕೊಡ್ಲಿಲ್ಲ mainಗೆ.
ಅಲ್ಲ, ಯಾವ್ದ್ರಲ್ಲಿ interim order ಇದೆ that will continue.
50 rupees ಗೆ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ.
Whatever interim order is there, it will continue. Beyond that, now I can't amplify. No, I can't amplify the interim order now.
My lord, we cannot insist, my lord, set up.
ಅದಕ್ಕೆ we'll take it on Monday.
17th
at 4 p.m. 4 p.m. ಅಂದ್ರೆ it will only be after 5 o'clock. But we ready ಅಷ್ಟೇ.
Please.
They can argue my presence.
Not necessary. ನಿಮ್ದು ಆಯ್ತಲ್ಲ? Convenience compilation ಕೊಟ್ಟಿದ್ದೀರಾ? Who remain is Shashidhar sir, Sanjeevini and Viresh. ನೀವು ಇದ್ದೀರಾ? ಇಲ್ಲ, ಸರಿ ಆಯ್ತು. On Monday.
Please.
You also prepare compilation of synopsis and give. ಹಾಕಿದ್ದೀರಾ?
ನಾನು ಕಂಪೈಲೇಷನ್ ಅದರಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ, so that there is continuity.
निशा तिवारी मैडम क्या कर रहे हैं? I'll reserve it and pass, but you want me to pass an order in the open court. That's the problem.
My lord, I will not insist on that.
If that is the case, this is going to happen.
I for assisting my lord, I have collated the corrections.
We will file a 2-page synopsis only.
Please do it.
That's the action that
Allah,
should be better. So that
Nisha Tiwari madam.
we'll file it in the
You
registry.
file the written submission or synopsis, whatever form you want. Both of you file, I'll consider it and pass
That
out.
should be fine.
This is a copy of the order. I have highlighted the corrections.
Good sir.
She's, they're in regular touch also.
No,
Delhi.
but one theli, prima facie, I have not dealt with the original order or whatever it is. This man, he was no way connected. How did he get convicted?
No, I'll just point out. Two submissions I would like to make.
I think somebody has earlier messed it up. It's
I'll-
not correctly done.
Let me clarify this. Two
No,
submissions.
now I'm not going to go back into all that. That is up to the petitioner.
Just two submissions I wanted to make. First thing, Millard, the right to appear before your lordships, Millard, the reason is they have given an undertaking, Millard. Millard, I have filed a statement of objections in this case, wherein they have undertaken to deposit 10 lakhs and given under. They have not done that even after 4 years. How they have done it? They have said they will do that within 30 days.
Millard,
Which
10
should
lakh-
then, no, let me complete.
Wait,
Millard, should they not have? They cannot take court for rights.
No, I'm not on that, but.
First, enough clarify. They cannot get an order, get an order suspended for 30 days, and then Millard don't comply with that order.
I will consider that.
That's one thing.
We'll see.
And second thing, Millard, suppose that's what the learned judge has.
No, that was only a view because this is a 2008 matter. It began, your dispute began in 2008 and I think he has resigned or something before that. How did he get convicted even?
Yes, that I'm going to point out. In fact, they raised this issue, very issue.
Correct.
Before,
I don't know.
before that very learned judge Miller, and then learned judge has rejected that contention, giving reasons. Miller, he has placed reliance.
Anyway, the corrections you have indicated in this?
Millard, may kindly flip page number 3. Millard.
Yes, madam.
Millard, from there to Learned Senior Council, I have given the list of corrections and the proposed corrections also. Millard, the corrections, the errors have been highlighted in green, Millard, and the proposed corrections which I have proposed has been written
Blue.
in the left-hand side, Millard, type copy. This is Millard, the note, which 2-page note I have given, but that has a gist of my submission, which I had already advanced, and I have already supplied a copy. So that can be taken up. Millard, with respect to this contention that 10 lakh rupees I have not paid, it is admitted, and Millard, that is the reason why I wanted that 7.72.2 to be on record, Millard.
But I've already said
Because
that.
I understand, Millard. In fact, on 22nd of June, I have filed a memo with the registrar and the Chief Justice that let the matter be placed for special assignment. So there was nothing on my part that I was seeking indulgence from this honorable court after recusal, Millard.
Yes,
because it comes on
correct.
me as a counsel,
Correct.
Millard. And secondly, Millard, I wanted those entire pleadings to be along with the annex because it's a bulky pleading, Millard. To demonstrate that it is admitted case that in 2023, after this order was passed, which is not sought to be corrected, Millard, 4 days down the line, I compromised. I admittedly gave him 10 lakh rupees cash and a check amounted 1.90 crore. It was his misfortune, Millard. He did not
Lakhs cash
present
is
it.
given, is it?
10 lakh is given in 2023, my lord, and this is admitted in 14332, my lord, and that is the reason why I wanted to demonstrate it from that. Every single time it is projected as if I have flouted this order. My lord, I had all means to settle it, and I have had all bona fide intentions to settle it. Unfortunately, my lord, that sort of means are not available to me now, my lord. I will not litigate unnecessarily, my lord. And it is a case of gross injustice, my lord. Every single stage I have been prejudiced. Every single stage, my lord. The sentence, entire sentence imposed on me, I'm not a convict. And not even a penny of fine going to the company. Entire liability imposed on me. My lord,
No, that itself is shocking.
my lord, in fact, when I was arguing...
Anyway, that has gone up and it has reached finality.
In fact, when I was arguing this very matter before Justice Basaraju, my lord, when I pointed out that the hearing on quantum of sentence has not been afforded to me, then he pointed out that in Karnataka, we do not hear the people on summons cases. Has this been converted into warrant case? I said, my lord, I have practices 7 different high courts, state practices. Every single time in summons cases, there is a separate hearing conducted on the question of quantum of sentence, my lord. Had I been heard only to the extent of quantum of sentence, because there was no grievance till such time, I was punished with severe sentence in this matter, my lord. My grievance is that you recover everything from the company. I have no issues. Only thing is, why the entire fine on me and not even a penny of fine on the company? My lord, the respondents never furnished the registered address of the company. There was no effective service to the company ever, my lord. And this was my misfortune. Sometimes your bad luck travels far faster than your wisdom. But this is a classic case where it has happened, my lord. Unfortunately, in the Supreme Court also, these contentions were not raised, my lord. And my lord, I engaged best of the lawyers, my lord, to argue this. And it was really unfortunate that these contentions were not raised. That is, it's an order of nullity. There is no conviction. There is no hearing, no quantum sentence. There is no representation of the accused. Sole convict.
We'll see.
Nothing was there, my lord.
Insofar as this is concerned, I will pass. What has been messed up or not, I can't correct it anyway.
My lord,
I will also file, my lord,
You synopsis haki, sir.
synopsis ಕೊಡ್ತೇನೆ. And it may be posted for judgment, my lord, not for dictation. I only request. Because
No,
again,
open court dictation is impossible.
ಅದೇ
madam.
ಪುನಃ ಅದೇ start ಆಗತ್ತೆ.
ಅಲ್ಲ, no, because it's not.
My lord, understanding your lordship's
I'll
difficulty, my
do
lord.
what is to be done.
I have highlighted all these things
Yes,
for my lord's convenience,
Yes.
my lord. And secondly, my lord, this court has made some remarks against me in para 10 and 11
Against
also.
why?
My lord, in this order, which is sought to be corrected, I would seek my lord's indulgence in that.
Against
Para 10 and 11.
Novel idea.
My lord, novel idea, mischief,
All right.
beating a dead heart.
All right. Yes.
My lord, I understand that it could be a lapse on the part of the
Yeah,
court, but
I am happy,
there may
my
not
lord,
be
if all
an
the
effective
entire
assistance.
No, he will not object to
Madam,
that also.
I am happy if the entire judgment is recalled and.
No, I'm not
No,
saying.
let me
Recalled
complete.
why?
Let me complete. Only thing I want is writ petition is dismissed. That's all, madam. Because ultimate
Entire
result is
judgment
that.
recall petition dismissed.
Ultimate result is that. That's all I am concerned, not with the other
fact-
things, madam.
In fact, my lord, the judgment, the order says that since the company records have been destructed, therefore it cannot be summoned, my lord. Under Rule 8, the very same rules which have been relied upon by this court, under Rule 8, it is mandatory on the ROC to maintain the record of what all has been destructed. Lord,
Why,
that
why
has not,
you filed a review or recall?
my lord, I have filed a correction only.
Correction.
Because now I have procured that document elsewhere, otherwise, my lord. So I am not aggrieved with the operative portion anymore. And after 3 years, my lord, I'll
What I
not
said.
seek my lord's indulgence to review the order and all. No,
No,
that's
yes, I
unfair.
have my own
We'll see.
reservations.
Yes.
My lord, the other matter, the recall, my lord.
Which is the other one?
72.
That we will take it next week sometime or 14th.
My lord, 5
Madam, let it be
minutes, 5
called
minutes
after
only. I just-
minutes. All these things.
Not now.
All these things, madam, has a direct relation with the application she has filed in 422.
No,
Appeal
we'll see.
422.
That I'll
That may
take
be
it.
called, I mean, let it be.
ಈಗ ಆಗಲ್ಲ ಅದು. Let the Honorable Chief
ಆಮೇಲೆ
Justice
ಇದನ್ನ
allot it to someone. We'll see.
My lord, that we assigned. But
No,
my lord,
they can
in
move
that-
the Honorable Chief Justice and get that matter listed
My lord,
first.
we have
Court
already,
she has done.
already
Madam,
moved, my
sorry,
lord.
I said
And this is the memo which I just wanted to place on record in 72, my lord.
that's what Madam has done is what is said. Yes.
It is done on 22nd of June.
Why?
Long
No,
back.
no, let's- I know.
Long
The
back,
reason
madam.
is office has been pointing out, they have not complied with office objection. Until office objection is removed,
My lord-
Honorable Chief Justice doesn't take the papers.
My lord, I have given my written submissions to the objections with respect to maintainability. My lord, that has to be posted before the court for adjudication.
I've been watching in the first court, my lord. And have you removed the office objection? No, then it will not be
My
posted.
lord, all that I can make is to make
what I
submission,
said.
my lord. Ultimately, it has to come before the court for overruling of office objections, my lord.
Yes.
The registry is
Correct.
not
Registry will
competent.
not do it.
In fact, I have appealed
Overruling
before
is
the
not
registrar.
cannot be done by the
I have
registry.
appealed before the registrar also,
Yes,
my lord. He has said that the matter needs to be posted before the
So
court.
this I will pass. That when you want it.
My lord,
I feel, my
I'm
lord,
there.
that first 422 and then that matter. Because
Should we
direct
wait for
relation-
the Honorable Chief Justice's order of allotting it?
Not necessarily required, my lord. Not
Then
necessarily.
next week sometime you tell me.
My lord, if it can
Can
be
it be
taken
the
up
first
tomorrow,
week
I'll
of
take
September
only 5
because-
minutes. my lord.
All right.
Not,
Yeah.
not, I'm here tomorrow, that's why, my lord, I'm requesting personal accommodation.
Tomorrow you're there. Then
No, no, no.
tomorrow difficult. Ma'am. Tomorrow board is so
Thursday, my lord, Thursday we
250
are-
matters tomorrow.
Thursday there will be law and
No,
order problem.
tomorrow 250 matters.
Day after, my lord.
No, day after tomorrow, that's what I said. Likely to be law and order problem.
The Kaveri.
Kaveri, ಇವತ್ತು against, ಅಲ್ಲಿ ಪುನಃ against ಆಗಿದೆ order. And
My lord,
some political leaders, they have already.
Friday, madam.
because, my lord, there is already a conviction warrant against
Friday.
me.
We are
Friday.
not executing, like,
Friday, 14.
they can take advantage of that. We are not executing that order.
He's saying Friday will take.
My lord, I'll rely upon his assurance then.
Come online. If you're not in Bangalore, you can come online. Yes.
On 14th.
14th. Yes.
Very well.
This I will pass and release. Yes.
Great.
Yeah.
Oblige.
The last week of this month, because she has some personal inconvenience.
ಇಲ್ಲ
and
ಇಲ್ಲ 14th
ಬರ್ದೆ ನಾವು
14th
ಬರ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
14th is midweek, sir.
Yes, that's
Yes.
right. 14th is okay.
14th, madam.
Oblige. My lord, can it be time fixed at 4 PM or so?
4 PM on,
My lord, I
it
understand.
will reach only at this time.
My lord,
4 PM, I'll fix it at 4 PM, not a problem.
This will be
Yes,
better also.
4 PM. So you need not come in the morning and wait.
no, that's not it.
Online ಅಲ್ಲಿ ಬರೋದು.
Online, fine, yes.
Online files.
All right,
No, I'll be
4
here.
PM, yes,
I'll be here on 14.
yes.
Great. Ma'am.
ಅದು ಇದು ತಗೊಳ್ಳಿ, ಸೆಟಲ್ಮೆಂಟ್, SPP ಅವರೇ, ಸೆಟಲ್ಮೆಂಟ್ ತಾನೆ?
That marriage, my lord, has happened 2023.
ಹಾ,
Therefore, we have booked a Child Marriage Act rightly against them. Now they're showing, my lord, subsequent to this case, they have married again. So child marriage, my lord, should not be allowed.
ಅಲ್ಲ, marriages happened after 18?
Yes, my lord.
Wait, sir. ಇಲ್ಲ ಅಲ್ಲ?
No,
Ah,
16 years,
nothing.
4 months.
No, sir.
Based on the, now they have remarried again after major anta ತೋರಿಸಿದ್ದಾರೆ.
And she got child also.
That's a different thing, sir. We may quash it against the boy and the girl, but not against the parents. ಅವತ್ತೇ ಹೇಳಿದ್ದೇನೆ, parents na we will not spare who have got their children married before 18 years.
At least that can be done.
That we will do.
Your lordship may consider that, my lord. Your lordship may consider that.
Boy and girl ಮಾತ್ರ ಅದು ತಗೊಳ್ಳಿ settlement. ಅಲ್ಲಿ the settlement is restricted only to the victim and the accused number 1. Insofar as the others are concerned, the petition would be answered on its merit, list the matter on 20th, list the matter on 27th. All right? Yes. Boy and girl sign ಮಾಡ್ಲಿ, settled and closed. Yes. ನಿಮ್ದು ಯಾವ settlement, madam?
83 serial.
Settlement ಏನು?
Settlement.
376.
Yes, my lord.
376.
SPP ಅವರೇ.
Yes, my lord.
ನೋಡಿ, ಇದರಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ 13B
ಅಲ್ಲ, ಮೀಡಿಯೇಷನ್ ಈಗ ಫಸ್ಟ್ ಇವರು ಮದುವೆ ಆದ್ರು, ಮದುವೆ ಆಗಿ 13B ಹಾಕಿ ಮ್ಯೂಚುವಲ್ ಡಿವೋರ್ಸ್ ಆಗಿದೆ.
ಇಲ್ಲ, ಮದ್ವೆ ಆಗಿ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಹಾಕಿ ಅದರಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಿ ಮತ್ತೆ ಮ್ಯೂಚುವಲ್ ಡಿವೋರ್ಸ್ ಹಾಕೊಂಡಿದ್ರು.
ಆದ್ಮೇಲೆ ಮತ್ತೀಗ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ 376 ಗೆ.
ಇಲ್ಲ ಮೇಡಮ್, ಬಿಫೋರ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆದ್ಮೇಲೆ
ಬಿಫೋರ್ ಆಗಿತ್ತಾ?
ಬಿಫೋರ್ ಆಗಿತ್ತು.
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಹೌದು, 13B
ಅದರಲ್ಲಿ ಕ್ರೈಮ್ ಕ್ಲೋಸ್ ಮಾಡೋದು ಬರ್ದಿದ್ದೀರಾ?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
376 ಹೆಂಗ್ ಕ್ಲೋಸ್ ಮಾಡ್ತೀರಾ?
Your lordship decide on merits.
Merits ಮೇಲೆ we can decide.
Another petition is family members all.
Family members I will quash it immediately, taking it, except the accused number 1 and the victim, I will answer it on merits.
Yes.
Kindly take the family matters.
Family ಇದೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡೋಣ. Yes.
With your lordship's kind permission. In respect of other accused, I withdraw the petition.
ಸರಿ, ಬೆಟರ್ ಅದು. That's a better idea. ಅಲ್ಲೇ ಮುಗಿದೋಗುತ್ತೆ.
Yes, sir. We'll frame the charge and go on.
Better, yes. ಅಲ್ಲಿ petition disposed insofar as the other accused are concerned. Accused number 1 and the victim, accused number 1 ಮೇಲೆ settled and closed on account of marriage. ಅದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ತಗೊಳ್ಳಿ. ಆಯ್ತು, that's a better idea.
Yes,
Now this against the petitioners, we have serial number
83 man.
83.
The petitioners are before this court seeking the following prayer. The case has a checkered history. The accused number 1 and the victim initially get married, first in marriage.
Crime registered after marriage, 376.
Get married. A crime comes to be registered for offense punishable under section 376 after the marriage. During the subsistence of the proceedings, the wife files a restitution.
Wife.
Files the petition for restitution of conjugal rights. After which the two file petition under section 13B of the Hindu Marriage Act, and now the marriage is said to be dissolved. They have, while dissolution of marriage happens, the parties to the list have entered into a settlement before the concerned court, or the conditions of dissolution of marriage is withdrawal of the crime so registered by the respondent for offense punishable under section 376 hyphen the subject crime. The issue is whether it could be closed by way of settlement. Insofar as the accused number 1 who is alleged of the offense punishable under section 376, whether it is tenable or not would be considered on the next date of hearing. Insofar as drawing of all the members of the family as accused in a case concerning 376 of the IPC, I deem it appropriate to accept the settlement, close the proceedings against all the members of the family. Insofar as the accused number 1 only, list this matter on 27th to be heard on its merit.
83.1 will be closed.
83.1 ಅಲ್ಲಿ ಆರ್ಡರ್ ಬರೀರಿ. 83.1 closed on accepting the settlement. 83 27th.
Great film.
ಅವತ್ತು ನೋಡು ಹೆಂಗು ಆಗಿದೆಯಲ್ಲ, ವೆದರ್ ದ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ವಿಲ್ ರೈಟ್.
Order sheet signatures.
ಎಸ್. ನಿಮ್ದು ಯಾವ್ದು ಆನಂದ್?
Passover, list number 231st.
ಪಾಸ್ ಓವರ್ ಯಾಕಾಗಿದ್ದು?
Matter because council was.
ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕ?
Yes.
ಈಗ ಯಾವ ಡಿಕ್ಟೇಟ್?
No, maybe date.
ಡಿಕ್ಟೇಟ್ ಇಲ್ಲ, ಓನ್ಲಿ ಡೇಟ್.
Only.
ಎಸ್. ಟ್ಯೂಸ್ಡೇ. ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕ್ಬಿಡಿ.
First list, my lord.
ಹಾ?
The first list.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲ ಇರೋದೇ ಒಂದು ಲಿಸ್ಟ್ ಅವತ್ತು. ಆ 50 ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ, 5 ನಿಮಿಷ, ಅದು ಅರ್ಧ ಗಂಟೆಗೆ ಮುಗಿಯುತ್ತೆ.
Great.
Serial number 66 ಪಾಸ್ ಓವರ್
Entry
ಏನದು?
ಮೆಮೋ ಆಗ್ತದೆ.
ಏನದು?
ಫಾರಿನ್ ಹೋಗಿದ್ದು ಮಕ್ಕಾ ಮದೀನಾಗ ಹೋಗ್ಲಿಕ್ಕೆ ನೇಮ್ ಕರೆಕ್ಷನ್ಗೆ ಮೆಮೋ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀನಿ, ರೆಸ್ಪಾಂಡ್ ಟು ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ.
RPO ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
ಹಾ, ಕೊಡಿ.
ಇದು ನೇಮ್ ಕರೆಕ್ಷನ್.
Lord, interim order may be next.
ಅಲ್ಲ, ಅದು ಕರೆಕ್ಷನ್ಗೆ ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್. ಹಾ, ಇಂಪ್ಲೀಡ್ RPO
ಮಾಡಿದ್ದೀನಿ, ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ.
ತೊಳಿ. ಇಂಪ್ಲೀಡ್ RPO ಅದರಲ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. ಒಂದು ಕೆಲಸ ಮಾಡಿ, Lynette CGC Kirti Reddy is directed to accept notice for the respondent Regional Passport Office petitioner to serve set of papers upon the council. The council, the Lynette CGC shall secure instructions and make submissions on the next date. ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ ಅದು?
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
ಆಯ್ತು, ಮತ್ತೆ
My lord, serial number 64, my lord. Need
Yes,
short
sir.
accommodation.
Huh?
Need short accommodation, my lord.
64 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಅದು ಲೆಟರ್ ಚೇಂಬರ್ದು. ಅದು ನಿಮ್ಗೇನು ಬೇಕಾಗಿಲ್ಲ.
Okay.
My lord, serial number 65.
65, what happened?
Entry murder ಇದು extend.